Yeah, just
There you go.
when unplug it. And
That's because you're not old and didn't grow up on paper like I did.
I'm, but thank you.
Yeah, no, I sent him a note saying, hey, I'm in Baltimore for the rate case here, so we get the same vibe.
Testing, testing.
You know, and best wishes. Where's he going?
Let's begin. We're going to resume our rate case here. Let me just say a few things. I want to say a few things about questioning and, I want everybody to say everything they want to say, and I want everybody to ask every question they want to ask, but I want to admonish everybody that I know that you're trying to make discrete points, and sometimes you can do that with fewer questions rather than more questions. I don't want to tell you to not ask every question you want to ask, but we are paying attention here and we get the points. And I also want to say that sometimes when a witness is somebody you don't agree with, if they answer the question honestly, but they don't use precisely the words you want to hear, let's try and just let it rest there. And I assure you, the five of us will make the appropriate judgment from where for what that leads us to. So I think I made my point and I've been sufficiently vague. So with that, let's turn to AOPA in your cross-examination.
Good morning, Your Honors. Good morning, Mr. Nelson. A few minutes ago, I gave the bench some data responses. I'm going to give you a copy now, too.
Do you mind if we got one more? Or if you have enough? Sure. Okay. Just give them all to us, man.
Yeah, I did.
Is this all for me?
What? No, it's just one. Yeah, do you want another one? Okay, give this to me.
Please proceed.
Okay. Mr. Nelson, I'd like to introduce Pepco's response to AOBA data requests set 3, questions 1, 3, 4, 6, 10, 14, and 16, which as a packet, Your Honor, I think I want to mark that as AOBA exhibit by 6. 6.
He's keeping count. 6. So marked.
Am I correct, Mr. Nelson, that you are listed as a sponsor of Pepco's responses to AOBA data request set 3, questions 1, 3, 4, 6, 10, 14, and 16?
Yes, that's correct.
Are the company's responses to AOBA data requests set 3, questions 1, 3, 4, 6, 10, 14, and 16 true and correct to the best of your knowledge, information, and belief?
Yes.
Your Honor, I believe in your packet there is also a response to Pepco's response to AOBA data request set 3, question 30 at the end of your packet, and I would like to mark that as AOBA exhibit 7.
So marked.
Okay.
I'm sorry.
At the last
what
page, look at the last page.
It's not stapled.
The last one I have is for the response to AOBA 715.
Look,
331.
3-30.
Okay.
There is a 331 and a
Yeah, I'm getting to that.
330. Okay.
You
I
have it?
apologize.
Okay.
Well, what number? AOBA
AOBA 7.
7. Thank you.
Am I correct, Mr. Nelson, you are listed as a sponsor of Pepco's response to AOBA data request set 3, question 30? Question 30?
Yes.
Okay. I would also like to mark Pepco's response to AOBA data request number 3-31, which is also in your packet. I'd like to mark that as AOBA Exhibit 8.
So marked.
Mr. Nelson, can you tell me, are the company's responses to AOBA data request set 3, questions 30 and 31, true and correct to the best of your information, knowledge, and belief?
To the best of my knowledge, yes.
Okay. Now, let's focus now, please, on data request set 3, question 30, which addresses the TTYCF RMA 22, under which Pepco seeks recovery of non-executive annual incentive plan cost. Is that correct?
I'm just reading the data request.
I'm sorry?
I'm just reading the data
Okay.
request. Yes, that's correct.
Okay. Now, in support of the company's TTCYF RMA 22, your direct testimony at page 22, lines 20 through 23, references, tell me when you're
Sorry,
there.
page 22, lines 20 to 23.
Correct. Tell me when you're there.
I'm there.
Okay. Now, in support of the company's TTYCF RMA 22, your direct testimony at page 22, lines 20 through 23, references case number 9311 as precedent for that rate-making adjustment, and you cite order number 85724. Would you accept that order number 89724 was issued on July 12, 2013?
Order number 85724, subject to check.
Okay. Were you a participant in that proceeding?
No, I was not.
Would you accept, subject to check, that Pepco made no rate-making adjustments for non-executive annual incentive program costs in either case number 9655 or case number 9702?
I think you're referencing forward-looking proceedings, but subject to check.
Now, please turn to your direct testimony, your schedule, CN-1, and I'd like you please to look at page 28 of 46. Are you there?
I'm there.
Okay. Does Schedule CN-1, page 28 of 46, present calculations supporting your proposed RMA 22 for annual incentive plan costs?
It does.
Lines 3 through 5 of Schedule CN-1, page 28 of 46, lists AIP costs for 3 annual periods, the 12 months ended September 30th, 2023, 2024, and 2025, correct?
Yes, that's correct.
Now, turning to your response to AOBA Data Request Set 3, Question 30, Part A, Part A of that response, AOBA's request references a $1,835,000 or greater than 12% increase in the company's claimed AIP cost between the 12 months ended September 2024 and the 12 months ended September 2025. That's in Part A of that data request. You see that?
I do.
Okay. Do you accept the accuracy of those representations regarding the increase in Pepco's AIP costs?
Do I accept the response that we can include it in Part A?
Do you accept that calculation of the $1,835,000 or greater than 12% increase in the company's claimed AIP costs between the 12 months ended September 2024 and September 2025?
Yes, I would say that the 12 months ended September 30th, 25, less the 12 months ended September 24, generally gets to that $1.8 million number.
And that's a 12% increase in cost.
I can't do that math in my head, but
Subject to
subject to
check.
check.
Your response to Part A of ALBA Data Request Set 3, Question 30 suggests that the observed increase in AIP cost is primarily due to changing headcount and merit increases. Is that correct?
That's what it says in the response.
You also refer to supporting data in, I don't know whether it's IN or 1N, A22 TTYCF, attachment electronic only. Correct?
Yes,
Refers
I see that.
Okay. Is it correct that neither your response to Part A of ALBA Data Request Set 3, Question 30, nor the supporting data in INA22 TTYCF attachment provides information regarding the referenced changes in headcount, nor the dollar amounts of merit increases paid?
I don't have that attachment in front of me.
Okay, I do. I should have passed it out. I think your honors have a copy.
What document are you?
I'm looking at
What document are you
It's
referencing?
Maryland Pepco 9820 TTYCF supporting data update section. Is that a 1 or an I?
Is that in this packet?
It's coming. It's your document. 1N attachment A22, 2 pages. I passed it out this morning.
Is it in this?
I gave it to the executive secretary. That was the second packet I gave you.
Oh, I see. Is this number 8?
I didn't mark this yet.
Oh, okay. Okay. Okay.
Oh, my God. Ed, are you passing around your magnifying glass?
Your Honor, I passed out 3 documents earlier today to the executive secretary.
No,
Three-
no, no, are you passing it around your magnifying glass? No, I'm kidding.
Oh,
I'm nearsighted, so it's not a problem for me. So she hasn't marked this yet. Okay.
Your Honor, I'd like to mark this as, I guess, AOBA Exhibit 9.
So marked.
Counsel, you handed me documents earlier. Which one is it? I'm sorry. Can you show me what it looks
It
like?
says, it's this one. Try the other one.
Wait, thanks.
I'm going to ask the question again, Mr. Nelson, okay?
Sure.
Unless you remember it.
No, please.
Okay. In your response to Part A, in ALBA Data Request 3-30, you refer to supporting data in INA22 TTYCF attachment electronic only. Am I correct that neither your response to Part A of ALBA Data Request Set 3, Question 30, nor the supporting data in INA22TTYCF attachment provides information regarding the reference changes in headcounts nor the dollar amounts of merit increases paid.
I would agree there's nothing in here related to headcounts. I think that's just documenting the contributing factors as requested in the data request.
Mr. Nelson, your response to AOBA data request set 3, question 30 refers to the supporting data in INA22TTYCF attachment as electronic only. Am I correct that that attachment was filed in PDF format?
I don't know the answer to that.
Okay. Based on the information in AOBA data request set 3, question 30, and the supporting data in INA22TTYCF attachment, would you accept that there is no basis for a third party to verify the influences of changes in headcounts and merit increases on the company's claimed AIP cost for the 12 months ended September 30th, 2025?
I would agree with you. Within the documents that you've referenced here presented, there's no headcount numbers.
Okay. In your response to Part C of AOBA data request set 3, question 30, you provide a table that details a 10-year history of unallocated distribution and A&G, administrative and general, annual incentive plan expenses. Am I correct that the data presented are for calendar years 2015 to 2024?
Yes, that's correct.
Would you accept, subject to check, that in the column labeled A&G, the company's AIP expenses increased by more than $1.8 million, or nearly 20%, between 2023 and 2024?
Subject to check.
Looking at the same chart, between 2015 and 2016, we also observed comparatively large dollar and percentage increases in Pepco's AIP expenses. Would you accept that the period between 2015 and 2026 is when, 2015 and 2016 is when the PHI merger with Exelon became effective?
I don't have that exact date or knowledge.
Do you know if that's the approximate time period?
I do not.
Okay. Would you accept? Would you accept that the supporting data for the TTYCF RMA 22 indicates that over the 3-year period you have used to compute the average annual AIP cost for your TTYCF RMA 22, the company's distribution and A&G AIP costs include incentives paid to PHI, Fisco, and Exelon BSC employees, as well as incentive paid to Pepco employees?
Yes, I think that's right.
Now, AOBA data request set 3, question 30, was premised on your October 14th, 2025 direct testimony. Did you update RMA 22 and supporting data for that RMA when you filed your supplemental direct testimony on December 18th, 2026?
Can you point me to that?
I'm sorry?
Can you point me to that in my supplemental?
I'm asking, did you update it in your supplemental? Yes, I can. Okay. I have it on page page 29 of 48. I'm looking at your supplemental testimony, your supplemental direct.
Yes, I'm there.
Okay. Now, the original data request, set 3, question 30, was premised on your October 14th, 2025 direct testimony. Did you update RMA 22 and supporting data for that RMA when you filed your supplemental direct testimony in December 2025?
The numbers do look very immaterially different.
And this is an update in your supplemental, correct?
Yes, those numbers are different.
Am I correct that your initial support for RMA 22 included, excuse me, Your Honor, included projected data for the months of July through September 2025 and the updated support for RMA 22 as provided, and the updated support for RMA 22 was provided in December 2025 in Pepco's TTYCF supporting data update section 1N attachment A22, which reflects 12 months of actual data for the TTYCF.
Yes, we updated to 12 months of actuals in the supplemental direct.
If we review the comparable pages for the TTYCF RMA 22 from your direct testimony and your supplemental direct testimony, would you accept that for the 2 fully historic years, the 12 months ended September 2023 and the 12 months ended September 2024, the company's reported AIP costs declined slightly, while the reported cost for 12 months ended September 2025 increased further?
I agree that the 12 months ended September 2023 and 2024 decreased, and the 12 months ended September 30th, 2025 increased.
Would you accept, subject to check, that from the AIP expense detail presented in TTYCF supporting data update section 1N attachment 22, we find that of the total reported distribution and A&G incentive costs for the 12 months ended September 2025, 62% are for A&G incentive payments.
Can you point me to that number?
Well, actually, I am looking at the second page of what was marked as ALBA Exhibit 9, Section 1N A-22, page 1 of 2. And when you turn the page, you see a whole bunch of columns that
Yes.
when we were doing the numbers, we were doing it electronically, so we're able to read them. So that's where I got these numbers from. So that's the question that I'm asking you. We find that of the total reported distribution A&G incentive payment costs for the 12 months ended September 2025, 62% are for A&G incentive payments.
I'm not sure which columns you're adding up, or if it's all Pepco, if it includes the service companies. I'll just say subject to check.
Subject to check. Do you agree? Okay. Would you also accept, subject to check, that of the total A&G incentive payments, 88.8% are incentives paid to FISCO and BSC employees? And again, I'm getting that information from this chart.
Subject to check.
Okay. What justification have you presented in your testimonies in this case for Pepco's payment of AIP costs for FISCO and BSC employees?
I don't know that I've specifically included the justification. I will say that costs incurred at the PHI service company and BSC service company are ultimately incurred down at the Pepco Maryland level and included in our cost of service. I think that, there was some documentation around the benefit that this provides from an operational efficiency perspective.
That's
as
what
well
I'm
as
asking
being-
for. Where are those operational benefits shown in your
I don't-
testimony?
I don't think we quantify them or present them.
Okay. Is it Pepco's position that incentives paid to BSC employees provide equal or greater benefits to Pepco's Maryland ratepayers?
Can you reframe the question, please?
Do you believe that the incentives paid to BSC employees provide equal or greater benefits to Pepco's Maryland ratepayers than Pepco employees?
Yes, I don't know that we weight the benefits across the different employees and where they sit.
And again, as of that specific quantification, there is no quantification of the difference in benefits provided from BSC employees versus a Pepco employee, correct?
We do not have a quantification of that.
Okay, Your Honor, I think I marked earlier Pepco's response to AOBA data request set 3, question 31 as AOBA Exhibit 8. Okay, I'd like you to refer to AOBA Exhibit 8.
Sorry, what did you want me to refer to?
It's Pepco's response to AOBA 3-31.
Got it.
It's in your packet this morning.
Yep, I have it.
Okay, and I believe we established that you're the sponsor and that it's true and correct to the best of your information, knowledge, and belief?
Correct.
Okay. Now, AOBA data request set 3, question 31, addresses TTYCY RMA 24, under which Pepco seeks recovery of cost for auto and general liability claims. Is that correct?
Yes, a 3-year average of auto general claims payments.
Now, in your response to Part A of AOBA data request set 3, question 31, you reference supporting data IN A24TTYCF, attachment electronic only. But in fact, this supporting data was provided in a PDF and was updated along with your supplemental testimony that was filed in December. Is that correct?
I don't have that attachment in front of me, and I'm not exactly sure the date.
Okay. I'm going to give it to you as soon as I can find it. Your Honor, I believe Your Honors have a copy that was passed out this morning.
Are you talking about the attachment marked 8?
A24, 12/18, 25 update.
It's coming now.
Okay. Yeah, okay. Oh, here we go. For you. Yeah, there you go.
Okay.
I mean, it is.
Your Honor, I would like to mark the supporting data update, section 1N, attachment A22, pages 1 and 2. Excuse me, I'm marking the wrong document. Scratch that. I would like to mark the TTYCF supporting data section 1N attachment A24 12/18/25 update, a 4-page document as AOBA exhibit
10.
10.
10, so marked.
Now, looking at this, Mr. Nelson, I'm going to ask my question again. In your response to Part A of AOBA Data Request, Set 3, Question 31, you reference supporting data INA24 TTYCF attachment electronic only. And would you accept subject to check that this was provided in PDF format and was updated along with your supplemental direct testimony that was filed in December 2025? Is that correct?
Subject to check, and it looks like it has a 12/18/25 date
Okay.
in the titling.
Okay. Exhibit 10. Okay. Now, and this is an updated version of the information that you referenced in response to AOBA Data Request Set 3, Question 31, Part A, correct?
I don't know the timing of when this data request was received and completed versus this update. It does reference the same IN attachment A24.
Well, Question 31 referenced your direct testimony, correct?
Yes, that's correct.
Okay. Do you know, Mr. Nelson, when was this provided, AOB Exhibit 10 in PDF format? Do you know?
The only information I have with me currently is the 12/18/25 update in the top right corner.
Okay. Am I correct that the supporting data provided in the company's TTYCF supporting data section 1N attachment A24 12/18/25 update shows that the vast majority of claims payments made by Pepco are for general liabilities and not auto-related liabilities?
And you're distinguishing line 1 versus line 5?
Well, actually, I was looking at all of the supporting detail in pages 2 through 4.
Can you restate the question?
Am I correct that the supporting data provided in the company's TTYCF supporting data 1N attachment A24 dated 12/18/25 update shows that the vast majority of the claims payments made by Pepco are for general liabilities and not auto-related liabilities?
Yes, I would agree that the numbers in the general column are larger than the ones in the auto column.
Does Pepco carry general liability insurance?
I don't know the answer to that. I assume so. I don't know the answer to that.
So you don't know that are the claims payments that Pepco has made over the last 3 years, are they reflective of payments that were partially covered by general liability insurance, and these are claims over and above that? You have no information on that?
Your Honor, at this point, I'm going to object. These questions are veering a lot into discovery-type questions. This all could have been handled in discovery.
obviously we did discovery because we got these documents. So there was discovery.
you know what? I'm going to allow it and overrule in this case, but be careful, counselor. Just
I'm not going too far on this line.
okay. Thank you.
Can
So-
you restate the question?
So you don't know whether the company carries general liability insurance. Is that correct?
I do not.
Okay. And so I ask you, obviously you don't know whether any of these claims payments are for claims made over and above liability insurance that may have been made to some of these.
I do not have that information.
Okay. Should ratepayers be held responsible for the cost of liability claims if the company has elected not to carry insurance?
I would say that these costs have generally been accepted by the commission as a cost of service incurred at the company by the company, and this rate making adjustment has been precedentially accepted most recently in 9602.
I understand that, but that wasn't really my question. My question was, do you believe that ratepayers should be held responsible for the cost of liability claims if Pepco has elected not to carry general liability insurance?
Objection, Your Honor, asked and answered.
Sustained. I agree.
Okay. Now, one more exhibit. This, I believe, is in your packet, the first packet of data requests that I handed out this morning. It's Pepco's response to 7-15. And I would like to introduce this as AOBA Exhibit 11.
7?
11?
Do-
11.
I'm sorry. I'm losing track of the. Oh, 15. Yes, got it.
It's the last
I
page.
got no.
Okay.
I got it. So marked.
Okay.
What was the data request? Sorry.
7-15.
I have 3.
Keep going at the end of the packet.
It's the last
Yeah, it's the very last page.
I have 3-16.
It looks like this.
It's
I
dash.
have it.
Yeah.
Sorry. Got lost.
Exhibit 9. Ms. Francis,
Yes.
up here.
Oh.
What was your Exhibit 9?
TTYCF supporting data update. Yeah.
Thank you.
Okay, thank you. Okay. Do you have that, Mr. Nelson?
I do.
Okay. Am I correct that you're listed as the sponsor of Pepco's response to AOBA data requests, set 7, question 15?
I am.
Is it true and correct to the best of your information, knowledge, and belief?
Yes.
Okay. Your Honor, I don't have any more questions, but I would like to move the admission of AOBA's exhibits 6, 7, 8, 9, 10, and 11.
Your Honor, I don't necessarily have an objection to the entrance of those exhibits into the record. I would just note that on AOBA 6, the company's response to AOBA DR 314, Mr. Nelson was a co-sponsor with that with witness Allo. So obviously, Mr. Nelson can only attest to the portions of his response that he sponsors there. I honestly don't know if counsel for AOBA asked questions about this to Mr. Allo yesterday. And then AOBA 7, again, Mr. Nelson is a co-sponsor along with Ms. O'Donnell, who I know is going to be coming
She's
up on
coming
the
up,
stand.
yeah.
Yes, and I know she speaks about head count and whatnot, so I just wanted to include that caveat.
Certainly. So without objection, so entered.
Okay. That's all I have, Your Honor.
Thank you. Next, we will go to MEA. Does MEA have an?
I think MEA went.
Oh, that's. I forgot. You see, you're messing me up when you go out of order. Who hasn't tested? Is it staff now? Okay.
Thank you. Mr. Chairman, may my co-counsel, Ms. Wilkerson, approach the bench and the witness?
Yes, granted.
and this, I think, should be easy. It's staff, we'd like to mark it as staff 5 with your permission. And,
So marked.
thank you. It's the company's response to staff DR 56-1. We're not asking for admission for 56-2.
Ms. Herman, are you absolutely sure you're at 5? Is it 4? Just, you know. I mean, it's,
I'm checking. I'm not absolutely sure. We are at. I didn't enter 4 yet. Can I leave a placeholder
Yes,
for
you
4?
may. Yes,
Thank
you
you. Thank you very much. We're going to ask about 4 later. Thank you. And I believe the company will stipulate to the admission of this into the record if it's okay with the other parties. Is that Counsel for Pepco? This is staff DR 56-1. In the packet is 56-2. We're not asking for admission into the evidentiary record of that. Just Pepco's response to 56-1 for this witness.
okay, well, anyway, so marked as 5, and we'll get to 4 later.
Thank you. And could we ask that this be entered into the evidentiary record? I don't have any questions about it. And I believe that the company will stipulate to agreeing to DR 56-1.
If there's no objection, we'll enter it.
Just with the caveat, Your Honor, that once again, on Mr. Nelson is a co-sponsor
Right.
on one of the responses, and the other responses are for Ms. O'Donnell. So,
And
but we
Allo.
don't- but for the portions that Mr. Nelson is sponsoring, we have no objection, Your Honor.
Thank you. That's fine with
Okay,
us.
so entered.
Thank you.
Your Honor, if I may be heard for a moment,
Sure.
just in response to the company's discussion of the co-sponsored DRs, it's not clear on the DRs which subparts were sponsored by which witness. So unless it's abundantly clear which subparts were sponsored by which witness, the witness on the stand, it should be, if that witness is knowledgeable of the DR response, there shouldn't be an issue about who sponsored it.
Could I be heard about that? I'm sorry. We actually have already entered that question for Lemming and for Allo. We've already, it just happened earlier in the case, and I don't want to bore everyone with it, but I'm sorry.
Counsel, no, I'm just raising it as a general matter because it came up with the OPA's exhibits too.
Well, I mean, it's a point well taken. I think that as a general rule, as we go through the procedure, we can ascertain who's knowledgeable about what data point. So, but thank you for bringing that up. Ms. Herman.
Yes, sir. Thank you. I have 6 yes/no questions and then one really short question. And I want to ask the question 1 first and ask for the board and Mr. Chairman to consider that this is a different question. There's a word difference, but it's a word that makes all the difference in the case. And I don't want to go into attorney testifying, so I don't want to give more of an explanation. So if I could have leave to just present the question and see what the parties and the board thinks.
Certainly.
Good afternoon. Good morning, Mr. Nelson.
Good morning.
Mr. Nelson, did Pepco provide a list of all TTYCF plant closings in this case? One list, either in your testimony or somewhere else in the case.
I'm not aware of a list that has been aggregated into one. I think all the data has been provided within discovery to parties that makes up the population of plant additions that are being sought for recovery in this case.
Okay, thank you. Mr. Nelson, am I correct that your Surabottle testimony updated information for RMA2, inclusion of post-test year reliability closings, October of 2025 to March of 2026 from your rebuttal testimony? Is that correct, sir?
The surrebuttal update was to 1 month of actuals for RMA2, so it was March of 2026. The 5 months prior to that had been provided sometime earlier in early March to the parties.
Thank you.
In her question, she said rebuttal, and you answered surrebuttal. Does that matter to anybody?
It does, and I missed that. Thank you. Should I ask the question again?
Please.
Okay. Mr. Nelson, am I correct that your surrebuttal testimony updated information for rate-making adjustment?
You just said surrebuttal again there. Are we talking rebuttal?
No, actually, she said rebuttal the first time, and this time she said surrebuttal.
And what I meant was, did your
Potato,
surrebuttal update
potato.
the rebuttal? I apologize.
No.
Yeah. What I meant, did your surrebuttal update the rebuttal?
I think that's what I answered the first time.
Okay.
So that we're clear, that's
Yeah.
it.
So sort of, but not exactly, but in two ways, I think I heard. Did your surrebuttal testimony highlight the changes by ITN from your rebuttal?
I don't know about by ITN. It may have been a lower level of granularity than that.
Mr. Nelson, am I correct that your surrebuttal testimony updated RMA 3, rate making adjustment 3, inclusion of post-test year reliability closings, April of 2026 to July of 2026, from your rebuttal testimony?
Yes, it was updated from rebuttal.
Did the surrebuttal highlight the changes by ITN?
Again, I think it was at a lower level of granularity than that.
Mr. Nelson, during rejoinder, am I correct that Mr. Seegers asked you if Pepco provided invoices and executed agreements for rate case expenses? Am I correct?
Can you restate the question?
Sure. Am I correct that during rejoinder, counsel for Pepco asked you about Pepco providing invoices and executed agreements in support of rate case expenses?
I don't know that he asked me specifically about that. He may have asked how we have approached and supported the rate case expenses presented in rate making adjustment 10, and I think my response was these costs to prepare and develop this case are supported by actual invoices and executed contracts.
Were those filed with the commission? The agreements, the contracts that you mentioned, were those filed in the confidential docket somewhere, or?
I believe they were submitted via data requests. I don't know if they were filed specifically with the commission.
And then the next question, and maybe someone can get back to us, when were those filed in a discovery response? That would be my next question, and maybe someone has to get back to us.
I don't know that offhand.
Yeah, sure. And I just have two more, and then we're done. Mr. Nelson, is it your testimony, yes or no, that the commission has always authorized a return on rate case expenses across all utilities? And I'm just asking you a question because I was listening yesterday, and I just want to know if that's what you said. So yes or no, is it your testimony that the commission has always authorized a return on rate case expenses for all utilities?
I can't speak for all utilities. I think my response yesterday was, in the recent instances where the commission has approved regulatory asset treatment in cases 9443 and 9418, it was commensurate with the return on that regulatory asset recovery.
That's all I have, Mr. Chair. Thank you.
Thank you. Redirect?
Just briefly, Your Honor. Good morning, Mr. Nelson. Let's start with let's start with OPC. Mr. Nelson, do you recall being asked by counsel for OPC about the company's proposals regarding exogenous costs?
I do.
Can you tell us, are any of OPC's witnesses, are any of them in support of any of the exogenous costs proposals of the company?
Yes, OPC witness Madsen communicated his support for the pension regulatory asset and the extent that those costs are largely out of the control of the company.
Okay. And in the discussion that you just had with counsel for staff, do you recall being asked whether or not the company has provided a complete list of plant closings for the TTYCF?
Yes.
Are you able to tell us, has that ever been, or at least in recent history, has that been a requirement in any traditional rate year case?
Not that I'm aware of.
Okay. And is it also, and were the parties to this proceeding, or at least OPC, AOBA, and staff, were they able to calculate a revenue requirement without such a list?
Yes, they were.
Okay. And staff also asked you about actual rate case expenses.
Yes.
Okay. What is staff's position regarding the company being able to recover actual rate case expenses up to the date of the hearing?
They agree with that.
Okay. And has the company, have we provided actual rate case invoices up to the date of the hearing to staff?
We have.
Okay. Was that done in discovery?
Yes, it was.
Okay. And finally, Mr. Nelson, in your discussion with MEA yesterday, I believe that you were asked about whether or not we have a list of all the projects for which we are seeking recovery of in the TCYCF and their revenue requirements. Do you recall that question, Mr. Nelson?
Yes, I believe so.
What would be involved in compiling such a list? Is that even something that's feasible for the company to do?
It would certainly be an exercise to understand the monthly plant balance or plant additions that we're accustomed to, that how they bleed into the 13-month average, and then subsequent to that, calculating a revenue requirement on each one of the plant additions and projects associated.
Okay, and just approximately, if you know, how many projects would that be?
I don't know offhand.
All right, thank you very much. Nothing further, Your Honor.
Very good. We'll turn to the members of the commission. The order for questioning in this instance will be Commissioners Suchman, Hoover, McLean, Linton, and the chair in that order. Commissioner Suchman.
Good morning, Mr. Nelson.
Good morning.
So when Pepco filed initially with the commission, it was filing for a fully forecasted test year. And then you drew the short straw and were responsible for the traditional test year compliance filing. Is that correct?
That's correct.
Okay, and of all of the witnesses that were proffered by the company, you are the only person who is responsible for the traditional test year compliance filing. Is that correct?
I would say for the revenue requirement of the traditional test year compliance filing, there's also testimony from at least company witness Allo on some of the rate making adjustments that we've included in this proceeding. So I would say from a revenue requirement perspective, I'm the sole witness for that.
Right, but the information that we would need to be able to make determinations then is not just in your testimony, it's in other testimony, but it is it's mixed up with the fully forecasted test year filing.
I would just add that I think part of the reason why we included some of the fully forecasted test year testimony and when we went through the red lines was the fact that a lot of some of the basis, at least from parties, was predicated on some of that information that was included in the proceeding. So to not muddy those waters, I think that was generally our approach. From a traditional test year compliance filing and the actual cost of service and electric plant and service that sits within rate base as of September 30th, 2025, that's all contained within my testimony.
And I appreciate that. The commission was notified by the company that they were no longer pursuing a fully forecasted test year. That they were just going to pursue the historical test year. And then we asked that for purposes of administrative convenience, but also to know what it is we should be focused on and what we should not be focused on. We asked for redlining the testimony, and I can tell you that the redlining was inadequate because, just as an example, witness Williams yesterday was almost everything about his testimony was fully forecasted, and yet I don't believe anything was redlined in his testimony, and that's created a burden for the parties and for us because then it sort of puts the burden on us to go through the testimony, try to figure out, is this fully forecasted and is this historical, and it also goes to the heart of my concern and concern that you have heard from parties, that we're not clear on what's in and what's out, what's missing and what's not. And so I have a bench request for the company, and it's pretty extensive, but it's going to help us. It's going to help you because the burden is on you, and so if we don't have this information, then the possibility is that we're just going to find that you haven't met your burden. So this is for you, but it's also for the parties who have been expressing over the last couple of days information that is either missing or not clear. Okay, so in your testimony, you noted that you were discussing rate-making adjustments both to rate base and operating income.
Correct.
Okay. So in terms of the rate base adjustments, I would like you to prepare a document that identifies by ITN every project that is impacting rate base for that test year, for the historical test year, the amount for each of those projects, whether the amount is based on historic or forecasted amounts, because yesterday during Mr. Williams' testimony, he had, there was a chart that looked to some information that was historic and some was forecasted and was not clear. I mean, this was, I think, for 2023, so it wasn't clear to me why forecasted was in there. So when you put that amount in, we need to know what is actual and what is projected, and then the in-service date, and that also needs to include actual versus forecasted, because yesterday you were talking about reliability projects that you were sure were going to be in service, but it was for next year and the year after. So we need to know for all of those the identified projects whether the date is actual, has already happened, historical, or forecasted. For O&M, we'd like you to specifically itemize the cost for the test year. Because I don't think that there's a sufficient amount of information in the testimony. And then finally, you have 37 rate-making adjustments. We would like you to link the everything that you're sort of laying out now to the rate-making adjustments, to the specific rate-making adjustments, because again, I can't tell, what you were talking yesterday about rate-making adjustments 3 and 4, and for the life of me, I can't tell you what's in those. So we need to then work backwards. I mean, you're asking for a lot of money. And the response shouldn't be, well, you have enough information to make that determination, because I can tell you we don't. And so, and this is, I understand that this is a lot of information we're asking from you, but this is information that should have been submitted when you first filed your case, and we shouldn't be having to ask for it now during a hearing, because it's clear to us that we don't have the information that we need.
If I may,
Please.
I would just say the commission, and you noted this very early on, the company's initial proposal was really from an FFTY perspective, and we felt like what we've included in the record was supportive of that, and we complied with 9702 to provide the requisite information from a traditional test year perspective. I think as far as testimony goes, we did think that it was valuable to leave in some of the testimony that gave insights into the operational planning associated with some of some of what we do across our organization here. And in addition to that, I would say the parties were. There was never a point where there was confusion about the traditional test year, and we provided in discovery what was needed to them, and completely appreciate the bench requests, and we'll make sure we address this. But I
I
think
can tell you that there was confusion because I've been hearing confusion over the last couple of days. And I appreciate that it's a challenge to try at the last, you provided the notice to us just on the eve of the hearing. So I appreciate what a challenge it would have been. I suppose it would have been less of a challenge if rather than just sort of it would have been a less of a challenge if you had actually provided historic test year proposal as well as a fully forecasted proposal. That would have made it a lot easier, as opposed to just sort of saying, well, we're going to give you the information that you can use if you need to develop historical test year, because then again, that puts a lot of the burden on us and our poor staff. And we love our staff, but there's only so much that they can do, and that shouldn't be up to us.
I'll just agree. I would say the only thing is we received revenue requirement adjustments from all parties, and through discovery never got the pushback of we don't understand what's in or how we can make adjustments or what they were attributed to, and all the parties have developed revenue requirements. So the confusion seems in the hearing to be a little different from how we have gone through the proceeding, and completely understand the legislation has kind of thrown a wrench into all this. So
Right, but Mr. Nelson, understand that I've read all the testimony, and I can tell you that I have been overwhelming my staff with questions about where is this and why is it. So even if the parties were not confused, but I can tell you that they've been confused as well. I can tell you that I'm confused, that I feel like there is not the kind of information that we need for us to make a determination about what's just and reasonable. Okay, so you understand what we're asking.
I do, yes,
Okay.
and we will get the team on that, and we're certainly interested in making sure everything is in the record so that you can make the appropriate decision.
Okay, but also this information is not just for us. This is for the parties as well. So they're going to need the information before they submit their briefs. And so I would love it if we could have it while the hearing's going on, but I understand that that's not possible. Can you get it to us within 10 days? Is that doable? I mean, it should be information that you have now.
I will say, just by the breadth of across rate base, O&M, and rate making, just we'll do our best. I mean, we will actively be working on this today. I don't know that I can commit to 10 days, but we will get it to you as soon as we can.
And Commissioner, I would just ask if you could just repeat what you're looking for, because I want to make sure, because I don't believe that I got all of it.
I mean, I think we can
I can repeat
transfer
it, but it's in the transcript. So I'd rather actually rely on the transcript now that I've gone through.
We can send something to you to
Okay.
make
Okay.
it crystal clear what we intend.
That's a
Thank
good
you.
idea.
Yes,
I recognize why Commissioner Suchman is asking what she's asking for. It's essentially looking at what is missing or putting the pieces together.
Right.
My question is Pepco filing a bunch of numbers? Are they filing testimony?
Well,
And-
let me answer your concern in this fashion. And before I recognize Commissioner Hoover, let me just say that it's always dangerous to, having been the CFO of a medium-sized company and having had to report to my management, it's very dangerous for me to draw an analogy between my little $15 million company and a gigantic company like Pepco. But the basic principle, the basic context within which I think we want to set this is, ideally we want to have a large enough data set with sufficient descriptors so that our staff can put it in an Excel spreadsheet and slice and dice it in ways that makes it meaningful for us and allows us to make proper decisions with respect to this case. And so, I don't mean to be critical of the company here. I do appreciate the fact that the company received the message from the state legislature in what the Relief Act required, and you very, proactively reached out and said, we're going to make this a historic test year case, and you conscientiously tried to change all of your submittals to reflect that. I appreciate that, and I appreciate the fact that it was sort of last minute, not your fault, but it was. And I suppose the comfort I want to know is I want to know that my staff and my advisors and my colleague commissioners have the ability to look at the totality of the data and to come to sound conclusions. I think that's the position of the commission, and certainly my position. Go ahead, Ms. Francis.
Okay, my concern is, and again, I don't mean this to cast dispersions, but we've all seen a lot of corrections and a lot of changes throughout this case. So Pepco's going to be producing something comprehensive and new. We haven't seen it. We haven't been able to even try to understand it, relate it to these notebooks full of information that we've already seen. Are we going to have a chance to respond to it? I'm always concerned at the end of a hearing when, after hearing additional filings, whether they're bench requests or party requests, if new information comes in that hasn't gone through the vetting process. So I don't know what we're getting. I'm sure it's going to be extensive. I'm sure they will try to, in view of Commissioner Suchman's concerns, I'm sure they're going to try to respond. Number one, we don't know exactly what that will look like. We don't know whether there will be errors in it. We don't know if we will be able to respond, and if we can respond, how do we respond?
Well,
So
let me.
I'm not objecting. I'm just sharing my concerns that this is hitting me right now.
Well, let me address the issue of errors. I mean, I am confident that the company will conscientiously give us information that is correct, which ties back to their audited financial statements and their cost counting system, which I'm sure is 1,000 times more complex than anything I've personally ever worked on. I'm confident that they will conscientiously do that, and that this data set will allow us to make correct decisions on information that we regard as being meaningful. So let's wait and see what we get. And but I appreciate your your comment on this. I sense People's Counsel moving to the microphone. Or
No, I've been advised by my co-counsel to refrain, so we will. If there's a matter related to this discussion, you'll hear from us, Your Honor.
okay, thank you. Awesome man that he is. So, all right. With that, I will proceed to.
You're done, right?
She's done.
I'm done.
Okay.
You're up next, Commissioner.
Mr. Nelson, can you turn to Pepco's Exhibit 30-C?
This is in my direct or in rebuttal?
This is
or,
what you were given by your counsel during the, before you started being crossed. This is the, oops.
What a man.
And before everybody sort of jumps out of their seats, I understand this is a confidential attachment, and I'm actually not going to ask any questions about the numbers.
Okay.
So this is an invoice for services rendered by Concentric in support of Pepco's rate case. So I guess my question is, why did the invoice go to somebody at Exelon?
I believe it needs to go through our supply organization that sort of manages this, and there's certainly efficiencies that can be had with that when you talk about the business services company and sort of how they approach it across the greater Exelon organization. I'm not sure why it goes directly to an Exelon employee.
Well, I guess
It could just be-
my question is, I mean, Concentric, do they work for Exelon? Do they work for just for Pepco? And were they selected by Pepco, or did Exelon tell you to hire these people?
No, Exelon didn't tell us to hire. I think this was a conscious decision, and when we considered Pepco engaging with Concentric, it was purposeful, and as I stated earlier, something that was based off of their understanding of the Pepco case dynamics and the consistency at which they provide all their analysis, and additionally, from I think company witness O'Donnell outlined in her testimony challenges around hiring and attrition, and so this was something that was considered and the best option for us to provide the needed analysis.
Okay, and then does Exelon send you a bill for what they pay for, or?
No, I think all these costs would be incurred at the Pepco Maryland level.
Okay. All right, that's it. Thanks.
McLean.
Good morning, sir. AOBA and OPC hit on almost all the things I wanted to touch on. There was one issue Mr. Oliver brought up in his SIR rebuttal. I don't know if you want to give him, I can summarize it, but if you want to have it in front of you, that's fine.
This is the SIR rebuttal you said, Your Honor?
Yes, sir. I'm looking at page 8, and I don't think you addressed it. I don't know why I'm honed in on storm costs in this case. Page 8, sir.
Okay.
Line 5, Mr. Oliver discusses the July 2023 storm costs, and he claims that the document or work papers you provided included expenditures through June of 24, and that it also included overtime that it incurred, that the company incurred in October 2023, December of 23, and then April through June of 24. But there's no explanation on that. I wonder if you could just respond to that, sir.
I don't have probably sufficient detail to go into why those costs. I will maybe add the context that as we assess what the incremental value that is actually authorized to be deferred to the regulatory asset, there can be adjustments, invoices can come in at different time, and so I think that's probably a little bit of the reasoning for the timing shifts. When I looked at the data, it did seem to me as though at the end of 2023, we had really incurred the majority of the costs, and from there, potentially some overhead allocation, noise that kind of rolled out through the 24-year period.
Okay, so the overtime that was incurred in April through June of 24, are you saying that you believe that happened closer in time to the storm and you're just getting the bills several months later? Okay.
I don't have that detail, but
Okay, thank you, sir. I appreciate it.
Sure.
Commissioner Linton.
Thank you, Mr. Chairman. Good morning, Mr. Nelson.
Good morning.
So I have a couple questions about some of your testimony and the effort to, and I'll use the word salvage your fully forecasted test year case, converting it to a historic test year. And I have a couple of thoughts about my colleagues on the record request. But I'll start with my question, and I'll point you to your rebuttal testimony, question number 8. So it starts at the bottom of page 4, works on into the rest of page 5. And just give everybody a moment. I don't think we've talked about this section that often. So let me first ask, just to be clear, your testimony is already in the record. I don't recall there being any red lines to this section. I chose this section. There were other sections I could have chosen, but I picked this one first because it's easier to get to, but also because to me at least, it kind of summarized what I thought was a theme throughout all of the case that the companies offered here today. And I asked some of these questions to witness Lemming on the first day of the hearing that making certain that, and so I'll ask the question to you too, uh, you've adopted this testimony, it's in the record, there isn't any changes that you need to make to it of any kind?
Other than the corrections that I mentioned, but not to my rebuttal. I don't believe there are any corrections or red lines.
Okay. All right, so the company's always been, has preferred a forward-looking model. I mean, I think that's fairly confirmed throughout everything that we've seen already. So there's been a bit of a struggle to try and move to a historic test year model. But your current testimony and a number of the adjustments that you've proposed, that you specifically, but the company's proposed, and is now requesting that we include in the revenue requirement, is still fairly significant. I mean, based on my rough math, and I'm not an accountant, but it looks as though it's in the range of about 20% of your current revenue requirement is still forecasted. And that's certainly, you can take that subject to check, but that's, again, I'm a lawyer, so you have to trust my math in that, which you may not want to, but so my first question to you is, in light of the fact that this is a historic test year case, as the company has chosen to proceed that way, at what point is the commission supposed to conclude that a combination of forecasted adjustments starts to look more like a mini forecasted test year case, as opposed to a historic test year case, which is what we're supposed to be working with here now?
Yeah, I guess I would start with, and company witness Lemming, I think, articulated this well, the benefits that we see in aligning the revenues that we are collecting with the costs that we're going to incur in the time period. That mitigation of regulatory lag, I think it's a balance. The commission has accepted that regulatory lag can be beneficial, and also mitigating against that regulatory lag can be beneficial. I think we tried to structure this very similarly to, from a traditional test case perspective, very similar to the rate making adjustments we included in 9602. So I think we were trying to align with costs that will incur in the rate effective period. I will say, completely understand this, and the company appreciates that we're asking for a lot of money. I would just add the context as well of, this really isn't just and one of the things that, from a mitigation of regulatory lag perspective, is it avoids more frequent rate cases where we haven't been in since May of 2023. So it's not exactly a 1 year leap, and so it's an accumulation of a buildup of investments that we've incurred and trying to recover those investments.
Well, I know you haven't been in since 2023, and quite frankly, I wasn't here back then either, but you've been in for adjustments, reconciliations. Have those been annual? So it's effectively the same impact. I mean, customers are still getting increases. There may not be what we would call a full rate case, but it's still the company coming in seeking additional revenue from customers.
Not anymore.
I would agree with you that there have been increases related to the reconciliations that occurred from case 9655. Subsequent to that, in 9702, we were given a historical test year. And so, again, I think these rate-making adjustments, which are largely aligned with what we proposed in 9602, are to just mitigate against that regulatory lag and where the company expects to be incurring costs in the rate effective period.
Mm-hmm. So you mentioned earlier the legislation that the General adopted. The enrolled bill specifically references what it constrains the Commission's authority for this type of case, which is part of the reason why the company modified its case here today. But many of the adjustments that you've proposed rely on what I consider to be a legal interpretation of that enrolled legislation. And just like I know I can't do a whole lot of math, I know I'm not going to suggest that you couldn't interpret the legislation, but I'm not going to ask you a bunch of legal questions about it, because I certainly had some related to that interpretation that I see as part of your testimony, where there's a significant reliance on forecasted adjustments. So I guess I'll just ask the broad question. Are you relying on and interpreting the Utility Relief Act to suggest that the commission can still set the revenue requirement by relying on forecasted adjustments.
I'm not a lawyer, so I don't know how exactly to answer that from an interpretation question. I will kind of go back to my previous answer of when we structured this TTY and to address the requirement as of 9702, we really said, let's just mirror this after 9602 and what was approved there and the rate making adjustments that we requested.
Right.
Completely understand your question. I would just say that's sort of how we approach this. And then from there, the very forward-looking future test year that we included, I think the immediate response was to withdraw that as of the legislation.
So in order for the commission to give the company the revenue requirement that you're seeking, it's not just that the company has to make that interpretation, but the commission has to as well. So it'll be our esteemed chairman that'll have to defend that decision in front of the General Assembly and anybody else that challenges us on the fact that we've reached that conclusion. So, yeah, like I said, I won't ask you a lot of legal questions about that because, as you've already stated, that's not your area of expertise, and I can appreciate that. But I do think that it's an issue that it is your testimony is largely 20% of your revenue requirement, roughly 20%, is based on that interpretation, and it is something that it's not something that I'm going to ask for in terms of a follow-up, but I don't see I didn't see anything in any of the testimony to help me understand how we get there. So with regard to the additional data that my colleague Commissioner Suchman requested, I certainly do. I appreciate it, and I wish he didn't have to ask for it, because I've had similar concerns that she's had. I guess the only point I would point out is that because we have already had the evidentiary proceeding, any additional documents that or information or interpretations that the company is going to present is going to have to connect to what we've already had in the record. So it'll have to point to exhibits, testimony, etc. That does make it a lot more difficult. I'm not sure how that works in terms of our procedural schedule, but it is, quite frankly, we shouldn't have to ask for it, because we should have been able to see that as part of this testimony. It was something that was part of the order, that the company actually filed the historic test year information in this case in response to our order. It wasn't a response to the legislation. But as I said earlier, obviously the company prefers the fully forecasted test year model, which is why we find ourselves now struggling to figure out how to navigate with the historic test year data. I think I'll end there.
Okay.
So thank you, Mr. Chairman. Thank you, Mr.
I don't have anything to add over what I said previously, so thank you very much, Mr. Nelson. And Mr. Seegers, if you'll present your next witness.
Excuse me, Chairman Barve, I apologize. Could staff reserve its right to recall this witness?
Of course.
Thank you.
Why don't we take a 5-minute break? So we'll be back a little after, 11:26, 7, something like that. Okay, let's saddle up here. Please call your next witness.
Getting my papers straight here. Alrighty. Good morning, Chairman and Commissioners. The company calls Lance Schaefer to the stand.
And if you could please swear him in.
Yes, I do.
Mr. Schaefer, could you please state and spell your name for the record?
My name is Lance Schaefer. Lance is spelled Lance, and Schaefer is Schafer.
And do you have in front of you a document entitled Direct Testimony of Lance C. Schaefer?
Yes, I do.
Okay. Does that document consist of 37 pages?
Yes, it does.
Okay. And does it consist of 13 schedules?
Yes, it does.
All right. Was that testimony prepared by you or under your supervision and direction?
Yes, it was.
Do you have any corrections or deletions to make to your testimony at this time?
I do have one minor correction. This is on page 28, and it is lines 7 and 8. Those lines 7 and 8 currently read, however, customer class GSLV peaked in winter in 2024, summer in 2023, and winter in 2022. It should just read, however, customer class GSLV peaked in winter in 2022 through 2024.
Okay, and with that correction, if I were to ask you those same questions today under oath, would your answers be the same?
Yes, they would.
Your Honor, I'd like to get marked for identification as Pepco Exhibit 31, the direct testimony of Lance Schaefer.
So marked.
Mr. Chairman, I'm sorry. Could we request the ML number and the date of filing?
This is the clean version of testimony that was filed on April 24th. And I told myself I'd have the ML number because I knew you would ask, Ruthie. The ML number is 329413.
And I'm sorry we were late getting back to the table. What exhibit number is that?
31.
31.
And was there anything else entered in before we got back to the room?
No,
was that the
we
first
just
one?
got
No, that's-
started.
Okay, great, thanks.
That's it, yeah.
Okay. All right, where are we? All right, Mr. Schaefer, do you have in front of you testimony entitled Supplemental Direct Testimony of Lance C. Schaefer?
Yes, I do.
Okay. And does that document consist of 5 pages?
Yes, it does.
And does it have 7 schedules?
Yes, it does.
Okay. And was that testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions you want to make to your testimony at this time?
No, I do not.
Okay. Do you, actually, Your Honor, I'd like to get this marked as Pepco Exhibit 32.
So marked.
Okay. Let's go to your rebuttal. Mr. Schaefer, do you have in front of you your rebuttal testimony?
Yes, I do.
Okay, and does that consist of 24 pages?
Yes, it does.
Okay, and does it consist of 11 schedules?
I'm sorry, did you say 11 schedules?
Yes.
I
Did I?
believe I have 7.
7?
Yeah.
Okay, 7 schedules.
Yeah, 7 schedules.
And then was that testimony prepared by you or under your supervision and direction?
Yes, it was.
Do you have any corrections or deletions to make to your testimony at this time?
No, I do not.
And if I asked you the same question today under oath, would your answers be the same?
Yes, they would.
Your Honor, I'd like to mark this as Pepco Exhibit 33.
So marked.
Okay. And before I move them into the record, I just want to ask Mr. Schaefer a question, kind of in response to all of the questions we've heard from the bench. Could you direct the commissioners and the parties to where in your testimonies we make distinctions between what's in the traditional test year filing and what's in the forecasted, what supports the forecasted?
Oh, certainly. So every time that I have work that supports one or the other, they're clearly designated. So they're different studies. My TTYCF uses the revenue requirements and rate making adjustments that Mr. Nelson described. And so the final version of that, the final update I had for that was in rebuttal testimony. So when you look at my rebuttal testimony and you look at the schedules for the TTYCF, that is the final class cost of service work corresponding to the TTYCF revenue requirements that Mr. Nelson presents.
All right, so with that, I'd like to move for admission into evidence Pepco Exhibit 31, 32, and 33.
Without objection, so entered.
Mr. Chairman, can we ask again? We got for Pepco 31 the ML and date filed, but could we have it for Pepco 32 and 33, sir? That's the ML number and the date filed.
I'm sure we can.
Thank you.
I think that it is going to be the same one. It's everything that was updated on April 24th.
Okay.
And Your Honor, with your permission, just a brief live rejoinder. Mr. Schaefer, have you been listening to the testimony for the past couple of days?
Yes, I have.
And did you hear the questions from Commissioner Suchman regarding cost allocations specific to White Flint?
Yes, I heard those.
Could you explain how costs are allocated to cost causers?
Yes, and I know Chairman Barbe wants these descriptions to be brief, but so I will try to do that. So a class cost of service study, right? It goes through three major stages of functionalization, classification, and allocation. I won't go through all of them too much because I know that this is not that exciting for some people. But functionalization essentially is where you're taking costs and you're putting it, you're categorizing it related to its functional role that it has. And this is actually much simpler than it sounds. Like, for example, when you look at the FERC Uniform System of Accounts and you look at those FERC accounts, for example, 360 land and land rights, 362 substations, 361 structures and improvements, this sort of thing. You functionalize that by putting them in those accounts essentially. The classification says, are these demand-related costs? Are these customer-related costs? In other words, are they driven by the peak demands of a class, or are they driven by a function of the number of customers that are in that class? And then finally, after you've done the functionalization and the classification, you look for the allocation, the best allocation factors to apply to those costs to get them distributed to the customer classes based on the general concept of cost causation. So the class that is causing the cost to be incurred should be the class that's paying that cost, right? Now, most of the costs in the class cost of service study are shared costs. They're joint. It results from shared infrastructure, and so the art of the science of the behind the methodology of doing this is getting those costs allocated between the customer classes in a way that reflects cost causation. Now, I think people find interesting that most of the costs are related to shared use infrastructure. There are classic examples of when you can direct assign infrastructure to one particular class. The example that we almost always cite right offhand is when you look at FERC account 373, which is street lighting and signal systems. We know the class that is that all of that infrastructure is going to, right? So it gets direct assigned right to the street lighting class. So that's an example of direct assignment. But generally speaking, what we're doing is we're looking at shared infrastructure. There are multiple classes, multiple customers that are benefiting from that infrastructure, and we're developing logical ways based on cost causation of getting those costs to those customer classes, right? And so, I mentioned a few people tend to think about the distribution accounts, and I always think about poles for some reason. I don't know, but 364. But obviously, you have 360 land and land rights. You've got substation in 362. You've got conductor in 365. Those accounts that we tend to think about quickly, they are allocated. The allocation factor is based on a demand allocation factor. So we look at the class peak demands for those classes. We add them all together, and then we create an allocation factor by saying like, oh, this class's percent of that total amount is X, and we allocate those costs off to them. So this really reflects the load that's going over that level of the system. We obviously adjust these based on line losses, so they reflect whether it's happening at subtransmission, primary, or secondary. But that is on the demand-related side what happens. On the customer-related side, typically it's some sort of ratio related to the count of customers or to equipment that's clearly classified as customer-related, like meters. The real key to that one is that infrastructure is not infrastructure that's in place to kind of meet a changing level of demand. For example, if you when we look at meters, you would have to have a meter if you had no usage at all, right? And I've worked in places where our customers have had hunting lodges up in the north, and they say, hey, why do I have to have this meter? I don't go out there five months out of the year. It's related to the fact that they are customers. They do have to have a meter, whether they use 200 kWh or 300 kWh. So those types of costs are allocated more appropriately based on customers. There's the quantity of customers. So.
All right, and then just one last question. Mr. Schaefer, in witness Whitehead's rebuttal testimony at page 10, she states that Pepco's proposal ignores marginal cost principles. How do you respond to that position?
All right. So the little context, right? This is in relation to the seasonality study that I submitted. Now, the seasonality study, we were ordered to produce the seasonality study in 9702 in relationship to the company proposal to gradually eliminate the seasonal rate differentiation on certain classes. So we were ordered to do a cost study, right, to inform this general topic. So using methodology that has been generally approved here in Maryland, started my study with that, so that we're kind of speaking the same language. So I'm using an embedded cost study. Embedded costs, as we know, these are costs that are on the books. They're accounting costs, and I used a study that was approved in 9702, because again, if they're costs that are approved, we all know them. We don't have to argue about the costs that are going into the study. Now, embedded, as I said, accounting costs, this was an important aspect of doing this cost study, because essentially what we were looking at is the distribution something that we should consider to be more or less expensive in a different month based on the actual usage of customers? Like, should I say, well, the distribution system is less expensive in January than it is in July, on an embedded cost basis? Like, once we have those costs on the book, can I do that? And I'm saying the whole system, you can think about it individually, like individual infrastructure. You can think like, hey, a utility pole that we put out there in the system, should we consider that cheaper in January than we would in July when the system is peaking? Obviously, I think not, but this is the type of cost study that we produced using class cost of service type techniques, and then adding a few assumptions to try to get to a logical view of fulfilling the order, in fact, for this. Now, embedded is important, right? If we're thinking about embedded versus marginal, utility assets are long-lived. We've got poles that, on average service life for over 40 years, pretty much. We've got conductor, generally, we consider that at least a 35-year average service life. And the costs that are held on the company's books are the costs that were incurred when that was purchased. So imagine you've got a pole from 40 years ago and it's out providing service. The cost on the company's books for that pole is based on what they paid for 40 years ago. It's not a marginal cost. I mean, this is a good thing, right? It's good that this is long-lived equipment, and that you know, the customers are essentially that we're recovering costs as they were incurred back in those times. We're not inflating those costs or anything, right? So when we talk about marginal costs, what are we talking about? We're talking about a marginal addition of capacity, and then the cost that's associated with fulfilling that capacity. And those are modern costs. Those are not embedded costs, right? Now, from a class cost of service point of view, it's very important to remember that we run it on embedded costs. We don't run this on marginal cost. I don't produce unit costs for rate design that are based on marginal costs that would be certainly a lot higher than embedded costs. I don't do that. Now, this general topic is really related to what Witness Whited has said was the need to, and these are the words, interpret and translate the seasonality study that Mr. Schaefer, that's me, put forth, right? So in that interpretation and translation, she has mentioned marginal cost. Now, I would say to you that we have to look at this from a couple of points of view. We have to look at it from a cost study point of view, using known and approved class cost of service methodology. Of course, I've added some assumptions, right? Some assumptions to make it fulfill the seasonal requirement. So we have to look at it from that point of view. And then the translation and interpretation is taking it and putting it on a rate design space. So there is actual cost, and there's cost causation, and then there's taking that information and doing something in a rate design space. And that is what I would argue that Witness Whited is doing when she says that I'm not paying attention to marginal cost. Now, it's really important that I just mention, because I don't want anyone to think that because I've put together this study, and because in the end I say that I don't endorse this study, right? I was doing it to fulfill an order, and I hope it provided useful information. I don't endorse the idea that the distribution system is cheaper in any given month, right? We're finishing up April here, right? The usage in April is much less than July. It's much less than January. The distribution system that's in place is not cheaper in April, right? It's out there providing service. Nothing shrunk. It's out there. So even though I've stated that, I've also stated that, hey, we don't need this type of study, this type of seasonal cost differentiation study, in order to propose innovative rate design, right? So if someone wants to concentrate on rate design based on a policy consideration, for example, if someone is talking about rates and wants to make time of use rates using some sort of technique, that is different from what I have done here with this study. And what I've done in no way stops any proposals of innovative rate design. And in fact, I would say that the proof of that is that no other jurisdiction does this type of seasonal differentiation in a cost study like this. They don't do it, right? And that has never stopped any other jurisdiction from receiving a proposal for innovative rate designs from a rate design witness, right? So where she says I'm not taking into consideration marginal cost, I think really what she's talking about here is that once you move over to the rate design side, marginal cost could be an input to a policy-driven rate design. But I certainly didn't need to do it on the cost side, and I think we can all agree that that's a good thing, because this we don't use marginal class cost of service studies in Maryland. We use embedded, and those costs are lower as a result. So I think that's a good thing.
All right, great. Thank you. And with that, the witness is available for cross-examination.
All right. Let's first go to AOPA.
Good afternoon.
Good afternoon.
A bit earlier, AOBA passed out a Pepco response to AOBA data request 5-8. Your Honor should all have that. Mr. Schaefer has that. And, Your Honor, I would like to mark that as AOBA Exhibit 12.
So marked.
And before I begin, Your Honor, I'm going to be using a lot of documents. This is my only exhibit, but I'm going to be some shuffling back and forth. They're behind me. Mr. Schaefer, am I correct that you're listed as the sponsor of AOBA's response to AOBA data request set 5, question 8?
I'm listed as a co-sponsor, yes.
Okay. And you are one of the co-sponsors, correct?
Yes, that is correct.
Now, am I correct? Is the company's response to AOBA data request set 5, question 8 true and correct best to your information, knowledge, and belief?
12.
AOBA Exhibit 12.
Yes, my understanding of this DR is that this is correct to the best of my knowledge. It was appears to be a correction of a footnote reference.
I'm getting to that. Next question. Does your response to Part A of this request indicate that footnote 1 reference to page 22 of your direct testimony was in error?
That's what is written here, yes.
Yes, okay. Now, am I correct that your response to AOBA data request set 5, question 8 explains the differences in the customer unit cost measures the company has presented?
And sorry, what language are you making reference to reach that?
Okay. First of all, can you pull your...
Oh,
mic
yeah,
real close?
absolutely.
Okay.
Sorry. There we go.
Okay, I'm looking at where it discusses the differences in the customer unit cost measures the company has presented, and I'm looking at your response to Part B. You want to refresh your recollection?
Yeah, thanks. You said Part B, right?
Part B.
Part B, great, great. Right, right. So the difference between the unit cost calculated at the present rate of return versus the proposed rate of return, correct?
Okay. Now, were the customer unit cost measures by rate class updated or revised further in your supplemental direct testimony?
I believe this is making reference to Schedule LCS 3, which was an FFTY schedule. Supplemental Direct updated the TTYCF.
Okay. Now, let's take a look at your supplemental direct testimony.
Okay.
I'd like you to please look at LCSSD-3. Are you there?
Yeah, I'm there.
Okay.
Thanks.
Would you agree that your supplemental direct testimony, LCS-SD-3, page 1, please turn to that.
Okay, I'm on page 1.
Okay. Would you agree that you updated your unit cost measures, and those updates can be found on lines 30 through 38?
So I would agree that for the proposed rate of return for the TTYCF, that the unit costs can be found on the reference line numbers 30 through. In fact, I think it looks like I go through 30 to 40. I've got
Okay.
BCPIV down there, so you're close though.
Okay. Now, am I correct that the company's update to its TTCY revenue requirement in the supplemental direct testimony filed on December 18th, 2025, lowered the company's revenue increase from approximately $142 million to $118 million?
So I don't remember the numbers, but we can do the subject to checks, sure.
Those were approximate numbers.
Okay.
Okay. Do I understand that the company's response to AOBA data request set 5 question 8 indicates that the company's original $142 million TTYCF revenue increase request, the computed customer cost for the GTLV class at proposed rates was $1,365.11, and I am looking at 5-8. I'm looking at the chart in the middle of the page.
Sure, right. So, as we mentioned earlier, this appears to make reference to the FFTY. And so you've sent me to the supplemental direct, which includes only TTYCF. I don't think this data request talks about TTYCF. It's referencing LCS3. That was in the original FFTY schedules that that we've removed since. But this is making reference to the FFTY, not the TTYCF.
But you would agree that the number is correct, $1,365.11 for the GTLV class?
And for which period? Just because originally you stated TTYCF.
I'm on 5-8.
Right. And do you mind? Because originally when you asked about this DR, you said TTYCF, and I think we've already established that this is FFTY,
Okay,
right?
excuse me.
Thanks.
But the number is correct?
Yeah, for this FFTY, this update? Right.
Okay.
Exactly.
Now, if we turn to schedule LCS SD-3,
Okay.
page 1, line 30 in your supplemental direct testimony, do we find a unit customer cost for rate schedule GTLV customers of $1,669.94?
So technically we don't, because you said line 30, that's for residential, but I understand what you meant. You meant line 35, right?
I did.
Okay, yes, that's what is written there, line 35 for GTLV.
Would you accept that the change in the GTLV unit customer cost from $1,365.11 to $1,669.94 represents an increase of nearly $305, or about 22%, despite the roughly 17% reduction in the company's overall TTYCF revenue increase request?
So, as I mentioned before, I want to make sure I understand this because this is FFTY and you've just said TTYCF again, right? So you're comparing a number that was from the FFTY, you're comparing it to the TTYCF, you're referencing a decrease that I assume is TTYCF versus, I mean, I have to assume that.
The decrease that I'm referencing is that your decrease that was filed by the company on December 18th, 2025, that decreased your requested revenue requirement for the for the test period.
TTYCF.
Yeah, for the test period of 142 million to approximately 118 or 19 million dollars.
Okay, so you're comparing an FFTY number that has that is different than the revenue requirement that's from the TTYCF, and you're saying this number that comes out of your FFTY, which is based on the FFTY numbers, is the decrease relevant to the decrease between the FFTY to the TTYCF? Is that relevant to the decrease from the TTYCF filed in direct to the TTYCF filed in supplemental direct? Do I have that?
No, that wasn't exactly my question. Let's do this a minute. Your updated SD-3.
Right.
Okay. That's for a traditional test year revenue requirement.
Absolutely. Yep.
Okay. And then we talked about the reduction of $142 million to $119 million. That was also for the traditional test year.
Great. TTYCF from direct to supplemental. Good stuff.
Right. Okay.
Okay.
So now we're looking to your response to 5-8,
Yep.
right? Okay. Now, all Schedule 5-8 references it says Schedule PRB-5 unit cost from the CCOSS. And that number that I'm looking at is $1,365.11, right?
Right. The number
Now-
which says in the DR, which says the correct reference is to Schedule LCS3. That's a direct schedule, and that's an FFTY schedule.
Okay. So, you would agree with me that that number reflects a $305, we can argue relevance, but let's just look at the numbers, that represents an increase of $305 or about 22%, despite the fact that the company's revenue requirement was decreased approximately 17%.
I can't agree in any way with the way you're describing that. First of all, you said an increase between two numbers. If you had said there's a difference between two
The
numbers.
difference between two
So
numbers.
there's
Let's
the
do it
difference
that way.
between two numbers, which are not in the same
Okay.
periods or the same revenue requirements of roughly $300. So, to the extent that one number is different from another, I'm acknowledging that the first number that you pointed out is different from another. Now, the relationship between those numbers is important. So if you want to describe it as an increase based on a change in revenue requirements, well, we're getting into trouble here because one of them is FFTY, right? The other is TTYCF, and my class cost of service studies are very clear on which one goes to which period. Okay, they're completely separate. They're labeled. They're marked. There's no ambiguity there.
Okay. Now, has the company further revised its requested test year revenue increase request in its rebuttal testimony?
You're speaking for the TTYCF?
Yes.
I mean, that's a question I would have to give to Mr. Nelson.
You don't know.
Objection. He's asked and answered. She asked if he knew, and he's already said that it went to company witness Nelson.
Sustained.
Can you point to where the company has computed customer unit costs by rate class that are consistent with its most recent traditional test year revenue requirement?
My rebuttal testimony is my last update to the TTYCF analyses for class cost of service. So all of the unit costs that are in that in those exhibits are the last ones that I filed.
Okay. Now, let's turn to your direct testimony, section 7.
Do you have a page number, Ms. Francis?
I will as soon as I find my copy of it.
Okay, yeah, no worries. Thanks.
Section 7, which begins at page 27, line 7. Are you with me?
So, yeah, can I just check to see where you are real fast? 27, line 7.
Lines 27. Begins at page 27, and I'm looking at line 7.
Okay, yeah.
It says class demand trends analysis,
I
correct?
I don't have that there. Page 27, I think we need to confirm where you are.
Council, are you using the updated?
No,
main
Your Honor, I'm using my version that I originally got.
I think mine is on, we can get there, right? I think mine is on page 26, class demand trend analysis, if that's the section title
Yes.
that you're, okay, yeah, we can get there.
Okay.
I've
And
got that.
question 36, and I'll just read the question.
Okay, great.
In case number 9443, order number 88432, what did the commission direct the company to provide?
Okay, yeah.
Okay. Now, section 7 references, well, I have it on line 19, but the second question that says, is the company providing this data in the current proceeding? And what your testimony says is, yes, schedules LCS 16 and LCS 17 provide, do you see that? Parts
yes.
1, there's 3 bullets. Do you see that?
Yep, I see 4 bullets, but
Okay,
yeah.
4 bullets. So we're looking at the same thing.
Yep, yeah, we
Okay.
absolutely are.
Am I correct that the data you present in Schedule LCS-16 include actual data for past periods and either year-to-year or case-to-case percentage changes in measures of KW and KW8 usage by rate class?
Yes.
Now, am I correct that neither your testimony in Section 7 or the data analyses reflected in Schedules LCS 16 and LCS 17 document any effort by the company to fit trend lines to the historical data for each rate class or for any aggregation of rate classes?
Trend lines, as in a visual.
I'm sorry?
Sorry, trend lines, as in
Yeah.
you wanted to see a visual? The Schedule LCS 16 there has all that data by year. I don't have a graphic that has trend lines for you. I have the percentage changes. So,
Okay.
in case you're wondering what's on this, so I've got it for historical cases, the measures, the percentages, and the difference between 2 cases. And so each time we go forward, we have the differences between those. There is not a visual graphic, however, component of LCS 16.
Now, please reference LCS-16, page 1 of 2. Are you there?
Yes, I am.
On page 1 of 2 of Schedule LCS 16, you provide data for annual coincident peak demands, annual non-coincident area peak demands, and annual kilowatt-hour deliveries by rate class for the years 2020 through the years 2024. Is that correct?
That is correct.
Now, on the same page, you also compute year-to-year changes in each of those measures for each rate class. Is that correct?
Yes.
Now, is it your professional opinion that the information in Schedule LCS 16, page 1 of 2, clearly depicts trends in the reported measures of electricity use?
Yes, between those periods, we provide those measures. They are there. We qualify the changes, and all of that is available for clear review.
Now, please look, for example, in the middle of page 1 of 2 in Schedule LCS 16, where you present data for annual non-coincident area peak demands.
Okay.
If we focus on the first line, which is for the GSLV rate class, am I correct that between 2020 and 2021, the annual non-coincident area peak demand for the GS class increased 6.7%?
Correct. That is what is shown.
Now, as we go across the line for the GSLV class, we find subsequent year-to-year changes of negative 5.5% for 2021 to 2022, negative 6.8% for 22 to 23, and plus 19% for 2023 to 2024. Is that correct?
Yes.
Okay. Now, based on those observations for the GS class, can you tell us what the expected percentage change for 2024 to 2025 would be?
Sorry. I think you're asking me, can I estimate based on this, or can I make an estimation of the future, right? Like a forecast.
Expected, forecast, estimation, whatever you want to call it.
No, I haven't prepared a forecast of 24 through 25. Obviously, I've seen the data through. I can't remember what it offhand. I can't recite it to you, but I've seen the data for the 12 months ending June of 2025. But I haven't seen the complete 2025 numbers. And no, I wouldn't. I certainly wouldn't forecast right now based on this schedule.
Am I correct that none of the data presented in Schedule LCS-16, page 1 of 2, have been adjusted to reflect normal weather expectations?
So this information is non-weather normalized.
Now, let's turn to page 2 of 2 in Schedule LCS-16. Now, on page 2 of 2 in Schedule LCS-16 is presented a format somewhat similar to the format on page 1 of 2, except that A, all of the demand data is present as a percentage of the total Maryland demand for the identified demand measure, and those percentages are provided by rate class number and not by year, by year. Is that correct?
Correct.
Okay. Now, focusing on the section of data in the middle of page 2 that is labeled non-coincident area peak demand at primary substation, I'd like you to focus on the first line of data for the residential service class.
Okay.
The only trend I can observe is that the residential class percentage of the Maryland system total appears to be increasing over time. Would you agree with that observation?
So I think this.
I'm just looking at the numbers. Just
Yeah,
look at the
right,
numbers on the
Yeah.
page.
So if you are saying from 9472 in relation to the current, right, and if you're just choosing those points, then you start at 42.72% and you end at 44.90. But obviously there's some movement within those. There's some intermediate steps that, you know, hopefully are interesting to people who like this data. But if your question is from the very beginning to the very end, has there been an increase? Well, it started at 42.72 and the ending number there is 44.9.
Okay. Would you also agree that the amount of change in the residential class percentage of the system total demand varies from year to year, and the magnitude of the year-to-year change appears difficult to predict from one year to the next?
I would make no difficult to predict assumptions. The first thing you said, that it change from case to case, certainly, and you know we could read that. I mean 42.72, 41.94, 44.35, 44.56, 44.9. I mean there are some changes between those numbers. Yes. Now as far as the difficulty of forecasting, again, I'm not a subject matter expert in forecasting.
Now, if we look at the same data in the same table for the MGTLV class, would you agree that we observe noticeable year-to-year fluctuations in the MGTLV percentage?
Now, noticeable is an interesting word. There's a lot of things I notice. I don't know if by noticeable you mean large. Let's just say that when we start on the left in case 9472, that number is different from the next one, and it's different from 9655. Again, we can certainly read them if you like. It starts at 28.79, goes to 28.11, 27.7, 28.82, and 27.23. So those numbers we can say are not the same.
Yeah. Now, the MGT percentage goes from 28.79% from case 9472 to 28.36% for 9602.
Sorry, could you reread that, Ms. Francis?
Right. I'm reading my lines wrong. Let me get it.
Oh, it's no problem. I had to break out the glasses as well.
Okay. Now, the MGT percentage goes from 28.79% from case 9472 to 28.11% for case 9602 to 27.7% for case 9655, and then back to 28.82% for case 9702, and then down again to 27.23 for the current case. Is that correct?
Yes, that's exactly what is shown in the schedule.
Now, based on the data we just reviewed, what do you project for the next observation? In other words, what will be the MGTLV percentage of total non-coincident area peak demand at primary substation in Pepco's next rate case?
Objection. The witness has already indicated that he's not a forecast expert. He's not making any projections here.
Yeah, I think you're right, sustained.
Okay. Let me ask it this way. Would you be able to make a projection based on the numbers that we just read into the record?
Objection again. There's no projecting that this witness has already indicated that
Well,
he's
let
not
me
a
let me
forecast expert.
let me see. Did what you meant to say? Could a person make a projection?
That's exactly what I meant to say.
Okay, then overruled and ask the question that way.
Oh, sure. So, yours truly would not make a projection because that's not my role in life. It's a good role, but to the extent that someone who understands forecasting could use this data in relationship to all of the other things that they would take in consideration, which I am completely unqualified to talk about today. How often do people say that? That person, perhaps, when this data is in front of them, could use this as a part of a suite of information in a forecasting process. But for me personally, looking at this right now,
Established
Yeah.
what your delineation
Okay,
is.
great, thanks.
Mr. Schaefer, you presented a lot of data, but in reality, you haven't actually identified a clear trend. Is that correct?
I don't think that's correct. I mean, we have, and maybe what it is you're asking for would be different. We have these historical measures. We have the year-over-year changes. We look at them every rate case. So, if your question is again from the point of view, did you establish a trend using forecasting models? No, I didn't do that.
We agree. You presented a whole lot of data. We agree on that, and you show the changes from the.
Actually, technically, I don't know if I've said yes. I have.
Okay.
I have produced a whole lot of data. I mean,
Well, we're discussing the data that you've presented, and
Yeah.
there's quite a bit of it. But you haven't, and you showed the changes from year to year, right?
Yes.
But you really haven't shown a specific trend. You said, here are all the changes. Now, somebody would have to do something with that data to say, oh, there's a trend up for this class, there's a trend down for this class. Nobody's saying that. You're not nobody. You're not saying that, correct?
I might be misunderstanding what you're talking about, right? But when I'm producing numbers, and then, like you just said, that I didn't say something was going up or something was going down, we do have the percentage year-over-year change. We are setting the numbers side by side. You can look at it and say, just as we did actually together, this number is lower than this one. This number is higher than this one. It sounds like you want something more specific, though. I mean,
Okay, let's now look at LCS 17. Now, do I understand that pages 1 through 6 of LCS 17 provide measures of coincident peak demand by rate class by month for each month of calendar year 2024 at different levels of aggregation, different voltage levels within Pepco's Maryland system?
And could you repeat the page numbers you mentioned for the coincident peak?
I just said pages 1 through 6.
1 through 6. Yeah, thank you very much. Yes, that is what we're showing here.
Is there anything within the demand data presented in your schedule LCS-17 which you believe depicts a clearly discernible trend?
So this data is providing the monthly data over the same period as used for the annual demand demand data used for the same period, right? So this is not a multi-year analysis, right? This is a month-to-month a month-to-month analysis of one test year. Now, if you're asking, do I have a percentage on here to say, in January, the difference between 63,627 and 47,944, or any two measures for one class that occurred January versus February, do I have and that's X percent higher or lower? No, I don't have that in the schedule.
Okay. Well, my question was really simpler than you made it. I'm just saying, is there anything within this demand data that you believe depicts a clearly discernible trend?
When I understand the word trend, so this is monthly data, right? So there is no way to have a trend between different years on monthly data when this is just 1 year of data. This is 12 months of data, right? So this cannot do the same thing as LCS 16, which has, at least 4 years, multiple rate cases worth of data. That's not what this is. This is monthly demand data.
Well, do you see a trend over the months that you presented?
So generally, you see usage change from seasons. You see different usage from January to the shoulder months. For example, residential. You could look and say, well, the shoulder months, the residential class is using less. In the summer, they sure are using more. And winter, they're using more, but generally less than in the summer. Yeah, that's an annual trend there. Sure.
Okay, now I would like you to reference CNR-1 that accompanies your rebuttal testimony.
Sorry, did you say CNR-1?
Yes.
I'm
sorry.
What is that, actually?
No, what did I say? I said it wrong.
That's okay.
Your rebuttal schedule.
Okay, yeah. Okay, I'm at my rebuttal testimony. Is there I'll let you direct me to the
Wait,
right
one second.
schedule.
Okay, I'd like you to please look at page 25 of 57.
Which schedule are you referring to, Ms. Francis?
LCSR-1.
Yes. And
And there are 57 pages in this schedule, and I'm on page 25.
and just to check, is it concerning to you that this is an FFTY schedule?
Let me just ask my question.
Sure.
Okay. Referencing LCS-1 that accompanies your rebuttal testimony and reference page 25 of 57 of that schedule. Now please look at line 314 on page 25 of 57. You provide revenues retail sales by rate class for each Maryland rate class and in aggregate your overall Maryland jurisdictional distribution service, correct?
Yes, that's correct.
Okay. Yes. Can you identify the revenue items other than distribution base rate revenues that are included in the dollar amount shown on line 314 in Schedule LCSR-1, page 25 of 57?
Sure, 1 second. All right, so the retail sales to which Ms. Francis just made reference include the distribution sales. They include Maryland Environmental Surcharge. They include Montgomery County Surcharge, Universal Surcharge, Delivery Tax, and Gross Receipts. So those items are located in the Other Taxes section. Ms. Francis, you just pointed me out to the retail sales. If you look there, we can look down. I'm on page now 41, Ms. Francis, 41 of 57.
Not there yet. You answered on this page. Let me just check. Your representation of retail sales, it includes, do we agree, purchased energy revenues?
No, I said distribution revenues.
Okay, excuse me.
Counselor, are you on page 25?
Yes, I'm on page 25 of 57.
What line was that? I'm sorry.
It wasn't a specific line. I'm just asking him a question.
Okay.
Okay, so distribution revenues, does it include purchase capacity revenues?
This includes, I'll give it to you all right here, right? The retail sales, we've got distribution revenues, we've got the Maryland Environmental Surcharge, the Montgomery County Surcharge, Universal Surcharge, Delivery Tax, Gross Receipts Tax.
Okay.
Now you can see those items, they're in the other tax section. They're on page 40 and 41, but if you just want to get the entire company total Maryland distribution, it's on page 40.
Okay.
Yeah, it's the heading there is other taxes, so you can find those items in the other tax section. Sure.
Does page 25, does that include BSA revenues?
Yes.
Does it include sales tax revenues?
It includes delivery tax and gross receipts tax.
Okay. And where would purchased energy revenues be accounted for?
Purchased energy revenues.
Mm-hmm.
This is the distribution class cost of service, so our
Okay.
purchased energy.
Okay. Now, let's look once again at your executive summary of your rebuttal testimony.
Okay, I have it. Thanks.
1 second. Okay. Now, does the executive summary of your rebuttal testimony suggest that the company's CCOSS is not the place for examination of either 1, rate-making adjustments by FERC account, or 2, verification that the costs reflected in the company's proposed rate-making adjustments are associated appropriately and appropriately allocated or assigned to FERC accounts for the purposes of identifying cost of service responsibility by rate class?
So, class cost of service, right? I am taking in the revenue requirements that are provided to me upstream, right? They're calculated upstream. Now, in the class cost of service, the class cost of service is a wonderful place to look at the allocation factors assigned to these costs, to allocate them off to the classes. It's a wonderful place to look at the construction of those allocation factors, so we can look at the cost causality that they represent. You can look at the numbers, the totals by rate-making adjustment. You can look at the totals by FERC account, all of these things that have come in to my studies that have been prepared by Witness Nelson. So all of those things are reviewable, and that is the domain of the class cost of service. We're talking about cost allocation. We're talking about studies to develop allocation factors. All of that is clearly reviewable. And so when you look at a rate-making adjustment factor like you were making reference to, you can look at that and see exactly which allocation factor is being applied to that amount. And then you can look at the you can judge if it has been allocated correctly. Now, if what you're asking, because I think there was a shade of it in your question, you can correct me if I'm wrong, right? But if you're asking if, do I, Mr. Schaefer, do I make sure that, do I go upstream of me and do I say, well, the revenue requirements told me that I should include this rate making adjustment in this account. That's simply not my job because Mr. Nelson is a lot smarter than I am. So I take his numbers and then I put them through the class cost of service study as he prepares for me.
Okay. Let me just break down my question because I think it was probably too general.
Okay.
Does the executive summary in your rebuttal suggest that the class cost of service study is not the place for any kind of an examination of rate-making adjustments by FERC account?
So can you point to that language?
Well, I'm reading from 1, 2, 3, 4, from the fourth bullet down.
You don't mind if I read that, do you?
No.
The Commission should reject AOBA witness Bruce Oliver's claim that he is unable to assess the assignment of rate-making adjustments in the class cost of service study. The class cost of service study clearly shows into which FERC accounts the rate-making adjustments are included and clearly shows the allocation factors applied to the FERC accounts. The class cost of service study is not the place to include detailed accounting information that witness B. Oliver would require if he desired to conduct an audit of the account.
Mm-hmm.
Now, if he wants to audit the allocation factors that I've applied to these things, the class cost of service is a wonderful place to do that.
Mr. Schaefer, that wasn't really the question. All I'm saying is, are you arguing that your rate-making adjustments by FERC account is the place not to examine that is in a class cost of service study?
Objection. Mr. Schaefer has provided read into the record exactly what that bullet says. I don't think he's...
Well, I'm going to overrule you because I think that question is different, is manifestly different, I think.
Yes.
I'll allow it. Go ahead.
And by the way, I didn't quite get all that question. Would you mind repeating it, Ms. Francis?
Does your executive summary in your rebuttal testimony, does it suggest, I'm not reading words, I'm
No, that's fine.
suggesting,
I just want to hear it.
that the class cost of service study is not the place to examine rate-making adjustments by FERC account?
By examine, you mean to examine the contents of what is included in a rate-making adjustment. Is that correct?
Correct.
Exactly. Class cost of service is not the place to dissect the amounts coming in from a rate-making adjustment. Class cost of service is getting those costs allocated correctly based on cost causation to the classes. I absolutely don't think that there's a good reason for this, by the way. You don't want to do accounting auditing in the class cost of service study. Interveners don't look for that information in a class cost of service study. I would confuse them quite a lot if I included all that accounting data in a class cost of service study and just expected people to go in and audit rate-making adjustments or any FERC account in the class cost of service study. I don't know of any class cost of service study in the country that does that.
Is your executive summary also suggesting that verification of any of the costs in the rate-making adjustments, that the class cost of service study is not the place to look at whether those adjustments are assigned or allocated to FERC accounts appropriately?
I'm objecting, asked and answered. I think Mr. Schaefer's last answer went to
I'm just asking.
Well, I didn't hear him mention FERC accounts in his answer, so I'll allow it overruled.
Okay. So if I didn't hear all that question, let me know. But exactly, if what you just said was, Mr. Schaefer, in the class cost of service study, are you able to audit what amounts?
No, that's not my question.
Okay, can you
What
repeat
I
it?
was asking was, I'm just trying to understand what you said in your executive summary.
I did
That's
your
all
question.
I'm trying to do.
Yeah, that's great.
So are you saying in your executive summary that the class cost of service study is not the appropriate place to verify whether the rate-making adjustments are associated or allocated appropriately to different FERC accounts for the purposes of identifying cost of service responsibilities by class?
Right. So, okay.
Is that what you're saying in your executive summary?
As I said before, I am not the person who parks expenses into the FERC account, right?
You know,
So,
No,
let me advise you. If it's possible for you to answer with a yes or no and then explain, I think the commission would prefer that.
I will attempt to. So the thing is, she's using a bit of language, like she's using allocation, right? Allocation is a very important word for us, right? And it has a specific context in class cost of service. And so to keep this very, very clear, I'm going to say my executive summary says, indeed, that it's not my place to put amounts into a FERC account. I get that from upstream of me. So I hope that's clear. I do not do that. The class cost of service does not, there's no moment in my analysis where I say, hey, I wonder if I should put this in 364 or 365. That never happens for me.
I'm not asking. My question is not what you're doing, what you're capable of doing. I'm focused on what you're saying in your executive summary. That's all I'm focused on.
Can
Just
we-
because you reread to yourself the fourth bullet on your executive summary.
I'm really trying to answer your question here, right? I really am. Like, it sounds like you're asking me two or three different things. Like, I've clearly said that it is not my job to put amounts in FERC accounts. It's not my job to decide into what FERC account is directed an RMA amount. It really is. So I think that's clear, right? Class cost of service, that's not the domain that I work in. I get that information from Mr. Nelson. And so, you know, my testimony, there's nothing in any part of my testimony, that hinted that I make such decisions.
Your Honor, I'll move on. Am I correct that elements of the cost incurred for a given ITN may include costs that may be properly assigned to two or more FERC accounts, where the FERC accounts to which those costs are assigned may have different rate class allocation factors applied?
So for the first part, the ITN being divided up into different FERC accounts, that's my understanding.
Yes.
And so you're saying that could they be in two different accounts that use different allocation factors or slightly different allocation factors? Yes.
Okay. Do you believe, Mr. Schaefer, that cost allocation detail contained within a large electronic-only spreadsheet file that can't be readily reviewed by the public or the commission as part of cross-examination evidence is consistent with a transparent presentation of class cost of service allocations?
I'm actually really surprised you said that, and there's a reason, right? So the company developed this model back in, it was before the case 1150. The company was using a well-known model by Management Applications Consulting, the firm. Now, DC said, hey, wouldn't it be great if we had like a model that allowed interveners to make their own changes to the model so they could really understand it and get in there? So Pepco took a lot of effort, made a lot of effort to develop a model that is customizable. Like interveners can change amounts, they can erase amounts, they can change allocation factors, they can do pretty much what they want, and have a confidence that their results are getting through there. So it's actually, I think it's probably the most user-friendly model I've seen. Now I would give an example of that. Back in 9655, the first time we filed it with Maryland. What did staff do? They went in and they said, "Hey, I want to change all the demand allocators." Now that change affects it's like at least 60% of the cost, right? The demand allocators are really prominent. So they went in, and this was I think it was a junior staff. I don't want to say junior. I don't know what her title was. It was someone who was here for only 2 years, did a fantastic job, went in there, modified the study, reran the results. made an argument. At the time, I didn't like the argument, but she kind of won me over, right, in the end. And so, you know, from class cost of service models, gosh, I just can't agree with that description at all.
So I guess your answer is yes, it's transparent.
Absolutely, yeah. I mean, and the result and the proof is that we had someone else do what they wanted to it.
No. It would be nice if you used a yes or a no
Oh,
somewhere
sorry.
in your answers.
Yeah, sorry. Yeah.
But-
Yes, it is definitely transparent.
I
Yes.
accept your answer.
Thank
But what my focus of the question was an electronic-only spreadsheet file that we can't be producing where the cost allocation detail of how it was allocated is buried in an electronic-only file that can't be seen by the public.
So-
That was the focus of my question.
So no, because buried is just not consistent with the description I just gave. We made a lot of effort to make sure nothing is buried. There's nothing buried. Buried is a word that people use all the time. You know, anytime an exhibit is large, someone says the word bury. I mean, it's too easy.
Your Honor, that's all the questions I have. I'm going to move the admission of my exhibit. I just forgot the exhibit number. Exhibit, what was it? 12.
Without objection, so entered. So next would be, if I use my order, MEA, but I don't see anybody from MEA here.
No, they're here.
Oh, there? No questions? Okay, then we would go to OPC, but let me ask People's Council, how much do you have? Because I'm considering having a break for lunch.
I don't have more than 5 or 10 minutes.
Okay, go for it.
All right. Thank you. Good afternoon, Mr. Schaefer.
Good afternoon.
And for the record, I'm Pauline Races, appearing on behalf of the Office of People's Counsel. My name is spelled Pauline. Last name is Raisis. I have a few questions about Pepco's proposal regarding seasonality, which you mentioned earlier. So I'm going to ask you a few questions about that.
Okay.
So currently, Pepco's rates are seasonally differentiated. Is that correct?
For a couple of the classes.
For a couple of classes. All right. So that means for those classes, the electric distribution rates are slightly higher in the summer than in the winter. Is that right?
Yes, correct.
Okay.
Excuse me. nodding.
And then on page 27 of your direct testimony, you mentioned case number 9702, which was Pepco's previous rate case, where witness Blazunas made a proposal with respect to seasonally differentiated rates. Is it correct that the company proposed to eliminate seasonally differentiated rates for certain rate classes in its previous rate case?
Yes.
Okay. And is it correct that the commission did not approve the company's proposal to eliminate seasonality in that case?
I believe they just asked for more information. So it was not enacted in that case. So I think my answer is yes.
Okay.
It's true that. So they asked for some more information.
Okay, yeah. So you just mentioned that they asked for a bit more information. In that case, did the commission ask Pepco to provide a cost analysis and customer impact study of
Yes.
the gradual elimination of seasonal?
Yes.
Okay, thank you. And in this case, the company is again proposing to begin to gradually eliminate seasonally differentiated rates for certain rate classes. Is that right?
Correct.
Great. And that seasonal cost study that was ordered by the commission in case 9702, that's attached to your testimony, your direct testimony as Schedule LCS-18?
Yes, it is.
Okay. And is it correct that the purpose of the seasonality study ordered by the commission in case number 9702 was to determine if there is a cost basis to justify the retention or the elimination of seasonal rate differentiation for certain customer classes?
Yes.
Okay, thank you. So would you agree that the commission ordered this study so that it could inform rate design in this case?
No. A cost study? I think they ordered a cost study to receive a cost study. Now, I don't know beyond that. Like, I only know the language of what was in the order. I don't know what they intended to do with it after that. I mean, it was a cost study done in the certainly in the context of seasonality. But what was going to happen with it after that, I don't know what their intention was.
All right. Okay. So in this case, Pepco did not translate the results of the seasonality study into rates. Is that
No,
right?
no, we did not.
Okay. Could the results of the seasonality study that you prepared have been translated into rates?
So I'm not a rate design witness. I'm just the humble class cost of service witness, shall I say? And so my part was limited to the production of the cost study.
Okay. So in your professional, you don't know whether it could have been translated into rates.
Oh, I think that's beyond what I was intended to do, right? I did not, think about after I got the results of that study, it wasn't a part of my study to say, okay, now that I have the results, I'm going to interpret that, I'm going to, translate that into rates now. That wasn't a part of what I did.
Okay. Thank you. I guess, okay, just a couple more questions. Do you think that translating the results of the seasonality study into rates would have helped the commission evaluate whether Pepco's proposal to begin gradually eliminating seasonally differentiated rates was justified on a cost basis?
So I think the best thing for that is the cost study itself. I mean, as I mentioned before, it's interesting the words that were applied to my testimony, that it somehow needed to be interpreted or translated. I mean, we're in lofty territory there. So no, I produced a cost study. The interpretation and translation, I have a hard time understanding what interpretation means in this context, So no, I didn't think about that. I produced a cost study that I thought showed cost differences under a certain assumption, which, as you know, I also don't necessarily endorse because these types of cost studies are not done anywhere else and generally do not reflect our belief that the distribution system, once that embedded cost goes into place, the distribution system doesn't get cheaper in April, for example. I mean, that cost is out there. And so, whether or not the investment of that was driven by summer peak or for other utilities, winter peak, once that is in the ground, it doesn't shrink somehow, that cost during a shoulder month.
Right. Understood. All right, just one more. And so, are you aware of OPC witness Whitehead's recommendation that Pepco should no longer classify the month of October as a summer month and instead should reclassify October as a winter month?
Yes, I'm aware of that.
All right. And is it correct that the company does not oppose witness Whitehead's recommendation to reclassify October as a winter month?
That's correct.
All right. Thank you. I have no further questions.
Thank you very much.
How much does staff have? One question.
Yes, sir.
Okay, so we'll do that question, and then we will break, and then the commissioners will ask, will follow up with questions. Go ahead.
Hello, Mr. Schaefer. It's nice to see you.
Hello, nice to see you too.
Thank you.
Zero.
And forgive me, Ms. Beckham, if this has been asked and talked about or corrected. Did any other party in this case dispute the new administrative SOS charge? Did any? Are you aware?
No.
Okay.
No.
That's all. Thanks.
Okay, thank you.
Well,
I was going to say I also have no live or no redirect.
oh, of course, yes. Go ahead.
I have none. So
You have none. Okay. And apparently none of the commissioners have a question, so thank you very much.
Thank you.
And we will break for lunch and come back at 5 minutes to 2 is what we'll do. I understand that People's Council has a preliminary item they'd like to present us with.
Yes, Your Honor. Thank you. We have three preliminary matters. The first preliminary matter pertains to Mr. Madsen's operating revenue adjustment.
Okay.
He has informed us that he plans to withdraw this adjustment, the one he initially recommended in his direct testimony. We've notified the company of this, and we're in the process of preparing clean and red line versions of his direct and surrebuttal testimonies, as well as revised schedules to reflect this withdrawal. And once he takes the witness stand virtually, he will present and discuss this change before we move for the admission of his testimonies and schedules.
Okay.
The second concerns the fully forecasted test year specific testimony. Only two OPC witnesses have testimony specific to the FFTY proposal. That would be Mr. Madsen and Mr. Fitzhenry. They have both prepared revisions to their filed testimonies that would remove the discussion of FFTY specific issues that don't bear on the TTYCF proposal.
Okay.
And we'll be filing those revised versions as well.
Terrific.
And the last item concerns the OPC witness availability. I think we're approaching the end of the company's case here. Mr. Garrett, our cost of capital witness, has informed us that he has a appearance scheduled in Arizona next Tuesday.
Okay.
And he would need to take the stand tomorrow in person. And we'd request that to be, if he be granted that date certain.
Okay. Yeah, I think that'll probably be fine. Yeah.
Okay. And just an update on our other witnesses. Ms. Whitehead is in Baltimore, and she is available to testify at any point today or tomorrow morning. Mr. Fitzhenry will be available to testify tomorrow, but if it looks like he's being pushed to Monday, we'll need to notify him immediately so he can address his flight. And Mr. Madsen is available to testify virtually anytime tomorrow or on Monday.
Okay. Thank you very much. Your witness.
Good afternoon, Chairman and Commissioners. Taylor Beckham here on behalf of Pepco. Mr. Blazunas, please state and spell your name for the record if you are not already sworn in.
I do.
Please state and spell your name for the record.
Peter Blazunas, PeterBlazunas.
Do you have in front of you a document entitled The Direct Testimony of Peter R. Blazunas?
I do.
Does that document consist of 68 pages?
Yes.
Does it have 12 schedules?
Yes.
Was that testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your testimony at this time?
I have 4 small corrections.
Please go ahead when you're ready.
The first one is page 19, line 7. It says 702. That should be 9702. The second one is on page 33 in footnote 25. In the last sentence of the quote, it says the commission may revisit. I'm just correcting the spelling of revisit to revisit. The third one is on page 37, line 11. It says schedule RTM class. It should say schedule R class. And the final one, on line 25 of page 39, it says June 2024. It should say June 2025.
All right, great. So if I asked you the same questions in that testimony today under oath, would your answers be the same or similar?
Yes.
Your Honor, I'd like to get the direct testimony of Peter R. Blazunas marked as Pepco Exhibit 35, please.
So marked.
Mr. Blazunas, do you have a copy of your, do you have in front of you a document entitled Supplemental Direct Testimony of Peter Blazunas?
I do.
Does that consist of 6 pages and 10 schedules?
Yes.
Was that testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same questions today under oath, would your answers be the same or similar?
They would.
Mr. Chairman, I ask that the supplemental direct testimony of Peter R. Blazunas be marked as Pepco Exhibit 36.
So marked.
Mr. Blazunas, do you have in front of you a copy of a document entitled Second Supplemental Direct Testimony?
I do.
Does it consist of 3 pages and 1 schedule?
Yes.
Was that testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to it at this time?
I do not.
If I asked you those same questions today, would your answers be the same or substantially similar?
Yes.
Mr. Chairman, I ask that the second supplemental direct testimony of Peter Blazunas be marked as Pepco Exhibit 37.
So marked.
And then lastly, Mr. Blazunas, do you have a document in front of you entitled The Rebuttal Testimony of Peter R. Blazunas?
I do.
Does that document consist of 26 pages and 10 schedules?
Yes.
Was that testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you those same questions today or today under oath, would your answers be the same or substantially similar?
They would.
Mr. Chairman, I ask that the rebuttal testimony of Peter R. Blazunas be marked as Pepco Exhibit 38.
So marked.
And then I ask that Pepco Exhibits 35, 36, 37, and 38 be admitted into evidence.
Mr. Chairman,
Yes.
does that be heard? Pardon me. Could we request that council provide the ML, the mail log numbers for each of those items and the date that they were filed? Thank you.
For the direct testimony, that was filed with the company's application on October 14th, and I will have to get back to you with that mail log. The mail log for the, you know what, can I get back to?
Yes,
record?
just as long as we read it out into the record.
Okay.
Ms. Beckham, I've got the first one for you, for your original case. It's 3275.
Okay. I will find the one for the April 24th filing and then the second supplemental direct. And I do just want to make sure that I have the right, I think it's Pepco Exhibits 34, 35, 36, and 37. No?
35 through 38.
Yeah.
Okay. Can I move those into the record?
Without objection, so admitted.
Okay. And Mr. Blazunas, you heard here today some commissioners asking about what the purpose of your various testimonies are. Could you provide just a quick outline of what we're looking at today?
Yeah, certainly. So my direct testimony focused on a FFTY and a TTYCF revenue allocation, rate design, bill impact analysis, and customer impact studies. And they're separate sections within the testimony. My supplemental direct testimony provided the update to the traditional test year compliance filing and is focused on that filing, the update to actuals. My rebuttal testimony focused on both the FFTY and the TTYCF and provided updates for both and rebuttal for both. And my surrebuttal testimony, I focused on surrebuttal items for both the FFTY and TTYCF. I don't believe I filed any schedules with my surrebuttal. And then finally, my second supplemental direct focused on the TTYCF solely.
And then, thank you, Mr. Bazunas, for that, because I don't think that I marked your sur rebuttal. Do you have in front of you your sur rebuttal testimony?
I do.
Does that document consist of 4 pages or 3 pages? 4 pages?
Yes.
And it has no schedules?
No schedules.
Was that testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you those same questions today under oath, would your answers be the same or substantially similar?
They would.
Mr. Chairman, I would like to mark Peter Blazunas' sur rebuttal testimony as Pepco Exhibit 39 and move that into evidence.
So marked and without objection, so admitted. Do you need, the staff need the mail log number for that?
Thank you. We do. Thank you.
I will get that to you all by the end of Mr. Blazunas' testimony.
Terrific.
Okay, we have brief live rejoinder. Mr. Blazunas, OPC witness Whited, stated in her on page 20 to 21 of her sur rebuttal that in this case, if the commission elects to reduce or eliminate seasonal differentiation in standard residential rates, it should not rely on the working group process. Instead, the commission should direct Pepco to file one or more opt-in rate designs that are cost-reflective and support beneficial electrification, including heat pump adoption by a date certain. Do you have a response to OPC witness Whitehead's recommendation?
I do. Pepco is not the only utility in the state. To the extent rate design is being used to advance statewide policy goals, the working group process or a statewide process is likely the best way to do that. I would also note that in her sur rebuttal in the next Q&A, she talks about the Commission's notice for comments from parties regarding standardization of evaluation of time of use rates for electric distribution utilities. So in my mind, to the extent there's a benefit from a common approach for evaluating these kinds of programs, there's probably a benefit from a common approach to designing these programs.
And then also in Ms. Whitehead's sur rebuttal, as well as what's been discussed with previous witnesses, Mr. Whitehead states, or Ms. Whitehead states that October reflects a more clear-cut case for inclusion in the winter season rather than the summer season. Do you have a response to Ms. Whitehead's indication that October has a more clear-cut case for inclusion in the winter season?
Although the company does not oppose the recommendation regarding the movement of October to a winter month, I don't think the case is as clear-cut as Ms. Whitehead states. So the company is proposing the gradual elimination of seasonally differentiated rates. So we're talking about at some point in the future, there is not going to be a distinction between summer and winter. With that in mind, if, as company witness Vosvik mentioned, we are required to do this. We could be incurring some amount of time and expense for something that would ultimately no longer matter because that differentiation would have been removed. I would also note that with respect to compliance in this proceeding, if we do the movement, I think it's been made clear that we can't enact it immediately. So I think there would need to be 2 sets of compliance rate designs. One initially where October is still treated as a summer month, and another where October is treated as a winter month.
And then last question, Mr. Bruce Oliver, on page 46 of his sur rebuttal testimony, states that on pages 19 of 25 he's referring to your scheduled PRB 7, pages 19 of 25 through 24, that those computations give unwarranted credibility to the proxy measures of cost responsibilities and revenue requirements produced by monthly BSA rate adjustments without examining how well its BSA adjustments actually track changes in class cost responsibilities. Do you have a response to Mr. Oliver's recommendation or proposal here?
Yes, so Mr. Oliver is conflating the purposes of the bill stabilization adjustment and the effective rate adjustment. So the bill stabilization adjustment is the company's revenue decoupling mechanism. In a test year rate proceeding, it serves as the basis for the company's distribution revenues, okay, based on authorized amounts that were set in the company's most recently approved rate case. The effective rate adjustment just reflects the fact that in rate design, when we're designing rates, if you take, the billing determinants, customer count, kilowatt hours, demand, multiply them by the rates in the tariff, and you compare that to what you get if you just do a customer count multiplied by a revenue target, there's a difference, okay? And usually it's relatively small, and so the effective rate adjustment is just meant to reconcile that difference, and it's done in every rate proceeding, rate design in which a decoupling mechanism is involved. So it's very common. I would also note that Mr. Oliver talks about tracking cost responsibilities. In the context of the BSA is the revenue decoupling mechanism. It's not meant to track cost responsibilities. Cost responsibilities are considered at the time of when the rates are established. Okay, so Mr. Schaefer puts together a class cost of service. Included in that class cost of service are revenues and costs. Included in the revenues are the company's distribution revenues, which are determined based on the bill stabilization adjustment. So that is when the issue of cost responsibility is considered for purposes of the BSA.
All right, great. Thank you, Mr. Blazunas. With that, the witness is available for cross-examination.
Okay,
No questions, Your Honor.
no questions. MEA,
No questions, Your Honor.
okay. People's Counsel,
Briefly, Your Honor. Good afternoon, Mr. Blazunas.
Good afternoon.
Were you in the room when I asked witness Schaefer about the seasonality study that the company prepared?
I was.
Do you agree that the purpose of the seasonality study ordered by the Commission in case number 9702 was to determine if there was a cost basis to justify the retention or elimination of seasonal differentiation for certain customer classes?
Yes, I think it was meant to underlie the company's or support the company's proposal in this proceeding.
All right. So I asked the following question to Mr. Schaefer, and he explained that it was beyond the scope of his expertise. So I wanted to ask you, could the results of the seasonality study be translated into rates?
No. So as Mr. Schaefer discussed, the cost analysis does not support the idea that costs are differentiated by season. Okay, so with that in mind, it would be inappropriate to use that cost study to establish a seasonal rate design.
Okay. Is there a different type of study that could have been prepared that would have been able to translate those seasonal cost relationships into rates?
I don't. I can tell you why we did the study that we did. So the study that Mr. Schaefer performed is looking and utilizing the company's class cost of service study, which reflects the fact that we design rates on an embedded cost basis.
Understood. One moment. So would conducting a study that looks at the marginal cost in each season have been useful for determining whether rates should be seasonally differentiated?
Well, there are marginal cost of service studies that are done. What I would say about marginal cost is it's a consideration in rate design, especially when it comes to electric distribution rate making. There are other things we're considering. We're considering, rate predictability, rate stability, revenue stability for the company, gradualism. So there are other considerations out there. Certainly marginal cost can be considered. I would say marginal cost is never actually used. Like there's going back to Economics 101, there's a reason why natural monopolies don't price at marginal cost. So it can be used to inform rate design. And I'd also say there's a reason why the flat kilowatt hour rate for an annual period is common throughout the industry. The idea of marginal cost has been around a long time, yet the prevailing rate design has been a flat kilowatt hour charge.
All right. Just one final question. So is it the company's position that the seasonality study that it prepared is or is not relevant to inform rate design in this case?
It informed the company's determination that costs are not seasonally differentiated, which informed our proposal to begin the process of gradually removing seasonal differentiation in those rates.
Okay. And I'm sorry. Actually, just one more. So then how does the seasonality study that the company prepared help inform the commission's decision regarding whether seasonality should be eliminated?
The cost study shows that the cost of the distribution system does not vary by season, does not vary by month. So the fact that there are these large differentials between summer and winter rates is unsupported, which supports the movement away from these differentials towards a uniform rate across the annual period.
I have no further questions.
Staff,
No questions.
redirect?
No redirect.
Wow, that was fast. Land speed record. Thank you very much, Mr. Blazin.
Real quick before.
Oh. I always manage to screw something up. First Hoover, then McLean, then, yeah.
No questions.
All right, I'll ask you one, sir. Good afternoon.
Good afternoon.
You talked about witness Bosvic's testimony and what's going to be involved potentially if October is moved from the summer to the winter. Yeah. And I asked him, do you have a ballpark guesstimate as to what the cost that will be incurred? And I think he said it was a 5-month process approximately.
I do not, but I think Miss O'Donnell might have that
Okay. All right.
information.
Thank you, sir.
Linton?
Thank you, Mr. Chairman. Good afternoon. Just maybe 2 questions. I guess the first for your counsel, the second supplemental direct testimony, which exhibit number is that?
That was
Yeah, I missed the number. It was
30. The second supplemental direct is 37.
37. Okay, thank you.
Oh, it should be 36.
Excuse me, Mr. Chairman. I think perhaps the company may have skipped 34.
Okay.
You know,
So it should be this.
she could
All
fill
right,
it in
so
later.
It'll
I
be
mean,
30. It's 36.
36. Okay.
Well, then we'd have to renumber everything.
Yeah, let's leave the numberings the way that they were, and, you know, there's no crime to having one gap either,
Yeah.
so.
Or she could take a placeholder or
Yeah,
something.
you could, that's right.
Okay. So to answer your question, Commissioner Linton, the second supplemental direct is Pepco Exhibit 37.
37. Thank you. All right. And I just wanted to make sure in this second supplemental direct on page 2, it says Q4. There you note that the tariff, the proposed tariffs that you've included in your schedule relies on the revenue requirement and class cost of service study sponsored by witnesses Nelson and Schaefer. That testimony remains yours still testimony today.
Correct.
That's all I had. Thank you.
You're welcome.
Thank you, Mr. Chairman.
And no questions from Suchman or me now. Thank you very much.
Real quick, just preliminarily
ma-
to answer
The mail log?
the mail log
Yeah.
numbers. So I won't take us down the path of the exhibit numbers again.
Okay.
So, but what I will do is the direct testimony that we entered is the clean version that was filed on 4/24/26, and that is mail log number 329413. The supplemental direct is the version that was filed on December 18th, 2026. That's mail log number 325456. The rebuttal that was entered is the clean version that was filed on 4/24/26. So that's the same 329413. The second supplemental direct, it was filed on April 17th. That is mail log number 329130. And then the surrebuttal, sorry, I tried to do this in order of time, but I'm going one day before. The surrebuttal was filed on April 16th. Well, I'm sorry, the clean version was filed 4/24/26, so it's still that 329413 number.
Ms. Herman, is that everything?
It's great. Thank you.
Okay, terrific. Thank you. Your last witness.
Our final witness is Ms. O'Donnell. The company calls company witness O'Donnell to the stand.
No pressure, but you're supposed to answer all the questions.
I'll try. Aren't you excited? I've been waiting for it the whole time.
Yes.
I can see the excitement.
Absolutely.
It was really hard for us to tamper.
I could see.
Yeah.
Calm down.
All right, if you'd like to swear her in.
I do.
Ms. O'Donnell, please state your name and title for the record, and spell your name, please.
Sure. It's Elizabeth Morgan Downs O'Donnell. I'm sorry in advance. I'm the Chief Financial Officer and Treasurer for Pepco Holdings. I can spell any component of that you'd like. Elizabeth is Elizabeth. Morgan is Morgan. Downs is Downs. And O'Donnell is O'Donnell.
Now, Ms. O'Donnell, do you have before you the public version of a document entitled Direct Testimony of Elizabeth M.D. O'Donnell?
I do.
Does that document consist of 69 pages and 3 schedules, one of which is public and the other 2 that are confidential?
Yes,
Was that testimony prepared by you or under your supervision and direction?
it was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I ask you the same questions today under oath, would your answers be the same?
Yes, they would.
Your Honor, I would like to have the public version of the direct testimony of Elizabeth M.D. O'Donnell marked for identification as Pepco Exhibit Number 40.
So marked.
Ms. O'Donnell, do you have before you the confidential version of a document entitled Direct Testimony of Elizabeth M.D. O'Donnell?
Yes,
Does that document consist of 69 pages and 3 schedules, one of which is public and the other 2 that are confidential?
yes,
Was this testimony prepared by you or under your supervision and direction?
yes.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I ask you the same questions today under oath, would your answers be the same?
Yes,
Your Honors, I would like to have the confidential version of the direct testimony of Elizabeth M.D. O'Donnell marked for identification as Pepco Exhibit Number 40C.
So marked.
Ms. O'Donnell, do you have before you the public version of a document entitled Rebuttal Testimony of Elizabeth M.D. O'Donnell?
yes,
Does that document consist of 59 pages and 3 schedules, one of which is public and the other 2 that are confidential?
yes.
Was this testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I ask you the same questions today under oath, would your answers be the same?
Yes,
Your Honors, I would like to have the public version of the rebuttal testimony of Elizabeth M.D. O'Donnell marked for identification as Pepco Exhibit 41.
So marked.
Ms. O'Donnell, do you have before you the confidential version of a document entitled Rebuttal Testimony of Elizabeth M.D. O'Donnell?
yes,
Does that document consist of 59 pages and 3 schedules, one of which is public and the other 2 are confidential?
Yes.
Was this testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same questions today under oath, would your answers be the same?
Yes.
Your Honors, I would like to have the confidential version of the rebuttal testimony of Elizabeth M.D. O'Donnell marked for identification as Pepco Exhibit Number 40C.
So marked.
And finally, Ms. O'Donnell, do you have before you a document entitled Supplemental Rebuttal Testimony of Elizabeth M.D. O'Donnell?
Yes.
Does that document consist of 2 pages and 1 schedule?
Yes.
Was this testimony prepared by you or under your supervision and direction?
Yes, it was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same questions today under oath, would your answers be the same?
Yes.
Your Honors, I would like to have the supplemental rebuttal testimony of Elizabeth M.D. O'Donnell marked for identification as Pepco Exhibit Number 42.
So marked.
And I would like to move the admission of Exhibits 40, 40C, 41, 41C, and 42 into evidence.
Without objection, so admitted.
Now I would like to engage Ms. O'Donnell in some brief rejoinder. Ms. O'Donnell, are you familiar with OPC witness Garrett's position related to capital structure in his surrebuttal on page 17, line 16, where he notes that Pepco's capital structure is not fair and reasonable?
Yes, Mr. Garrett recommends an equity ratio of 43%. He bases that on a proxy group and not the company's actual capital structure when compared to the equity ratio proposed in the traditional test year compliance filing, which is 51.53%, which is based on actuals with an adjustment for Empower Maryland debt. There is a dark contrast between the two numbers.
And what are your thoughts with regard to his proposal?
Well, it's not, there's a longstanding precedent with the commission to approve actual capital structure. In fact, in the last commission's order in 9702, they made the note of saying that they are approving our capital structure based on that longstanding practice of using the company's actual capital structure. In addition, another important note is that when Exelon and PHI merged, there were multiple ring fencing conditions and merger conditions that required the company to maintain an actual equity ratio higher than 48%. So 48% was the floor. In fact, we are required to make a filing with the commission after any dividend payment to illustrate that we have not fallen below that floor. What's important about that is that, in just some context as to why that merger commitment was there, is that there were concerns by some of the parties during the merger proceedings that Exelon would take earnings from the utility, and this was a measure to prevent them from doing that by holding them to a certain level of equity ratio. And we've been doing that for over a decade and have been consistent in that practice. And so just in conclusion, Mr. Garrett's capital structure, it creates a significant difference between our actual capital structure and what he's proposing. And it doesn't align with how we have funded the long-term assets that we have in place, which is usually a balance of debt and equity, and that would create a large difference and would essentially infer we had more debt on the books than we actually do.
Thank you, Ms. O'Donnell. Now I'd like to ask you about a couple of questions that came from the commissioners to prior company witnesses that were referred to you. First, were you in the room for the discussion between witness Lemming and Chair Barve with respect to how Pepco's pension is funded?
Yes.
Can you provide some additional information to address the chairman's questions with respect to the company's pension funding practices?
Sure. So you asked directly about whether the pension was fully funded, but before I get into that, I want to talk a little bit about how sort of a pension works. And so there's a pension contribution that the company makes on behalf of future obligations that they will pay out to retirees as a part of the pension program. So you've got an asset that sits on the books that essentially are the investments for those contributions that are managed by an internal team at Exelon that are investment professionals, and they manage those assets utilizing investments in the market. On the other side of the balance sheet, there is a liability, and that liability represents the anticipated obligation and payments that we will make to the retirees upon their retirement. Towers Watson does a study for us every year. It's an actuarial study, and so what they do is they look at the number of employees, when they would retire, how long people are living, and they'll build out a set of cash flows is what they expect to pay those retirees over a period of time, and then they'll discount that back. So they'll do a discounted cash flow, and they'll use a discount rate to get to sort of what that liability is. And so when you take the assets that are sitting on the books, the pension assets, net it with the liability, that tells you how much you're funded. So the difference is obviously how much you're funded. Pepco uses several Exelon pensions, including the original PHI pension. And so if we're looking at the full Exelon pension benefits, we're about 83% as of the end of last year. We are also obligated to maintain a certain level for ERISA, which is a part of legislation, which I think is where you were going, that we're obligated to fund it to a certain level. And so what we try to do is, while we're not at 100%, we do try to make stable contributions over a period of time to ensure that we can get to that 100% factor, 100% funded basis. But there are other external factors that impact that. Obviously, the assets are subject to market fluctuations, and then the actuarial studies can change, and then the discount rate can make a difference. And so you're dealing with several external factors, but we do a pretty good job of managing it. Hence, we've got a strong funded basis of about 83%, but that can move every year when we do a study.
And were you in the room for the discussion between Commissioner Linton and company witness Bosvik about customers experiencing high bills that testified at the public hearing?
Yes.
Did you watch the public hearings that were held on April 14th and April 17th, 2026?
I did watch them the next day. I didn't actually watch them live.
And what was your reaction to the testimonials that you heard from the customers?
I think it was the same reaction that Commissioner Linton had, and there's significant issues, and our residential customers, along with our other customers that are business owners, are experiencing high energy costs. And they've become sophisticated in that manner. In fact, they noted supply costs. I don't know if over the last 20 years when I've been working in this industry, that I've also seen that level of sophistication in terms of, and I think that's probably a function of the fact that they have high bills and they've been forced to learn about them. And so it was very clear and impactful that they are struggling, and it is an issue that they are burdened with. In addition, I also heard stakeholders talk about how important reliability is as well. And so I think my takeaway is that we need to make sure that we keep affordability in front of mind, because it's in the front of mind of our customers. But in addition, we need to balance that with the ability to provide safe and reliable service.
And what actions did the company take to investigate the specific concerns raised by the customers regarding high bills?
Sure. We did look into the various components of the different bills for the customers. And then we did outreach, in particular, to those customers to talk to them about their bills. In one instance, there was significant high usage, and so we sent an energy engineer out to the premise to check that the meter was operating properly, and also to look at anything that could be potentially causing it. And so we've been working with that customer to try to figure out a way for them to make sure that their equipment is working properly on the other side of the meter. And we've also reached out to the other customers to support them in terms of what is driving their bills, and if there's any programs that we can do to support them further.
And what actions did the company or is the company taking to proactively identify these types of issues to avoid customer billing challenges?
We actually have a proactive process where we manage and look at anomalies in usage, and we will actually send messages or do outreach to customers if we do see those anomalies. It's not perfect necessarily, but we do try to warn them preemptively before the bills can get out of control. It's not a perfect process. They don't necessarily sometimes reach back to us, but we do have that in process. And then customers that have email with us do get high bill alerts automatically through their email. In addition, they get a monthly report about their usage that can help them identify early any anomalies in usage or high usage that could mitigate future high bills for them.
Thank you, Ms. O'Donnell. I have no further questions for this witness, and she is open for cross-examination.
Very good. We'll start with AOPA.
No questions, Your Honor.
All right. We will go then to MEA.
No questions, Your Honor.
People's Counsel.
Thank you, Your Honor. I have a few questions for this witness. Good afternoon, Ms. O'Donnell. Good to see you again.
You too. It's good to see you.
I have some questions about everyone's favorite issue in this case, net operating loss tax carryovers.
Okay.
So if you could turn to page 42 of your rebuttal testimony.
I am there.
Okay. And starting on this page, you're responding here to OPC's adjustments regarding the accounting of net operating loss carryforwards, correct?
Yes.
And as were you in the room to see the cross-examination between me and Mr. Lemming?
I was.
And so, as I discussed with Mr. Lemming, you're aware that this issue relates to a change in Pepco's accounting of net operating loss carryforwards. Is that correct?
It's a change in terms of rate making accounting in reaction to a private letter ruling for another utility that essentially has the same circumstances as we do with respect to accelerated depreciation and that private letter ruling.
Yes, and we'll get to the private letter ruling.
Okay.
But just to to a little context, you're aware that this change to the regulatory accounting has a sizable impact on Pepco's rate base and revenue requirement. Is that right?
I do know that it's approximately $50 million in rate base.
Okay, thank you. Now, if you could turn to page 43, line 13.
Yes.
So here, in this sentence, you note that Pepco was required to change its accounting practices due to a series of private letter rulings the IRS issued regarding the application of the IRS's normalization rules.
Yes, it was a. Yeah, sorry. I'm sorry. Did you finish your question?
Yeah.
I'm sorry. Yes, we are required to, upon our first opportunity, to reflect that change in rate base and cost of service.
Is it correct that IRS private letter rulings are determinations on specific taxpayer issues and are issued in response to requests from a specific taxpayer?
Yes.
And as you note in your rebuttal at page 43, lines 10 through 12, IRS private letter rulings can only be relied on by the taxpayer that received it. Is that correct?
The private letter ruling itself, however, there are circumstances where if we know about a private letter ruling of another utility with identical circumstances, we need to reflect that at our first opportunity.
And I think you discussed this in your testimony. You point to the letter as being instructive. Is that the language you use?
Can you point me to where you saw that? It sounds right, but I just want to make sure I'm confirming properly.
Line 11 on page 43.
Yes.
And even if PLRs may be instructive of the IRS's view on an issue, it's correct that only the taxpayer that requested the IRS ruling is required by the IRS to implement the changes to conform with that ruling. Is that right?
Can you say that again?
Sure. So you agreed with me that the PLR rulings in Pepco's mind are instructive on what the company should do to remedy a potential inconsistent practice. But would you agree with me that only the taxpayer that requested the ruling from the IRS is required to adjust their practice to conform with that ruling?
Well, I think, and I know that you'll probably disagree with me, but I go on to say that the fact patterns, as I said earlier, are similar in nature with the private letter ruling of the other utility, and that based on the revenue procedure noted on line 14, that Pepco is required to revise its methodology at the next available opportunity, which under IRS guidance is this proceeding, to comply with normalization provisions or be subject to the penalty for a normalization violation. And what we're trying to do is avoid a normalization violation.
Is there any IRS regulation or decision or guidance that you cite in your testimony that states the company is required to change its practices based on a private letter ruling to a separate entity?
I don't think specifically.
Okay, thank you. And just to be clear, for the entities that received the private letter rulings that the company cites as instructive, were any of these entities Exelon affiliates?
I do not believe so.
And then were any of these entities Maryland utilities?
I do not believe so.
To your knowledge, has any Exelon affiliate received a PLR from the IRS regarding the treatment of income tax benefits associated with net operating losses?
Not that I'm aware of.
Has any Maryland utility received a letter on that issue?
I don't know.
Okay. And it's correct that Pepco requested its own private letter ruling on this very matter?
That's right.
Your Honor, if I may introduce an exhibit.
Okay.
This would be OPC data request 2613.
So marked.
Well, I haven't gotten a number for us yet, Your Honor.
Is it, okay. I haven't gotten the paper yet, but still.
Yeah. Fair enough, Your Honor. I believe this will be, I'll pass it out and then I'll
Yeah.
mark it.
That doesn't stop me from marking it. 27? Oh, what did he say?
You just tell him what the DR number is. But the
Oh,
exact
oh, oh.
number will be different.
May I approach, Your Honor?
Please. Very interested in seeing this, actually.
Thank you.
Your Honor, I'd like to mark this data request response as OPC Exhibit 27.
So marked.
Ms. O'Donnell, you sponsored the response to that
Yes.
request? And Subpart A asks Pepco to confirm that its private letter ruling is still pending at the IRS. And the company's response states that the request is still pending. Is that correct?
That's correct.
And as of the date of this hearing, Pepco is still yet to receive a ruling from the IRS on this
Yes.
request?
Yes.
Do you have any idea when Pepco would receive a ruling?
I don't.
So if I'm reading your testimony correctly, it's the company's position that based on an instructive and non-binding IRS ruling that was issued to utilities based in another state and not affiliated with Exelon, Pepco concluded that it has inadvertently violated the normalization rules, correct?
That's right. And we've notified the IRS through our 2023 and 2024 tax filings.
But to be clear, the IRS has not determined that Pepco actually violated the normalization rules. Is that right?
I think it's safe to assume that because of the nature of the private letter ruling for the other utility, that we were in violation based on that private letter ruling.
But the IRS hasn't ruled on that, correct?
They've ruled on the other utilities' private letter ruling who had identical circumstances.
In a different state, correct?
I don't think the state matters since the IRS manages across the country. Also, it's important to note that the Commission has ruled on this for Delmarva Power and BGE through their annual information filings, and they too found that it was important to ensure that the company did not lead to a normalization violation when when BG&E and DPL reflected the NOLC in their rate base.
And I'd like to follow up on that. So you stated that the Commission ruled that the company's change in that circumstance was prudent? Is that your testimony?
I don't know if they used the word prudent, but they did accept that as a part of the AIF filing that they should include it in the rate base. And we were deciding whether to return refunds for customers in the event of Delmarva Power, and the amount we returned to customers was net of the NLC operating loss. And two, we committed to, if the private letter ruling came back differently, that we would refund those funds back to customers.
Could you turn to page 44 of your rebuttal?
Yes.
Line 6.
Yes.
And could you read, I guess, the sentence starting with the commission? Just read it to yourself.
Okay.
So is it correct, Ms. O'Donnell, that in this sentence here, you state that the commission found the inclusion of the NOLC was prudent?
I say that they allowed the NOLC adjustment for BG&E and DPL.
Could you read the sentence starting from the commission found on line 16 out loud?
Sorry, 16?
Yeah, line 16.
You want me to read out loud?
Read it out loud, please.
Yes, the commission found that the inclusion of the NLC was prudent and protective of customers in Order 91768.
Okay, thank you.
Okay.
That's all. And you quote the more language from that order. And in that order, the commission also stated that its prudency determination was actually in regards to withholding a final ruling on the inclusion of the NOLC. Is that correct?
I think in light of the private letter ruling still being outstanding, I imagine.
So the commission didn't rule, in your, as you understand that order, the commission didn't rule definitively on the inclusion of this adjustment in Delmarva or BGE's rates. Is that correct?
I think they ruled in allowing the adjustment, certainly.
Where does it say that in the order, Ms. O'Donnell?
I don't have the order in front of me. I'm sorry.
That's
I might.
I'd be impressed if you had it all memorized.
I wish I could.
Yeah, me too. Well, so I'd like to move on from this and ask you about another DR response.
Okay.
This would be DR 2614. Your Honor, may I approach?
Yes. It's going to be 28.
Your Honor, I'd like to mark this as OPC Exhibit 28.
So marked.
And you sponsored the response to this data request, is that
Yeah.
correct?
Yes, I did.
And this data request asks whether you're aware of any instance where a utility has been penalized for a normalization violation.
As I say, we are not aware of any examples.
And just to follow up on that,
Sure.
so you're not aware of any examples entirely of any utility being found to have violated the normalization rules?
I think it states I was not aware of any examples in which regulating commissions prohibit a public utility from correcting a normalization violation that resulted in the utility losing the ability to claim accelerated tax depreciation.
Okay, so are you aware of any instance where a taxpayer with the pending PLR request has been penalized by the IRS for violating the normalization rules?
I don't think I can answer that question because I would assume I know every utility's private letter rulings and normalization violations, which I don't.
But just to your knowledge.
My knowledge,
yeah.
I don't know, but that doesn't not mean that it hasn't occurred.
So then it's correct that you're also, you're not aware of any circumstance at all in which the IRS has penalized the utility for violating the normalization rules.
Objection, asked and answered.
Yeah, I think that's right. Sustained.
So let's just assume for the sake of discussion that Pepco's prior treatment of net operating losses, which is the subject of the PLR request, let's assume that the IRS decides that it does violate the normalization rules. So IRS procedures, if this practice is in violation of the normalization rules, Pepco is required to revise its methodology at the next available opportunity, correct?
Yeah, I think the way I think about it is the private letter ruling is to decide on which way we treat the net operating loss, not necessarily about a normalization violation. And so I think I just want to clarify that certainly that private letter ruling could lead to them assuming we had a normalization violation, but we've already said we did based on the previous private letter ruling.
Okay. And based on that, you made this identification, and the company would have to revise the practices at the next available opportunity, right?
For rate making purposes, yes. And this is that available opportunity.
Well, I'm going to ask you about that.
Okay.
So on page 43, look at lines 15 through 16 of your rebuttal testimony.
You said 15 through 16?
Yeah, lines 15 through 16. And this is where you state that the next available opportunity under IRS guidance is this proceeding.
Yes.
And that's based on your understanding of IRS Revenue Procedure 2017-47, correct?
Yes.
So I'd like to ask you a couple questions about that revenue procedure. And I have a copy for everybody here. Your Honor, I'd like to mark this as OPC Exhibit 29.
So marked.
Now, Ms. O'Donnell, would you agree that the document I passed to you, it reflects the IRS's procedure for the safe harbor for inadvertent normalization violations?
I think I can trust you for that.
Yeah, thank you. And this is the safe harbor provision protects utilities that have inadvertently violated the normalization rules from being penalized by the IRS. Is that correct? Just generally?
Generally, yes.
So could you turn to section 5 and review subsection .01? This should be on page 10. It starts towards the bottom. Okay, so this provision here that you just reviewed, it states that a taxpayer can seek protection under the safe harbor through filing a statement that identifies the inconsistent practice or procedure and a representation that the taxpayer intends to change a consistent practice or procedure, change to a consistent practice or procedure at the next available opportunity. Is that right?
That's what it says.
Okay. And next available opportunity, as referenced in this section and in your rebuttal testimony, is a defined term in Revenue Procedure 2017-47. Is that correct?
That's what it says, yes.
Okay. And to be clear, you, in your rebuttal testimony, as you've stated earlier, next available, you define it as meaning the next rate proceeding.
Yes.
Would that be this case?
Yes.
Could you take a look at the top of page 10, which provides the definition of next available opportunity? And is it correct that this definition has 3 parts?
It does.
Would you please review part 1 of the definition?
Yes.
And this part, you'd agree, applies to a taxpayer without a rate proceeding pending before the taxpayer's regulator? And in that circumstance, next available opportunity means the next rate proceeding. Is that correct?
Without a rate proceeding pending, yes.
Is this the definition that you refer to in your rebuttal testimony?
I would say not, because we have a rate proceeding pending.
Okay. Well, there's 2 other definitions that are of next available opportunity. Let's go through those. So please review part 2 of the definition. Good catch. Well, thank you. That's one of the longest sentences I've ever read, I think.
I had to read it twice.
Yeah, me too. So this part concerns a taxpayer with the rate proceeding currently pending before the taxpayer's regulator. Is that right?
Yes.
And you would agree that Pepco is a taxpayer with the proceeding currently pending before its regulator?
I would agree
correct?
with that.
Okay. And this definition states that next available opportunity means the currently pending proceeding,
Yes.
unless the regulator or applicable law precludes the taxpayer from correcting the inconsistent practice. Is that correct?
Yes.
So based on your reading just now and as you understand this provision, if the commission were to prohibit Pepco from correcting its inconsistent practice in this case, then under this revenue procedure, would this proceeding be considered the next available opportunity?
I believe that probably would apply, but I think that would be inconsistent with what the commission has ruled in other proceedings.
And that would be the proceeding where the commission opted to hold the issue in abeyance until the IRS issued a ruling on the issue, correct?
Yes, but included the adjustment and based rates on it for DPL.
Is there a reason why you didn't mention this provision in your testimony?
No.
Okay. Let's review part 3 of the definition.
Okay.
And this part concerns a taxpayer with a pending private letter ruling request at the conclusion of a rate proceeding. Is that correct?
Yes, that's what it says.
and this provision specifies that the private letter ruling request is to address whether or not a practice or procedure addressed in the rate proceeding is consistent with the IRS normalization rules, correct?
Sorry, can you say that? That was a really long question.
Yeah. So the provision that you just reviewed, it specifies that the private letter ruling request submitted by the taxpayer addresses whether or not a practice or procedure addressed in the rate proceeding is consistent with the normalization rules. Is that right?
That's how I interpret it, yes.
Okay. And you'd agree that Pepco's pending private letter ruling request aims to address whether the company's prior accounting for NOLs is consistent with the IRS normalization rules, correct?
Yes.
Now, this definition here states that the regulator must establish or approve rates subject to adjustment from the effective date in order to conform with the IRS's ruling. Is that right?
That's what it says.
So if the IRS hasn't ruled on Pepco's private letter ruling request by the time this commission renders a decision in this matter, would you agree with me that this provision here would allow Pepco to avoid a normalization violation if the commission sets rates subject to adjustment based on the outcome of the PLR request?
I'm going to object. This seems to be calling for legal interpretations.
If I may respond, the witness cited and interpreted this provision in her testimony, and I'm asking her directly about it.
Oh, I'll overrule the objection in this case.
That's how I read it, but I think what's important here is that we don't know what the IRS is going to say. And so for the practice of being safe and to totally avoid a normalization violation, which we don't know at this point, while we've actually admitted to the normalization violation in our rates, in our returns, it could be that we are fined. And so I understand that you're interpreting this in a way that gives the commission flexibility to do that, but it seems that the commission in their other orders has erred on the side of caution and has included the normalization adjustment for the purposes of rates in a reconciliation, subject to refund if the private letter ruling results in something different.
Well, we clearly view the commission's prior orders differently, so I'm not going to continue
Agree.
to go back and forth with you on that. But you would agree that the two definitions that definition 2 and definition 3 that I walked you through, both of these potentially could be applicable in this proceeding, and both of them provide a process by which the commission could deny Pepco's net operating loss carry forward adjustment and avoid being found to have violated the normalization rules.
Well, we would have violated the normalization rules, not the commission.
That's the company would.
Yes,
Yeah.
and so I think it would be dangerous.
Okay. Are you familiar with Mr. Madsen's rebuttal testimony?
Yes, I don't have it in front of me, though.
That's okay. I'll ask if you're. Do you recall, just off the top of your head, his suggestion for the commission to not issue a final ruling on this issue?
Counsel, I can provide a copy to the witness.
Yeah, this would be his rebuttal at page 36.
Could you say the site again? I'm sorry.
Yes, page 36 of his rebuttal. And focus on line 10.
Yes.
Okay. And at this part of Mr. Madsen's rebuttal, he suggests or he recommends that the commission could not issue a final ruling on this adjustment in this proceeding and defer consideration and corresponding cost recovery until after the IRS issues a ruling. Is that what
That's what he says,
about there?
yes.
Okay. And as you understand Mr. Madsen's proposal, is it correct that he's suggesting the commission require the company to remove the adjustment but track incremental costs associated with the accounting changes? And when the company and the company would be allowed to recover any incremental costs that might occur once the IRS determines whether Pepco's correction of its identified inconsistent practice is required?
That is what he says.
As you understand Revenue Procedure 2017-47, would this proposal be consistent with the third definition of next available opportunity?
I think closely, yes.
Are you aware of Pepco previously proposing this type of treatment when the company had a PLR request pending?
I'm not aware of it.
Are you aware of the commission approving this type of treatment when a company had a PLR request pending?
I do not.
Now, if you could turn back to your rebuttal testimony, page 46. Line 1. Here, you state that Pepco will refund customers if the IRS concludes that Pepco's prior accounting practices were inconsistent,
Yes.
or were consistent.
Yes.
Yeah. So there's the difference between your position and Mr. Madsen's position largely amounts to the timing of when the impact of the IRS's PLR ruling will be felt by customers. Is that right? The company's position is the customers should start paying for this accounting change now, and if the IRS rules differently, the company will refund customers.
I think it's because we feel it's unlikely that the IRS will, because the circumstances were very similar.
Yeah.
So that's our position. So I just want to make sure I reinforce it. And so I think
understood.
whipsawing customers and confusing them with changes in rates for something that I think is most likely to occur could create even more confusion for customers during this time.
Understood, but just to be clear, yeah, the basic difference is the company's proposal is to charge customers now, and if there is a change that in the company, the IRS rules differently than what the company expects, then the company will make a refund. And you understand Mr. Madsen's proposal as the company doesn't charge customers for this right now, but if the IRS does rule in the way the company expects, then customers would be charged the difference.
I think the difference is that we believe that not including the rate making adjustment to include the NOLC is a normalization violation and doesn't align with the accelerated depreciation benefits that the customers are receiving.
Would you agree that Mr. Madsen's proposal would afford immediate rate relief to customers if the commission were to authorize a rate increase in this proceeding?
No, because we're asking for a rate increase in this proceeding. So I just want to be clear on your question. So there would be rate relief because it is not reflected in rate base as the basis for rates today. So it would not be rate relief.
Let me ask the question a different way.
Okay.
So if the commission does authorize a rate increase in this proceeding, if the net operating loss carry-forward adjustment is removed from the final revenue requirement the company has authorized, would that result in a lower revenue requirement approval than one in which that adjustment is included?
It would lower rate base and would result in a lower revenue requirement associated with that adjustment.
So it would be a lower
incremental rate increase.
And that would be beneficial to customers, assuming that they have
not necessarily if they have to come back and pay us back for it through the tracking that Madsen proposes.
Okay, no further questions. Really appreciate your time. Thank you.
Yeah, thank you.
Thank you, Your Honor.
Okay.
Your Honor, I do also have to move my exhibits.
Oh, of course, yeah.
I'll move OPC Exhibit 27 and 28, and then I'll ask the Commission to take judicial notice of OPC Exhibit 29.
No objection.
Without objection, so entered and noted. Okay, we will proceed now to staff.
Good afternoon. Staff has no questions for this witness.
Okay. Redirect?
Yes. Ms. O'Donnell, you recall the conversation between yourself and OPC's counsel on the NOLC, correct?
Yes.
And you noted that the commission has ruled on whether it's appropriate for a utility to make an NOLC adjustment.
That's
Is that
right.
correct?
Yes.
And that was for two other Exelon entities, is that right?
Yes, in Maryland.
What are the consequences if there is a violation of a normalization adjustment? For example, would there be penalties?
There would be significant penalties, which is why I believe that the commission, and I can't speak on behalf of all the commissioners that made the decision, is to err on the side of caution and to include the NLC adjustment in rate base.
In the commission's order for the other Exelon entities, BGE and Delmarva Power, did the commission note that there were serious risks associated with an that at the IRS that could result in a normalization violation?
Yes, I said there were risks associated with it, which could result in the violation, and they warranted caution over expedience.
Did OPC previously request to defer the NOLC adjustment in the BGE and Delmarva Power cases?
I don't believe so.
Did the commission reject OPC's? Oh, you're saying you did not
To defer it?
did they make the same argument that they're making today in the BGE and DPL cases?
Yes, they did.
Did the commission reject that proposal?
Yes.
Council also mentioned that acceptance of Mr. Madsen's proposal will result in a lower revenue requirement. Do you recall that discussion?
Yes.
So even though there would be a lower revenue requirement, would there still be the potential for IRS penalties if we adopted the OPC's proposal?
Yes.
I have no further questions.
Okay, we'll begin questioning with Commissioner McLean.
Good afternoon, ma'am.
Hello.
How are you?
Well, how are you?
Good. Just to confirm something you had said with Mr. Sammartino right at the very end, I think you had said that adopting OPC's position in the long term would cost customers more. Is that
Yes.
what you were saying?
Yes.
Okay, and can you explain why that is, ma'am?
Well, we would track it, and then we would ultimately go back to collect it from customers. And so over that period of time, they would have to pay back that period of time where we should have had the NLC in rates.
All right, thank you. Mr. Blazunas said you might be able to provide. Oh, okay, good.
Yeah.
That you could provide a ballpark estimate of what it would cost the company to move October from the summer to the winter.
Sure. This is very high level. And so I would say it would range between about $300,000 to $500,000 to make the change. And what that includes is the logic that you would need to make the change. And then in addition to that, there would probably need to be customer communications to describe why the change was occurring. There would be filings that would be made, but I wouldn't call those incremental costs. But a lot of it is required to change the coding in the customer system.
All right, thank you. On page 5 and 6 of your rebuttal, ma'am,
Yes.
Here at the bottom, you're talking about the potential impacts on the company if there was a capital project such as White Flint that was denied recovery.
Yes.
And on line 9 on page 6, you state this would have a detrimental impact on the company's credit metrics. And you go on and I should just read the whole thing.
Okay.
I was going to yada it, but and Moody's and S&P would view this negatively from both a quantitative impact on credit metrics as well as a qualitative impact on the company not recovering prudent and reasonable investments. Does that state? Do you agree if you're not recovering? Well, I guess if the commission were to say a capital project was you can't recover it because it's imprudent, do the rating agencies look at that the same way?
I think they would look at it negatively, particularly since it's an asset that's in service, providing service to customers. they would view it financially, first off, which I described, which is that we would take a write-off, and so our O&M expense would be higher in the given year in which we wrote it off. But then there would be the lack of cash flows associated with that investment that we would have collected over the life of the asset once it was reflected in rates. I think they would also have concerns about the environment in terms of why that something that is a substantial investment that we believe was prudent was not allowed.
Fair enough. On page, in kind of the same vein, page 8 and 9, at the bottom, ma'am, there's a question on line 16 about instances in this proceeding that demonstrate the financial risk of the company that is exposed to in Maryland. And in your answer onto the next page, you talk about the denial of, or the potential of plant disallowances. And you say this is a prime example of the real financial risk that a company is exposed to in Maryland. Doesn't that apply to all utilities and all capital projects? Isn't there always a risk of imprudency finding, ma'am?
There's always a risk. Yes, I agree with that.
All right, so it's not unique to Pepco?
No.
Okay. All right, thank you, ma'am.
Yeah, thank you.
Thank you, Mr. Chairman, and good afternoon, Ms. O'Donnell.
Hello.
First, I wanted to thank you for following up, the company for following up on the comments that we saw from consumers at our virtual hearing. I don't know the end result of what happened with them all, but I'm going to assume that to the extent it hasn't been resolved in whatever way it needs to, that the company's continuing to work with those customers to resolve whatever issues they had with keeping their service on. I believe 2 of them suggested that their power was actually off at the time they were participating in the hearing. And so, with so many other programs the companies referenced here and others that are in the state, I'm hopeful that there's some way to make sure that those customers are getting taken care of.
Yeah, we will be providing a bench discovery response also in addition to give you more details about those customers. I wanted to avoid getting into customer, so just trying to avoid that, obviously to protect our customers from information. And yes, we will continue to work with them, particularly the individual who's had high usage to help figure out how to mitigate that going forward.
Good, thank you. So my second question, and it's in your rebuttal, I'm pretty much focused on pages 2 through 5. And there I don't remember which exhibit number this is, but
Don't ask me.
Let me make sure it is your rebuttal testimony. Yes.
Okay.
So, the commission has an obligation to make sure that the company is financially stable. And we have that same obligation for all our utilities. So when Pepco first wanted to participate in the original MYP pilot, I was obviously not pleased with that, and I'll leave it at that. And now we find ourselves a couple of years later where the company, and specifically in your testimony on page 5, you specifically state, and let me make sure I got the right section here. You've basically echoed the same comments that we've heard from other company witnesses, that the fully forecasted test year is the better option. If we move a traditional test year, that's problematic for a number of reasons for the company. Of course, we know what happened recently with the General Assembly and the Utility Relief Act and their prohibition of moving forward with a fully forecasted or forecasted test year data for this year. So this is going to be a bit of a softball question as opposed to some of the other ones that I might have asked earlier today. Is everything okay at Pepco? And I'm talking about it from a financial perspective. I mean, this is, and I'm serious. I know it might seem like an odd question for me to ask from here, but I've seen a lot of I know the companies run well. I know they have excellent employees. I've worked with them for many years in many different ways. And many of them I've known even before I've sat here as a commissioner. But I've just seen I've seen the company take actions here that are just, it almost seems like there's things going on that are financially challenging for the company, but we're not being told about it. And I'm sitting here on this side of the bench, and I'm thinking to myself, if there's something I need to know, I'd like to know it. And maybe it's not something you want to put on the bench, on the record, in a rate case, but it's been several years now, and I've seen this over and over again, from the initial pilot program to proceeding with a case here, when other companies and Exelon haven't done so, in both in PECO and BGE. And so I'm just curious, and I'm asking it that way. I know it's a bit of a softball. It gives you a lot of latitude to give an answer that you like to. So.
Well, first, I'm always happy to talk to you about the financial position of the company whenever you would like, and I'm happy to come here and do that. But what I would say is that you can determine financial health from a number of metrics. One, our credit rating is a determination of essentially our ability to have sufficient cash flows to pay back the investors who have issued debt for us for the investments we've already made. In addition, they focus more on the debt side because there's essentially the credit score for when we issue debt, and just like an individual, you have a higher credit rating or a higher credit score, you get better interest rates. And so, yes, we have an investment grade credit rating. We've been able to go out and issue debt at reasonable costs. But so from that end, I would say, yes, we are sitting today, we are fine. However, I think what we've seen is a degradation in our ability to get cost recovery in terms of outcomes. And so, and what does that mean? It means that maybe if I do it with math, would that be helpful?
I'm a lawyer, but you can work with
So actually, OPC pulled together the exhibit from the 10K. And they talked about all the earnings that Pepco has. I think they quoted, I don't know, they talked about the dividends we were paying, which was about $900 million, but you need to net that with the equity infusions that we're receiving from the parent. And so I think if you were to walk the line from the last time we got a rate case outcome, you'll see the growth in the net income has gotten lower. In fact, when you go from 24 to 25, net income grew by $11 million. That's one factor. What does that mean? It means that we're paying our employees, we're paying the O&M costs, we're making capital investments, and so that shrinking net income is going to show that we are not getting an ROE that is commensurate with what the commission has allowed. And so I think if you measure it on a return on equity, you're seeing it decline over time, and some of that is lag built into the rates, and so we haven't had a rate increase since April 1 of 2024. And so we are continuing to see that recovery is going, and that's why we're here. And that's the driver of the request. And we have made lots of efforts to try to mitigate the bill impacts to customers. One, we've kept O&M lower than the rate of inflation. And the way we've done that is by managed hiring. We've paused hiring for periods of times in order to mitigate that bill impact. But over time, the investments that we're making in terms of the rate base and plant and service, which the traditional test year is primarily based on assets that are already in place and providing service to customers. Those assets some of them have been in place for almost 2 years. And so when you think about the ROE, we're about, I think, 200 basis points from an unadjusted perspective below the 9.5% that was authorized in the last rate case. So Is it a dire situation? No, but I think we've had some things that have happened this year that have continued to put pressure on us financially. We had to write down a regulatory asset associated with the reconciliation based on the decision, and so that put pressure on us from an O&M perspective. But inherently, it's the assets that are in place providing the service to customers that we are not getting the cash flows for, and that's what's leading us to come into this case. And so a White Flint substation being fully written off would have significant impacts to us in terms of a financial impact for a write-off, but also we would lose out on collecting the cash that we had expended to provide that substation. And I think we've done company witness Taiwo Allo did a fantastic job talking about why that White Flint substation is necessary for a variety of reasons, not only for residential customers, for resiliency, but also for the growing business community and the White Flint and North Bethesda area. So we could talk on and on about this, but I would say everything is okay. But that's why we're here to make this request, is because we do need to get cost recovery for the investments that are already in place for our customers.
Okay. So you know that there's a perception, and we heard a lot of consumers say this in our evening hearings, that the company is financially doing well, and that they are the ones struggling. And so your case here today, this case, what they were talking about specifically, is harming them because they've been perceiving it as if you are financially enriching yourselves or supporting your company by raising rates on them when you really don't need it because you're already doing well. And so now, I know we got a lot to still do here today. I know we could talk about this at any time, but I do think it's important that even if you don't give us an answer today, that the company starts to figure out how to give that answer to customers, because that sentiment is out there, as you talked about it earlier today, and as we've heard it throughout the hearing here this week.
Well, I think there's definitely may I just respond quickly to that? I think there's certainly perception around Exelon and the earnings materials that they've seen, and I can tell you that Pepco is not really a contributor to that earnings growth for Exelon. So we were about a penny of EPS associated with that. So I think, and a lot of that is just they don't understand necessarily the Exelon versus the Pepco view, and so I think they're seeing things, and rightly so. We aren't padding our pockets, because if you look back at the dividends and the equities, and you net it with the equity with the net income, it's basically a 1% return on the $4 billion of equity that we have. So I would say that we are not. I don't know how you define it, because it's always in the eye of the beholder, but I would not say that we are just pulling earnings in all the time and then not using those earnings. Those earnings are directly being used to reinvest back into the system and are not going to shareholders if you think about Pepco as a standalone company, based on the math and the dividends and the equity infusions that we receive from the parent as a function of net income.
Okay. All right. Thank you very much.
Yeah.
Thank you, Mr. Chairman.
Good afternoon, Ms. O'Donnell.
Hi.
So the private letter ruling, I don't believe it's in the record, the actual request for a private letter ruling for Pepco. Is that
I
correct?
don't know the answer to that, but we can get you an answer on that.
Yes, it might be attached to another witness's testimony. I'll check on that.
Okay. Do you recall the contents of the letter?
I do not.
Okay.
It was filed a while ago.
Right. No. I'm looking at Mr. Lemming's testimony, and what he said is that you're seeking a letter ruling to confirm the proper application of the normalization rules. So you didn't just assume that you violated the normalization rules. You actually are trying to get confirmation that you violated them. So you don't have an actual ruling from the IRS at this point.
Not for our situation, but the fact that there was another private letter ruling with similar circumstances leads us to believe that we were in violation.
Right, but did you feel that you needed to get the private letter ruling as opposed to just sort of going, just
think-
assuming that you violated normalization and that you needed to do the changes that you needed to do.
I understand that you do need to go the process of the private letter ruling to get the confirmation for the individual entity.
Okay, and is that in order to qualify for safe harbor? Is that?
I think the safe harbor applies to the normalization violation. That's what we were talking about.
Okay, but did you feel that you needed to get the private letter ruling in order to qualify for safe harbor, as opposed to just, or you felt that you needed to get a private letter ruling to confirm that that there was a violation?
As you know, I'm not a lawyer,
Yeah, I
and
know.
so I'm sorry to defer this to something else, but
I just play one on TV.
Yeah.
Okay. Yeah. If you can confirm that it's in somebody's testimony, I'd like to take a look at the letter. If it's not, I guess maybe this is a bench request.
Sure.
If we could get a copy of
Absolutely.
that. Okay. We turn to your direct testimony. And if we could look to page 4. And on page 4, you've listed generally two different time periods. So you've got the FFTY periods of historic, bridge, and forecasted. And then for the TTYCP period, you don't list what's applicable there. So what is at least there? So what do the test year is how do you define test year?
for the traditional test year,
Right.
As September 30th, 2025, for 12 months ended.
Okay.
So rate base would represent all the activity occurring up until that point in time in terms of our plant basis, and then we have obviously rate making adjustments, which we talked about during the proceeding, that go beyond the test period. So I think Mr. Nelson talked about the various rate making adjustments for plan additions as an example.
Right.
And that's just to make sure we're clear, that is to align the test period for the traditional compliance filing with the rate effective period to get as close as possible to the costs that would be incurred or in service during the rate effective period.
Okay. And then you began conversation about O&M expense overview on page 18 of your testimony. And is the intent of that overview to apply both to the fully forecasted, and for the traditional?
I actually think you can do both. I think the initial intent is to address the forecasted test year and also the bridge year in terms of the process in which we develop the O&M forecast. But it certainly could be informational in the sense of like how does O&M get developed in a budget for the 3 months that we did update to actuals for the traditional test year.
Okay. You're starting to get close to my question. So that this long range plan is for the forecasted. It's not for the traditional.
The long range.
The LRP, long range planning. That you mention on page 18.
Yes, that would have been for the bridge year and the forecasted test year, so 25 and 26.
Okay. Would it have applied to any part of the traditional test year?
Technically, the rate making adjustments that are the post-test period rate making adjustments associated with reliability, those projects would have been part of the LRP. But those are a more discrete set of plan additions, but they would have essentially been part of that process, but you don't need to rely upon the LRP process to assess those plan additions.
Okay. So I guess what I'm getting a sense from you, and then section 6 was specifically for FFTY. So I'm getting the sense that section 5 was mostly about FFTY, and section 6 is exclusively about FFTY.
Hold on 1 minute. I just
Okay.
want to make sure. I would say yes, but the discussion around the growth in the O&M, I do think is relevant to the traditional test year because while you are going to be looking at actuals, with the exception of some adjustments to O&M for labor wage increases, and which could be union increases that we have already committed to. What I do think is important about the information, and while it isn't necessarily tied exactly to what's in the traditional test year, it gives you a sense of the O&M needs that will be in effect during the rate effective period, which will start in August.
But are those known and measurable?
When we filed, they were not known and measurable in terms of the 2026 forecasted test period.
Okay. So.
Can I say one more thing? I'm
Yeah,
sorry.
no, that's fine.
But a lot of the rate making adjustments associated with O&M in the traditional test year are known and measurable,
Okay.
like wage increases, et cetera.
So now this is the problem I'm having, is that we're not talking about the fully forecast test year anymore.
No.
Okay. So section 6 of your direct testimony no longer relevant. And the problem that I'm having is section 5 may touch on the traditional test year, but I'm not getting a clear sense of how. And then I guess the question is, does your testimony look at all to the specifics of O&M for the traditional test year?
My rebuttal does cover some of the adjustments that I think some of the witnesses put forth, but I would say that in this section alone, it really is focused on the forecasted test year, but it does give you some other information around how we have effectuated cost efficiencies to mitigate bill impacts. And so I think that part is important in terms of the actions we've taken to sort of avoid additional costs for our customers.
Okay. I mean, you were here when I did my bench request.
Yes.
And so I am really hoping that the information that we get from Pepco on O&M is responsive to our interest in making sure, because now that we're just on a traditional test year, we need to do historic and known and measurable. So we need to sort of know exactly what that is.
Understood.
Okay.
And then I think the one thing I'll add is that I just want to be clear that the traditional test year compliance filing that the company did make, it is like a traditional rate case. So it has all the materials that we would have provided in the past. It has rate making adjustments. And so those rate making adjustments, while the majority are known and measurable at this point in time, the purpose of that is to align with the rate effective period. And so I know that we've given a lot of information in this proceeding to be transparent, but I can commit to you that what we've provided in the record will prove that those things are in our assets in rate base they are in our balance sheet and serving customers.
No, I appreciate it. It's just that we're having trouble finding it. So even with breadcrumbs, we're having trouble finding all the information that we need. So that's why we were
Understood.
Okay.
And we are working on that furiously.
Terrific. Thank you. That's all I have.
Hoover. Good to see you again.
You too.
In your discussion about the capital structure, you
Yes.
said one of the reasons why you needed to use the actual capital structure was a condition in the merger agreement between when Exelon acquired PHI. And I guess what I want to know is, was that a merger condition sought by one of the parties, or was that just adopted by the commission as part of the overall agreement, if you know?
It was 10 years ago, so I
Sure,
don't
I
remember all the
understand, yeah.
details. But I do think that there was ring fencing conditions that were a part of the merger. And the intent of those merger conditions were to mitigate sort of adverse implications of maybe Exelon taking earnings from Pepco. And maybe I'll clarify the actual capital structure. I mean, the actual capital structure reflects the debt that we've issued with perspective of the interest expense that we're servicing for that debt. And so if you looked at our balance sheet, you would see those similar proportions. But I think the other thing that's important is that actual capital structure has been used for rate making for as long as I've known and been a part of these rate case proceedings. And to suddenly change an equity ratio from approximately 51% to 43% is pretty dramatic. And just and would be a real misalignment from what's actually sitting on our balance sheet,
Okay.
particularly from a debt perspective.
Okay. And then on the private letter ruling issue, you talked about the fact that, we have the opportunity to deal with that in this rate case. And it's been suggested to us, at least by one party, that we not take that opportunity. So I guess what I want to know is, from a process procedural point of view, if we don't act on that issue in this rate case, and then you get the private letter ruling and it goes against the company, would you then be able to make just a separate filing that we would deal with at an administrative meeting, or is this something that would have to wait till your next rate filing?
I think the risk of that is that could be perceived as, and I'm not a lawyer again, as single issue rate making. And so I think that's also the additional concern. And then I think it would be, I think it's confusing to customers. And I think out of an abundance of caution and to mitigate the risk of penalties in a violation, I think it would be appropriate for the commission to be consistent with how they've treated the NLC and the other opcos.
Okay. So, coming full circle, I had a discussion with the very first witness that you put forward, Mr. Lemming, about the PECO action and withdrawing their rate application. And he indicated reasons why he thought that wasn't the right action for Pepco to do. But I guess what I want to know is, one, I mean, was there any discussion within the company when PECO took their actions as to whether or not you should consider something similar with your application, given a couple of things? One, the fact that a lot of things have happened since you filed this case in October. We're now in a shooting war in some places, and the price of gasoline is doubled or tripled since when you filed it. And then secondly, you actually did have to make a substantial revision to your case because of actions by the Maryland General Assembly, which has caused all these other issues that we've been talking about. So I guess I would like to hear you talk about, were the things that the company was thinking about, because it seems to me that your customers are in a pretty unique position. I mean, not only are they dealing with this gasoline situation, but they're also dealing with the fact that a number of them are now losing their jobs. And it's almost the equivalent of what's happened in other parts of the country when we had, traditional factories shut down and people were being laid off. We're seeing that kind of employment situations affecting your customers because of the actions by the current people running the federal government.
Well, I think I'll go back to what the discussion Commissioner Linton and I had, and the fact is that we haven't come in for a rate increase, and when the decision is rendered, if you do allow us a rate increase, it would be almost 2 years since that rate increase. And so we've invested on behalf of our customers dollars to provide service to our customers. And so the facts and circumstances of our case are very different than PECO, especially now that we're litigating the traditional test year filing. It's important for us to continue to have that opportunity to earn our ROE, and also to mitigate a future rate spike. If so, let's just say we pulled this case, which certainly we always are talking about ways that we can help our customers. You're inevitably kicking the can down the road, and you may ultimately we may come in with a higher ask. And this is why we've advocated for MYPs, and I won't get into that, but gradualism is obviously something that's important. And so what I would like to say is avoiding that opportunities for rate shock in the future. So I think it's important to continue on and with the case, and it's necessary for us to get a return on those investments, and also for the O&M that we've incurred. I think it's also important. I know maybe seems silly, but there's a lot of work by all the parties that have gone into this proceeding, and we are very far down the line, and maybe that doesn't seem important to customers, but I do want to acknowledge the tremendous agility and appreciation for all the work that the interveners have done, because I know for them it is not easy as well. But I think I still stand by the fact that we do need to have you assess our costs and structure and assess the need for a rate increase, and that is your prerogative. And I think it's really important to proceed on. And I recognize that it's a terrible economic environment, and the supply costs are heavily weighing on our customers. But I do think for the sake of gradualism for our customers and for us to continue to be able to provide the reliable service that they've grown accustomed to, it's important for us to continue to litigate this proceeding.
Okay, and then one last thing, I want to follow up on one of the things Commissioner Linton asked about, which was, well, I appreciate the fact that, you've been proactively reaching out to the customers who came to the public hearing and expressed concerns with that, but I think if I remember right, we recommended that those customers actually contact our Consumer Affairs Division. So just so we don't have a situation of ships
Yes.
sort of passing in the night, I want to make sure that
That's a
you're
great
got
point.
them in the loop about whatever you're doing to alleviate these problems. And if nothing else, it'll save you from answering the same question.
We are happy to
twice.
do that. Yeah, that's a great point. I know that there was specifically one individual that Commissioner Suchman said to reach out to the consumer advocate. Yeah, that's a great point, and we will do that. Thank you.
Well, thank you.
Okay, I'm last, I suppose. Good afternoon. Just
Hi.
a very quick. Some of my questions were asked and answered already. I'm just curious with this NOLC situation. How have you handled this on your financial statements? Footnote, a charge. How have you?
So, this is for rate-making purposes, so it is not reflected in our GAAP financials. It is a rate-making construct, and so you would not see that currently on our GAAP financial statement or balance sheet.
I mean, you don't even know. You're not even noting it.
I don't know if there's a note even in the 10K right now.
Okay, but I would have thought it would merit a footnote.
We might have noted the private letter rulings. I'd have to confirm that.
Okay. Well, that's it for me. So, okay, we've come to the end of the company case.
Your Honor, just wanted to close the loop on Commissioner Suchman's request. The PLR request from the company is attached to Company Witness Lemmings Part 2 Direct. It is RTL5, and just noting it's a confidential exhibit, but RTL5.
Good.
And that concludes the company's case.
Okay, well, here's what we're going to do. We're going to take a 10-minute break. We will come back 5 minutes to 4, and we will proceed with the witnesses for AOPA. So,
They're both here.
okay, terrific. So, see you back in 10 minutes.
because she was using it on.
Let's begin with Ms. Francis, your witnesses.
Thank you, Your Honor. The Apartment and Office Building Association, wishes to call Timothy B. Oliver to the stand.
Terrific. If you could swear him in.
I do.
Please state your name and business address for the record.
My name is Timothy Oliver, spelled Timothyoliver, and my business address is 7103 Lake Tree Drive, one word, Fairfax Station, Virginia, 22039.
And Mr. Oliver, on whose behalf are you appearing here today?
The Apartment and Office Building Association of Metropolitan Washington.
And you have a document before you entitled Direct Testimony of AOBA Witness Timothy B. Oliver, Volume 2 of 2, filed on January 30th, 2026, consisting of 25 pages of testimony and one attachment identified as AOBA-A.
I do.
Your Honor, I ask that the direct testimony, including Attachment A, be marked for identification as AOBA Exhibit 13.
So marked.
Was this testimony prepared by you or under your direct supervision, Mr. Oliver?
It was.
Do you have any changes, corrections, or updates to your testimony?
I do not.
Your Honor, I ask that the direct testimony identified and marked as AOBA Exhibit 13 be admitted into evidence.
Without objection, so admitted.
The witness is available for cross-examination.
All right. Now, what is the tradition? Okay, Pepco.
Good morning, Mr. Oliver. How are you?
Good. Good afternoon.
Nice to meet you. I'm Taylor Beck. I'm here on behalf of the company. And I just have a few questions for you. So just to start, you submitted testimony in this proceeding providing recommendations for the company's proposed capital structure and proposed rate of return, correct?
Yes, but
Okay.
I have offered testimony regarding that supporting the company's capital structure. I had testimony on the return on equity recommendation and some observations on the cost of debt.
Great. And one of your recommendations in this case, specific to the rate of return that you recommend or that you speak to, was that 9.4% ROE, right?
That is correct.
Okay. And you understand that the company's current ROE is a 9.5% ROE, right?
Correct.
Okay. And your recommendation, and this is, I'm just taking from your direct testimony at page 9, line 7, you indicate, and I'll wait for you to get there,
What page, counsel?
9.
Thank you.
You say, and this is the second arrow, the adoption of Pepco's proposed forecasting would eliminate regulatory lag and significantly lower Pepco's risk, warranting a downward adjustment to Pepco's authorized return on equity, right?
That is correct.
Okay. And then that form eventually goes on to form the basis of your 9.4% ROE recommendation. I'll just have you turn to page 10, where you state the commission should authorize a ROE for Pepco of 9.4% based on a 10 basis point downward adjustment to its current authorized ROE of 9.5% to reflect the commission's gradualism policy. This downward adjustment is supported by the reduced risk engendered by Pepco's use of forecasting. Is that correct?
That is correct.
Okay. And you didn't file rebuttal in this case?
I did not.
And you didn't file surrebuttal in this case?
I did not.
Okay. You were the witness sponsoring an ROE recommendation in case number 9702, correct?
That is correct.
All right. And there you recommended a 9.1% ROE, right?
Correct.
Okay. Bless you.
Well, to be clear, I had a analytical determination of 9.1%, but my recommendation, I believe, was 9.25%. I remember, because I applied gradualism in 9702 as well. And I noted my analytical result as the directional factor for an ROE adjustment.
I'm sure you don't have a copy of your.
Unfortunately, I don't.
Yeah, 97. I will just. Will you accept, subject to check, that you, in your direct testimony filed in 9.7 or case number 9702, that you answered a question, what is the basis for the 9.1% ROE that you estimate herein?
Would you provide the page and line numbers?
It would be page 22 of your direct testimony from case number 9702, line numbers 10 and 11, which I understand you don't have in front of you, but.
You have a copy of the counsel?
Subject to check, I would
I have
accept
my
that.
copy.
Can you show it to the witness?
Yeah.
I mean, sure.
Correct.
And you recall giving testimony at the Maryland Public Service Commission in case number 9702,
I do.
live testimony? That testimony was under oath?
Correct.
Okay. I'd like to mark for identification at first, Pepco exhibit, I just wrote it down, 43. May I approach?
Yes.
Okay. Mr. Oliver, I've handed you an excerpt from your testimony within case number 9702. I'll submit to you that in the top left it says volume 4 of the hearing. This is an excerpt, but we're happy to provide a full.
Did you get one? Okay.
Could you show the witness the full transcript?
Oh, wait, no.
Yeah.
This is, I can clearly identify that this is an excerpt from the volume 4 of the hearing, March 12, 2024. If your questions pertain to just what's in this excerpt, I'm able to proceed.
Sure, and my questions are only to this excerpt, but I'm happy to provide you a full. I won't give.
Excuse me, what did you want to mark this as?
Pepco exhibit 43.
43, okay, so mark.
I can provide a full copy of, I guess, volume 4. I don't think we want the full transcript from case number 9702.
No, I haven't.
Okay.
It's not here.
So, Mr. Oliver, I will represent to you that this is your testimony or that your questioning that you went back and forth with in case number 9702. And I would just ask that we start on line 10. The question you were asked was, when we talked about your direct testimony on cost of capital, you indicated that if the commission gave Pepco an MYP, there should be a 25 basis point reduction because MYPs are less risky than historical test years. Is that correct? And your answer was that is correct. Is that right?
Excuse me, I remember this this line of questioning, and this is taken out of context. He's going to need more context around this to get a full understanding of what was said, because I do remember this.
I may be able to answer questions about this excerpt, but I would prefer that the whole transcript, or this whole day of the transcript, be included with the exhibit.
So first off, was that an objection, counsel?
Well, I'm the one who's making an objection.
Okay.
This is taken out of context. If she would provide the full context, doesn't have to be the whole transcript of all of Mr. Oliver's cross-examination, that I won't object to. But I do object to one page because I do remember this, and it is out of context.
And what's your?
have laid the foundation that he testified or he provided testimony in 9702, written testimony. He testified orally in case number 9702. And I've talked to the fact that he provided a recommendation of a 9.1% ROE in 9702. And I think that it's pretty.
Your Honor, I think that was a mischaracterization of what I heard Mr. Oliver say.
Well, look, I'm going to overrule the objection. You do get to redirect after, so please proceed.
Okay. You testified in case 9702 that if there was a historic test year, then you would add 25 basis points to your recommendation in 9702, right?
Can you point to me what line I say that in this excerpt?
So the question was at line 16, you would agree with me, would you not, that you need to add 25 basis points to your 9.1 for an ROE if we get a historic test year of 9.35%? You responded at line 20, and we can go to the next page.
Well,
a couple things. One, this development was not to make a revenue requirement. This was to show what the impacts were. Second, if the commission does determine that we're going to do a single year revenue requirement, I would accept a 9.35 IRE because of the increased ROE, because of the increased risk associated with it. I would even consider going up to 9.4 if there's no risk. But I even hedge the risk. You would also get less gradualism because you wouldn't be going so far out in the future. So I think the commission can make those determinations. But in this calculation, I used the 9.5 for the first 3 historic periods because that was what was approved. That's what was approved at the time of that. Did I read that correctly?
yes, you did. Thank you.
So you testified that you would accept a 9.35 ROE because of the increased risk associated, and you would even consider going up to 9.4, right?
I did say that, but in the context of that rate case, it was, multiple options. That's not the case in this instant proceeding. So that was trying to find a balance between how to make a recommendation with 2 very different courses the commission could take with their determination.
You understand that in this proceeding, Pepco is seeking a rate relief based off of a historic test year, correct?
Traditional test year compliance filing, yes.
A traditional test year based off of a historic test year, right?
Partially forecasted, then updated test year, yes.
So if the commission were to authorize a historic test year or provide, strike that, if the commission were to, is it your position in this case, or actually strike that, sorry. If the commission were to authorize Pepco's proposed revenue requirement in this case, based off of a historic test year, there is no risk of forecast in this case, correct?
That is incorrect. Commissioner Litton pointed out earlier that there are forward-looking adjustments, specifically RMAs 2, partially RMA 2, RMA 3, and RMA 4 are post-test year additions. Those are forecasts.
Do you understand that RMA2 is actually all actuals in this case?
If I haven't looked at the updates that were provided last week and verified that the information is correct. I know the intent was to update through the end of the proceeding, but I have not had the ability to verify that the updates are accurate.
I have no further questions for this witness. Thank you.
Okay. MEA,
No questions for this witness, Your Honor.
People's Counsel,
No questions, Your Honor.
staff,
No questions for this witness. Thank you very much.
redirect.
Yes. When you you've participated as in a return on equity witness for AOBA in several proceedings, have you not?
Almost 10, I believe, at this point.
And when you do testimony, do you design your ROE testimony for the specific case that you're participating in?
I do.
And looking at the full circumstances of the case in which you're participating?
Yes, I do.
Were the circumstances regarding case number 9702, were they substantially different than we find ourselves in this case, case 9820?
Substantially different, yes.
And did that affect your ROE recommendations in this case versus an ROE recommendation in case number 9702.
Yes, and a simple example is the length of time between the cases. There between 9655 and 9702, we had over 3 years in between cases, and the time period that 9702 was proposed to covered over 5 years. This proceeding was filed 2 years after the 9702 decision, and it's only intended to go out for, I think, 2 years for the rate effective period. So just with that distinction, the context is substantially different.
Thank you, Mr. Oliver. That's all the redirect I have.
All right, we'll take this in the following order. Commissioners Linton, Suchman, Hoover, McLean, and the chair.
Thank you, Mr. Chairman. No questions.
Suchman?
No questions.
Hoover?
I'm fine, thank you.
McLean?
No questions, thank you, sir. But Ms. Beckham, did you want to introduce this or no?
Yes, I will. I'd like to move for the admission of Pepco Exhibit 43 into the record.
Without objection, so admitted. And I have no questions. Thank you very much.
Thank you.
Your next witness?
AOBA would like to call its next witness, which is Mr. Bruce R. Oliver.
All right, if you'd swear the witness in.
I do.
Okay. Was the witness sworn?
Yes.
Okay. Please state your name and business address for the record.
My name is Bruce R. Oliver. It's B-R-U-C-E, the letter R, and then O-L-I-V-E-R.
And please state your business address for the record.
7103 Lake Tree Drive, Fairfax Station, Virginia, 22039.
On whose behalf are you appearing here today?
I'm appearing on behalf of the Apartment and Office Building Association of Metropolitan Washington.
And Mr. Oliver, do you have a document before you entitled Direct Testimony of AOBA Witness Bruce R. Oliver, Volume 1 of 2, filed on January 30th, 2026, consisting of 83 pages of testimony, 10 exhibits identified as Schedules BRO 1 through BRO 10, and 2 attachments identified as AOBA Attachments A and B respectively?
I do.
Your Honor, I ask that this direct testimony, including the 10 exhibits and attachments A and B, be marked for identification as AOBA Exhibit 14.
So marked.
Mr. Oliver, do you also have a document before you entitled Public Surrebuttal Testimony, Volume 1 of AOBA Witness Bruce R. Oliver, filed on April 16, 2026, consisting of 60 pages of testimony and 5 exhibits identified as BRO SR-1 through BRO SR-5, and 1 attachment identified as Attachment A.
Unfortunately, the copy I have doesn't have Attachment A with it.
Hold on. Your Honor, I'm handing Mr. Oliver a copy of his confidential surrebuttal and his confidential and his public surrebuttal.
Okay.
Sorry about that.
Now, Mr. Oliver, do you have a document before you entitled Sir Rebuttal Testimony, Volume 1 of 1 of AOBA witness Bruce R. Oliver, filed on April 16th, consisting of 60 pages of testimony and 5 exhibits identified as schedules BRO SR-1 through BRO SR-5 and 1 attachment identified as Attachment A, the public version?
I do.
Okay. Your Honor, I ask that the public version of Mr. Oliver's Sir Rebuttal testimony, including the 5 exhibits and Attachment A, be marked for identification as AOBA Exhibit 15.
So marked.
Exhibit 15P, and the confidential version be marked as AOBA Exhibit 15C.
So marked.
Mr. Oliver, do you also have a document before you entitled Supplemental Sir Rebuttal Testimony of AOBA witness Bruce R. Oliver, Volume 1 of 1, filed on April 21st, 2026, consisting of 5 pages of testimony, 2 exhibits identified as schedules BRO SSR-1 and BRO SSR-2, respectively?
Ms. Francis, I've been advised that the public version doesn't have to have a P in the number. Can it just have the number? Would
Oh,
that?
sure.
We'll mark it that way.
So, perfect. Okay. So I have Exhibit 15 and Exhibit 15C. Good. Okay. Okay. I'll start again, Bruce. Do you have a document before you entitled Supplemental Sir Rebuttal Testimony of AOBA witness Bruce R. Oliver, Volume 1 of 1, filed on April 21st, 2026, consisting of 5 pages of testimony and 2 exhibits identified as scheduled BRO SSR-1 and BRO SSR-2, respectively?
I have the testimony. Unfortunately, I don't have the exhibits attached.
I will give you the exhibits.
Oh, well.
Do you want me to hand it to her?
Yeah, give it to me. Okay. Thank you. Thank you. Your Honor, I ask that the supplemental Sir Rebuttal testimony of Bruce R. Oliver be marked for identification as AOBA Exhibit 16. Mr. Oliver, was this testimony, including direct Sir Rebuttal and supplemental Sir Rebuttal testimonies, prepared by you or under your direct supervision?
Yes, it was.
Do you have any changes, corrections, or updates to your testimonies?
None that I'm aware of.
With these, is all of this testimony, your direct, your Sir Rebuttal, and your supplemental Sir Rebuttal, true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I ask that AOBA's exhibits 14, 15, and 15C and 16 be admitted into evidence.
Without objection, so admitted.
The witness is available for cross-examination.
Company.
Thank you very much, Your Honor. Good afternoon, Mr. Oliver.
Good afternoon.
Always a pleasure to see you. Could you please turn to page 14 of your Sir Rebuttal testimony, sir? And I'm looking at the discussion beginning at line 1. Let me know when you're there.
Supplier consolidated billing costs.
That's
Correct.
where, that's the winner.
Okay.
That was page 14, line 1.
Yeah.
Want me to give you a second? Or?
No, I'm fine.
I have it.
Okay. Oh, I'm asking Ms. Francis. So here you discuss, as you indicated, your opposition to the company's rate-making adjustment regarding its costs for implementing supplier consolidated billing. Is that correct?
That's correct.
And specifically on page 15 of your Sir Rebuttal, you state at line 2 that before authorizing recovery of Pepco's claimed SCB costs, the Commission needs to carefully examine the magnitude of each utility's SCB cost claims and the prudence of the dollar amounts.
Oh, I'm not with you. I'm not seeing where you're reading from.
This language begins on page 15 of your Sir Rebuttal, beginning at line 2. Do I have that wrong?
Oh, however, before?
Yes.
Okay.
Yes. Here, I'll start over. So, okay, before authorizing recovery of Pepco's claimed SCB costs, and then you continue on to say, the Commission needs to carefully examine the magnitude of each utility's SCB cost claims and the prudence of the dollar amounts incurred for which cost recovery is sought. Is that correct, sir? Did I read that correctly?
That's what I said.
Okay. Now, you would agree with me, Mr. Oliver, that this proceeding provides the Commission and the interveners with an opportunity to review the company's SCB costs. Isn't that correct?
I don't think the company has presented any detail regarding those costs.
Well, has AOBA and all the other veners had an opportunity to conduct discovery of the company's SCB costs?
I didn't think that was our burden.
So is your answer no?
We had opportunities to provide to engage in discovery, and we've done a lot of discovery in this case, but that was an issue I think the company didn't make their case on, and I didn't feel that we needed to drag it out of them.
So, okay, so is it that you don't know that you conducted any discovery of the SCB costs in this
That's not
proceeding,
what I
sir?
said.
Okay, then what did you say?
I said we conducted discovery on a lot of issues.
Mhm.
I didn't feel we needed to do discovery on that issue beyond what we did. And I did a lot of investigation of that issue, including going back through many of the prior proceedings in which those issues were addressed.
Well, let's see if we can get at it this way. You don't allege anywhere in your testimony that any part of the company's SCB costs are imprudent. Is that correct?
I don't know, and I don't think the commission knows. I do know that there were substantial costs incurred, and there were concerns raised during the proceedings about whether the costs were reasonable and prudent to be passing on to ratepayers.
So, Mr. Oliver, is it your testimony that you thought our costs were imprudent, but you didn't include those specific concerns in your testimony?
That's not what I stated.
Okay, well then we're having a little bit of trouble here.
Yes, we are.
What exactly did you say, sir?
I said that I hadn't reached any conclusion because you hadn't provided the information necessary to support the prudence of the costs and the reasonableness of them, and that this was a matter that had been addressed by the commission in the SBC proceeding, and there was, at least at that point, no determination made on whether the costs were prudent or not.
So let's see if we can get at it this way. Did you have an opportunity to conduct discovery of the company's SCB costs?
Asked and answered.
I don't believe he has, Your Honor.
I think he did answer that sustained.
Okay. Let's look at, let's turn back to page 14 of your SIR rebuttal, and I'm looking at the discussion beginning at line 7.
Page 14, okay? At line 7, okay?
Here you note that company witness Lemming's description of how the company's proposal is consistent with order number 90696 in case number 9461. Is that correct?
I didn't say it was consistent with. I say he relies on language from that order.
Okay. But you're not disputing the fact that the company's position is consistent with that order. Is that correct?
I think what I am saying in that passage in the following paragraph is that the order was made and issued before there was a substantial change in the whole supplier consolidated billing cost matter, and the commission's intent in that order is something that, for all practicality, can't be implemented now.
So, okay.
The commission made it very clear that their intent was to collect costs from suppliers while there was an allowance that maybe, we would start off collecting some from ratepayers, there was a very clear intent from the commission to collect this from suppliers. At this point in time, there doesn't appear to be any way to collect those costs from suppliers.
And we'll get to that, Mr. Oliver, don't worry. But is there any portion of your testimony in which you allege that the way that the company is proposing to recover SCB costs is inconsistent with the Commission's order?
I have previously tried to indicate that there have been a substantial change in circumstance, and I believe that the order on which Mr. Lemming was relying doesn't reflect that change in circumstance.
So I take that your answer is no.
I gave my answer. Thank you.
So is it correct that your position is that the Commission should reconsider the time period over which the utility cost recovery of SCB costs is permitted as stated on page 15, lines 6 through 7 of your rebuttal testimony?
Well, I think my recommendation is twofold. One, that we need some verification that the costs were reasonable and prudent, and two, then once we know the magnitude of the reasonable and prudent costs, the Commission may wish to reconsider the period over which those costs are recovered.
Like I said, Mr.
Because these costs, as I tried to indicate in my testimony, are not used and useful. They're not providing any benefit to ratepayers. And the notion that they need to be recovered quickly needs to be balanced with the fact that ratepayers aren't getting anything out of this.
Mr. Oliver, are you wearing a red tie today?
Objection on relevance.
If he can answer the question.
It's not relevant to his position.
Sustained.
Trying to make this easy, Your Honor. Mr. Oliver, on lines 19 through 20 on page 15, you state that it is the Commission's role to balance the timing of cost recovery with ratepayer impacts. Did I read that correctly?
I think that is regularly one of the considerations that the Commission carries and one of the factors that the Commission must weigh, yes.
Okay. Are you saying that the Commission did not do that in order number 90696?
I think the Commission was trying to do that, but did not anticipate the change in circumstances that occurred.
Okay. Has AOBA or any other party submitted any kind of a petition or request to the Commission asking them to revisit Order 90696?
Objection. Relevance.
Your Honor, he's saying that that order is no longer valid because circumstances are changed. I believe that is directly relevant.
Overruled.
Not that I'm aware of.
Okay. And to your knowledge, has this Commission issued any kind of order or instituted any kind of proceeding to revisit its conclusion in Order number 90696?
There have been at least 2 or 3 subsequent orders, and I think the last order of the Commission that I'm aware of, the Commission was still looking to see if there would be some kind of response from suppliers. I think until the Commission makes a determination on that, the next steps would be premature.
But as you sit here today, sir, are you aware of any Commission order changing the cost allocation that they adopted in 90696?
When you say the cost allocations that they adopted, can you show me a portion of that order? Because I recall the Commission's order as being very clear that they wanted recovery from suppliers for a large portion of these costs. And that's not implementable. And therefore, to say that that order still stands is something I have to think twice about.
Here it is.
Could I have a copy of what you gave Mr. Oliver?
Sure. Mr. Oliver, I've handed you a copy of order number 90696. You can take your time and review that, and then you can answer my question, please. And I'm happy to repeat my question if you need me to.
Gotta love the website.
Can you point me to the paragraphs that you're relying on to say what the commission decided?
Well, Mr. Oliver, that's my question to you. You seem to be familiar with this order. And my question is, are you aware of any order from the commission that says they're going to change their cost recovery determinations that they make in that order?
Well, what are the cost recovery determinations that you're pointing to?
All of them, sir.
And you can't cite me to a page? Or
I'm sorry, I thought you were
paragraph?
familiar with this order.
Pardon me?
I thought you were familiar with this order, Mr. Oliver.
Your Honor, the witness never said, he said he read the order. That is different from asking for a cite. Every time I asked a question, I gave a cite. If Mr. Seegers can't give a cite, we're talking about a 23-page order. So give him a cite of what specifically you're referring to, and he'll be able to answer the question.
Your Honor, this witness has submitted testimony about this order, and he's specifically saying that the findings of the commission in that order are no longer valid or are outdated. So clearly this witness is familiar with this order, and my question does not even go to what is in this order. My question is if he is aware of any subsequent order by this commission that changed this order.
Yep, you can answer, yeah.
Well, at page 54, I do see underlined that the commission finds that a $2 per bill fee is reasonable. That's not
Which page are you on?
I'm on page 22, paragraph 54.
Okay.
And I would note that on the same page, paragraph 56 says this order does not address prudency, which is an issue that is appropriately addressed in the context of the next rate case. But Pepco has provided nothing to demonstrate the prudency of the costs that it incurred. So,
Mr. Oliver, this is going to go a lot faster if we can stay on point here, okay?
I thought I was on point. Sorry.
Well, okay, then let's see if you can give me an answer to my question. As the chair indicated that this commission prefers either yes or no answers to the extent possible. So,
You asked me to interpret this piece. That was not a yes or no question.
listen to my question very carefully, Mr. Oliver. As you sit here today, are you aware of any subsequent order of this commission that changed the cost recovery determinations that were made in that order?
And I'm asking you to cite for me the cost recovery determinations that you're referring to, because just looking through this, I'm not finding clear statements except for the pieces that I've already read you. Now, maybe with more time to review it, I could find more, but I don't memorize all of these orders. And I'm sure you don't either.
So did you submit testimony about an order that you didn't understand? Is that what you're saying, Mr. Oliver?
Not what I said at all, and you're being very argumentative.
Okay, let's move on. Let's turn to page 30 of your rebuttal testimony. And I'm looking at the discussion beginning at line 1.
You said 30?
30 of the rebuttal testimony. That's correct, Your Honor.
I'm there.
Here you continue your objection to the company's accounting for contributions in aid of construction, or kayak. Is that correct?
That's correct.
And on page 31, of your rebuttal.
Excuse me, let me just rephrase that a little bit. I'm raising my concerns. I didn't say that I was objecting to it. I was raising my concerns that it's not something that can be verified independently.
Okay. On page 31 of your rebuttal, let me know when you're there, lines 11 through 15.
I'm there.
You state that the company has not provided any information regarding its accounting of kayak payments or the deduction of those receipts from capital projects. Is that correct?
That's correct.
Okay. Now, Mr. Oliver, I actually looked at your resume in attachment A of your direct testimony, and it appears that you have 2 economics degrees. Is that correct?
That's correct.
How's your grasp of accounting?
Not bad.
Okay. So, does that also mean that you're familiar with generally accepted accounting principles?
To some extent, yes.
Okay. So you've had an opportunity to conduct discovery on the company's accounting of kayak payments. Is that correct?
And yeah, well, I've done a lot and not gotten a lot of useful information.
Okay.
My whole concern is that we should be able to see the dollars recovered through CIAC assessments or billings and how that is subtracted from the costs incurred for each project. And nowhere can we find that.
Mr. Oliver.
And given that CIAC is not a precise determination, it's based on estimates. Understanding the relationship between those estimates and the costs that are incurred and what's deducted from the costs that are incurred are very important to determining the appropriateness of the dollars that the company seeks to include in rate base.
Mr. Oliver, were you either here or listening earlier in this proceeding when both Mr. Lemming and Mr. Nelson provided a live rejoinder topic on this issue?
I heard some of it. I unfortunately was interrupted in the middle of Mr. Lemming's. I don't recall Mr. Nelson's, but...
Okay, well, would you accept subject to check that both of them indicated that the company's books and records, including its accounting of kayak, are subject to an independent audit?
That has nothing to do with the issues I raised. You can account for things appropriately under an accounting procedure for audit purposes and not account for them properly for rate-making purposes.
So are you saying that the company's independent auditor, PricewaterhouseCoopers, is not doing their job?
I don't think PricewaterhouseCoopers, from what I've seen about the audits that they've provided and what they were requested to do, is asked to make rate-making determinations.
You don't think they would take that as part of their independent audit?
No.
Okay. Page 31, line 17 of your rebuttal testimony. You also
I'm sorry, what page?
Page 31, line 17. Let me know when you're there.
I'm there.
You also contend that kayak payments are a source of funding for Pepco, and that the company's lead lag studies the company uses to compute its cash working capital addresses the receipt of kayak payments and the effect that those payments have on the need for cash working capital. Is that correct?
I'm saying that the company's cash working capital calculations do not consider the receipt of kayak.
Mm-hmm.
And kayak is very clearly a source of funds, as I think we demonstrated through cross-examination in this proceeding. Just for 2024, the company received $19.9 million in kayak funds. Mr. Nelson's most recent rendition of his revenue requirement for the TTYCF started off with a cash working capital allowance.
Your Honor, I haven't even asked him a question.
$11.4 million.
Go ahead and ask your question.
Thank you. Mr. Oliver, when was the company's most recent cash working capital study reviewed and approved by this commission?
I can't tell you offhand.
Would you accept, subject to check, that it was case number 9702?
I know that there was a cash working capital study in that case, yes.
Okay. Now, AOBA was an intervener in that proceeding, correct? Okay.
Yes.
And you, in fact, submitted testimony on behalf of AOBA in that proceeding. Is that correct?
I did.
Okay. So you had the opportunity to conduct discovery of and review the company's lead lag study used for cash working capital purposes in that proceeding, correct?
Yes.
And did you?
It was not a major focus. We had a lot of issues in that case. It was something I did review, but I did not review it at that time in the context of CIAC considerations. The CIAC was something that came out of the company's filings in this case, and some experience that we've had with AOBA members in recent periods, and raised concerns about whether these costs were being properly recognized in the rate-making process.
So isn't it correct, Mr. Oliver, that you didn't raise the specific claim that you are now making regarding the receipt of kayak on the company's cash working capital in case 9702?
That's correct.
Okay. And in case number 9702, the commission, they accepted the company's cash working capital lead lag study, correct?
I believe they did.
Okay. Let's go to your supplemental surrebuttal.
Hold on a second. Let me just... I'm trying to remember 9702. We've done a lot of cases.
We have.
I know there were some questions about the lead lag study in 9702 because the company had built that off of an historic period that was heavily influenced by the COVID period and the
I'm sorry, the what period?
the COVID
COVID.
pandemic.
Okay.
And how that impacted.
I just misheard the
yeah,
word, that's all.
I'm sorry. And how that impacted the company's receipts of cash during that period. And I know we raised concerns about that. I do not offhand recall the commission's final determination.
But as we established before, Mr. Oliver, you didn't raise the specific concern about the lead lag study in that proceeding that you're raising here, isn't that correct?
That's correct.
Okay, thank you. Now let's turn to your supplemental surrebuttal, please. And I'm looking at the discussion at page 4, starting at line 6. Let me know when you're there.
Okay. I'm with you.
Okay. Here you state that the Commission and other parties have had no meaningful opportunity to assess the prudence and cost effectiveness of the underlying plant additions and related rate base adjustments. Thus, acceptance of Pepco's RMA2 at this time is inappropriate and unwarranted. Did I read that correctly?
That's right.
Okay. Have you had an opportunity to review the rebuttal testimony of company witness Connor Nelson?
The rebuttal testimony of Nelson that was filed in early March.
Okay, yes.
I have reviewed it.
Okay. And isn't it correct that Mr. Nelson discusses your proposal to disallow the company's proposed RMA2?
I don't recall the details of it, but I'm not surprised.
Okay.
It's there.
Well, would you accept, subject to check, that Mr. Nelson states in his rebuttal testimony that the updated RMA2 to reflect that his rebuttal testimony was updating RMA2 to reflect actual plant closings from October 2025 through January 2026? Isn't that correct?
That's what he said.
Okay. And as you indicated, Mr. Nelson's rebuttal testimony was filed on March 11th. Is that correct?
I don't think I gave you the exact date, but yeah, I'll accept that.
I actually have the exact date.
Well, I'm not arguing the date. I just didn't say it earlier.
Well, would you accept, subject to check, that it was March 11th?
I would accept that, yes.
Okay. So you've had an opportunity to review those actual plant closings and conduct discovery since March 11th, correct?
I have reviewed what the company submitted as actual plant closings. I have not had the opportunity to review what he included in his Sir rebuttal, or in what he calls Sir rebuttal testimony, to further update those numbers. And as I
Mr. Oliver, we'll get there, so
Please
don't
let
worry.
Mr. Oliver finish his answer.
Let him finish.
As I document in my Sir rebuttal, those last updates are significant.
So, let me try this again. For the actual plant closings from October 2025 through January 2026, you've had those since March 11th, correct?
Yeah, a long time for this case, yeah.
Okay, and you've had the opportunity to conduct discovery of those, correct? Since March 11th.
There's been some discovery on those.
Okay. Now, Mr. Nelson's rebuttal testimony also states that that the company was committing to file further updates to RMA2 to reflect actual February 2026 plant closings on or about March the 12th. Is that correct?
That's what he said, but there was nothing in the commission's schedule that provided for that.
Well, are you disputing that that update was in fact provided on March the 12th?
On March 12th?
March the 12th, sir.
I'm not aware of. There was an update in his March 11th testimony. I'm not aware of another update on March 12th.
Could you please show the witness what you're talking about?
Sure. I can show him the rebuttal testimony from Mr. Nelson. Rebuttal testimony. 23. Where's Nelson? Is this Nelson? 23, 20. Do you remember which one it accords as yours? Because we're doing
Could you give him a cite, please?
Certainly will. We're looking at page 23 of Mr. Nelson's Sir rebuttal. And it's for most of that page.
On March 12th and on April 26th.
Correct.
No. Well, I guess somehow I never saw the March 12th.
Okay, well, would you accept subject to check that that was in fact filed on March the 12th? And I do have the case log right here, if you'd like to take a look at it.
Where in the schedule was that provided for this proceeding?
That wasn't my question, sir. Would you accept subject to check
If
that
you
the
say
company
it
did
was,
file that?
I'll accept it subject to check.
Wait, can I just clarify? Which update? We're talking about the rebuttal testimony was filed on March 11th. Isn't that correct?
And
No.
what he's saying is there's another update on March 12th. And then, as was indicated in that testimony, he planned at that time to do another update in April.
You accepted it subject to check, Mr. Just continue with your next question.
Okay. Since you were unaware of that update, sir, I suspect I already know the answer to this question, but you at least had the opportunity to conduct discovery on that March 12th update, and did you?
If you call a discovery opportunity something where you get it on one date and you have testimony due in roughly 2 weeks, it takes at least a week to get, it takes you a day or two to comprehend what they filed, and then you have to write your questions and submit it. You're not getting responses back until probably the day before you have to file testimony. No, I don't see that as an opportunity for discovery.
Okay. Isn't it also correct that in Mr. Nelson's rebuttal testimony, he expressed the company's commitment to file a further update to RMA2 to reflect
I didn't
actual...
see the word
May I finish my
commitment.
question, sir?
I was trying to answer.
Okay, well, you might want to hear the question before you answer, please. I'll start again. Isn't it correct that in Mr. Nelson's rebuttal testimony, he expressed the company's commitment to file a further update to RMA2 to reflect actual March 2026 plant closings on or about April the 12th.
That's what he said.
Okay, and isn't it correct that the company did in fact provide those updates on April the 13th?
Oh, they didn't make their commitment, I guess.
We said on or about, sir.
Yeah, 3 days before our testimony was due.
So is that a yes,
Their
sir?
rebuttal.
You agree that that update was in fact provided when the company said it was going to?
That update was provided, and I was aware of that, yes.
Okay, and you've had an opportunity to review those actual plant closings and conduct discovery, isn't that
No.
correct?
Very
You haven't.
emphatically, no, I have not had an opportunity to do discovery on those.
Okay. Company witness Nelson describes on page 24 of his rebuttal testimony how the timeline for updating the final month of Pepco's RMA2 is consistent with timelines for similar updates in prior proceedings. For example, he cites to case number 9602, where Pepco's final month of actual safety and reliability closings for RMA2 in that proceeding was filed on May 13th, 2019, 3 days before the surrebuttal was filed. Do you recall that testimony, sir?
I don't recall the testimony, but I'll accept that he said that.
Okay. And AOBA was a party to case number 9602, isn't that correct?
Oh, yes.
And you were a witness for AOBA?
Yes.
Okay. And if you recall, was RMA2 accepted by the commission in that proceeding?
I don't recall. I'd have to look back at the order.
Okay. Well, would you accept subject check that it was?
If it was, I don't know that the circumstances were similar. Now, here we have, from the time of Mr. Nelson's rebuttal testimony in early March to early April, a significant change in costs. I don't recall any change of that significance in the updated data in any of the prior proceedings.
Isn't it correct, Mr. Oliver, that there was really no change in the number of projects in that proceeding?
I didn't say number of projects. I'm talking dollars.
So I'll take that as a no.
You were asking about something I didn't say. So.
Well, and okay. I have nothing further for this witness. Thank you, Your Honor.
Okay. People's Counsel.
Are we, no question, Your Honor.
Oh, MEA. Well, that's our.
No questions, Your Honor.
Okay. People's Counsel.
No questions.
Staff.
Staff has no questions. Thank you.
Redirect.
Yes. Just want to clarify some of your answers to make sure the record reflects what you were saying. And I'm going to first focus on the order number from case number 9461, order number 90696 that counsel for Pepco raised with you. Now, I think you noted that you had at least two concerns with the supplier.
Your Honor, I would caution counsel not to lead the witness on redirect.
Let's hear the question first.
Okay.
In your testimony regarding supplier consolidated billing costs, I think you noted in your testimony that you had at least two concerns with supplier billing costs. One was prudency. Was that one of your concerns?
Your Honor, the objection, this is leading.
Your Honor, I'm just following up on his question.
No, I'll allow it. Overruled.
One was prudency, yes.
That was one concern.
That's
and
right.
does order number 90696 address prudency in paragraph 56? Do you have a copy of the order?
Yes.
Look at paragraph 56.
Yes, as I indicated earlier, the commission said that they were not making a determination on prudency in this proceeding.
And do you believe prudency has been established in this proceeding?
I do not.
And what is your second concern regarding the recovery of supplier
Well,
consolidated
my
billing?
second concern was that the mechanism that was perceived for recovery of supplier consolidated billing costs at the time this order was issued in 2023 was designed such that ultimately there would be substantial costs recovered from suppliers. And given the change in circumstance, that's not possible, and the costs that have been incurred will never apparently be used and useful or productive for ratepayers' concerns. And how to get a balanced treatment of that, I think, is a consideration that the Commission should address for all the utilities at one time, and not just for Pepco in this instance. It's not a simple issue, but I think given the fact that they're not used in useful costs, spreading them over a longer period of time would be a reasonable alternative.
Now, counsel for Pepco in some of his questioning has alluded to the fact that there were opportunities for discovery that were provided in this case, and he cites several RMA adjustments. And as part of your answer, you suggested, yes, while there was some opportunity for discovery, but could you clarify your answer? What are you saying when you when you said you didn't have opportunity for full discovery?
Between the March 11th filing and when our testimony was due, there was hardly time to absorb all the pages of all the witnesses, identify the issues that you need to follow up on, write the discovery, and then get answers back in time that you could process them for inclusion in testimony.
And when you received an update or notice of an update on April 13th, and your testimony was due on April 16th, did you consider that those 3 days provided you the necessary time for discovery and analytics to put that into your rebuttal testimony?
No, I did not.
Your Honor, I think that's all that I have.
All right, we'll turn to the members of the commission. Commissioner Suchman,
I have no questions.
Commissioner Hoover,
So your concerns about supplier consolidated billing cost. So the company spent money to set up this system, and as you described, the plan was that as suppliers took advantage of this, they would then in turn pay for it.
Well, I think the Commission's determination was it would be sort of shared between
Right.
suppliers and customers. Yeah.
And what you talked about was events that overtook that process, specifically SB1 and the fact that suppliers have now left the Maryland market.
That's correct.
So the money that the company spent, was at the direction of the commission and following commission's orders as to how to set this system up, and it's not the company's not responsible for the fact that SB1 was enacted and suppliers left the Maryland market.
I agree that the company's not responsible for the fact, and I agree that they undertook this process and incurred costs to implement a system that the Commission asked them to implement. That doesn't relieve them of responsibility for showing that they didn't spend undue amounts of money, that what they spent was really prudently incurred. And I think the Commission's order clearly says that they expected to be addressing prudency in subsequent proceedings. And that hasn't been addressed yet.
Okay, all right, thank you.
McLean. No question, sir. Good to see you. Linton.
Thank you, Mr. Chairman. And good afternoon.
Good afternoon.
I just had one clarification question for you in your rebuttal testimony. starting at the end with your conclusion. There in lines, well, it starts at line 10, but I was reading a sentence you have here in lines 12 through 13.
I'm sorry, on what page?
It's your conclusion, so it's section 6. Hold on a second. Let me reopen the file.
Okay.
Takes a minute to scroll all the way down. Did you find it?
I'm at section 6.
Okay, good. It's only one paragraph. So
Okay.
in there, you reference, you have a sentence there that references the company's references to precedents in Maryland rate cases, and in your words, you claim that the references were inaccurate, misleading, or taken out of context. And what I wanted to understand is, were you referencing the company's references to your direct testimony or to something else in general?
Well, I think one of the examples I bring out in my testimony was a reference by a company witness to the determinations by the administrative law judge in 9602, where it was represented by the Pepco witness that this was a precedent for future proceedings, yet and I've quoted in my testimony, the language in the order, in the proposed order from the law judge, very clearly said this was not a precedent and we'd be addressing this in each subsequent case on a case-by-case basis.
Okay. All right, that's
And that's just one example. There are many others where the company cites prior proceedings, prior orders, but doesn't quite, from my perspective, characterize what was really said by the commission in those proceedings.
okay. Thank you. That was the clarification. That's what I was expecting. Thank you very much. That's all I had.
Thank you. Good afternoon. I don't have any questions, so thank you very much. And that concludes this witness. I want us to go until 6, and because I really do want to wind this all up by tomorrow, if at all possible. So let's go to MEA, and your witness. Who will be your first witness? Lombardi?
Yes, Your Honor, but before I call Ms. Lombardi to the stand, I just have one brief administrative matter,
Certainly.
and that is to hand out to the Executive Secretary and the parties the correctly marked version of MEA Exhibit 1 and MEA Exhibit 1C that was previously moved into evidence.
Okay, everybody, let's everybody else do what you're doing quietly. Please proceed.
Yes, I just want to hand out the properly marked copies to the Executive Secretary and the parties of MEA Exhibit 1 and MEA Exhibit 1C that was moved into evidence earlier this week.
Okay, please do that.
Thank you. And I'd like to now call Ms. Lombardi to the stand.
I think Ms. Lombardi's trying to get to the stand, if you could... And if you could swear her in. Oh. You only have one? Yeah. Oh. Oh, here we go. Thank you. Yep.
Have you?
And here, two more. Yes. What?
Has she been sworn in?
She's been sworn in.
Yes, thank you. Good afternoon,
Are
Ms.
they?
Lombardi. Would you please state your name and title
They
for the
are.
record?
Sure. Joyce Lombardi, Energy Policy Manager, Maryland Energy Administration.
And do you have a document in front of you that is labeled Direct Testimony of Joyce Lombardi?
I do.
And does this document consist of 10 pages and include accompanying exhibits MEA 1 through MEA 4?
It does, except I do not have MEA 1 through 4, I just realized.
Your Honor, I'd like to provide Ms. Lombardi the...
Sure.
This isn't your note, is it? Okay. That's the hope. So, what do you need? Oh, wait, don't. No,
I made one. I may have, yeah, I think that there were no exhibits. I apologize. I think it's just direct testimony of Joyce Lombardi.
I believe so.
And, Your Honor, I'd like to mark for identification the direct testimony of Ms. Lombardi as MEA Exhibit 3.
So marked.
Ms. Lombardi, was the direct testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your direct testimony?
I do not.
If I asked you the same questions as in your direct testimony under oath today, would they be the same or similar?
No. Due to the back and forth that we've gone with some of the numbers, with the fully forecast test year and the traditional test year, we would like to reserve the right to update those numbers. I believe there's an outstanding bench data request which would allow us to have more accurate numbers in this. Other than those numbers, yes, it would be the same testimony.
Could you just identify the numbers that you're planning to, you may update for me?
Absolutely.
Thank you so much.
Those numbers would be the amount of the investment AD.
You know, I'd really prefer for you to ask those questions on cross rather than, yeah. But go ahead, since you started, go ahead.
It'll be number one.
Yeah.
I'll do it that way. I'm sorry, Your Honor.
That's okay.
So, Your Honor, I would like to move MEA Exhibit 3 into the record.
Without objections, so admitted.
Thank you. Ms. Lombardi, do you have a copy of your rebuttal testimony, which consists of 6 pages?
I do.
Your Honor, I would like to mark for identification the rebuttal testimony of Ms. Lombardi as MEA Exhibit 4.
So marked.
Ms. Lombardi, was the rebuttal testimony prepared by you or under your supervision and direction?
It was.
And do you have any corrections or deletions to make to your rebuttal testimony?
I do not.
If I asked you the same questions under oath as in your rebuttal testimony today, would they be the same or similar?
No, for the reasons I stated before, there would be some, we reserve the right to make corrections based on some of the updated numbers.
Your Honor, I would like to move MEA Exhibit 4 into evidence.
Without objection, so admitted.
Thank you. Your Honor, the witness is available for cross-examination.
No questions?
Company.
Oh, I'm sorry.
No, the
I'm
company.
Sorry.
Now you get the
Sorry.
pounce on.
I'm used to going first.
Yeah, no, understood.
Good afternoon, Ms. Lombardi.
Good evening.
You're the manager of energy policy at the Maryland Energy Administration, is that correct?
Yes, one of them.
And the purpose of this testimony is to address broad energy policy issues, is that correct?
Yes.
Could you turn to page 2 of your direct testimony, which I believe has been marked as Exhibit 3, MEA Exhibit 3? And there are no page or line numbers on the testimony, so I'll do my best. There you talk on page 2 in probably like the 6th or 7th line about an executive order that was issued by Governor Moore building an affordable and reliable energy future. Is that correct?
Yes.
Could I get an exhibit marked, Your Honor? And this would be
Yes.
Pepco exhibit number 44.
No, the executive order.
What is this? What number?
Thank you.
Ms. Lombardi, I'm handing you what I asked be marked as Pepco Exhibit 44. Are you familiar with this document, ma'am?
I am.
And is this document the executive order that you have cited at page 2 of your direct testimony?
It is.
I'd like to ask you some questions about this document. And if you could turn to section 2 on page 6 of the executive order, and let me know when you're there.
I'm there.
And I'm focusing on the grid optimization and cost control rate making. Do you see that section?
I do.
And would you agree with me that that section of the executive order requires MEA to file a petition with the Maryland Public Service Commission to adopt a regulatory strategy that prioritizes and incentivizes flexible, optimized, low-cost grid solutions over expensive capital projects?
Yes, except it's optimized lower cost, but yes.
I'm sorry. Thank you. You agree with me, Ms. Lombardi, that that strategy should apply to all Maryland electric distribution companies, not just Pepco?
Yes.
And you would agree with me that MEA has not filed that petition, is that correct?
That is correct.
And I believe in your testimony you indicate that this executive order was issued on December 19th, 2025. Is that your understanding?
Yes.
Is it also correct that MEA does not know at what time it will file the required petition by this executive order?
Not at this time.
Okay. Now, I asked you a DR Pepco data request number 1-2, and the answer to that data request was MEA didn't know. When did MEA arrive at the time the petition was going to be filed?
I'm sorry, when did we arrive at the time?
Yeah.
We haven't yet arrived at that time.
Okay. So is it your testimony that MEA does not know at this time when it will file the required petition?
Yes, and the data request that you just mentioned, do you have a copy of that? I think it says the same thing I'm saying now, but I just want to check.
I don't have it with me, but
All right.
I just noted that. I can get it at a break if you'd like. But all I want to know is, right now, sitting here on the stand under oath, MEA does not have a time when it's going to file that petition. Is that correct?
That is correct.
All right. Fair enough. If you could look at, again, page 6, and I'm looking at the executive order, and I'm focusing there on 2C. Do you see that? It's labeled non-wires alternatives, NWAs?
Yes.
Okay. Now, does that suggest, or does that say that a unified framework for requiring utilities to evaluate and implement flexible non-wire alternatives in all relevant structure planning cases?
It does.
And under little 1, it says the petition shall recommend consistent benefit cost framework to prioritize lower cost grid solutions over expensive capital projects. Is that correct?
That is correct.
And you would agree with me, would you not, Ms. Lombardi, that today there is not a unified framework requiring utilities to evaluate and implement flexible non-wire alternatives in all relevant infrastructure planning cases in Maryland?
There is a COMAR regulation. There is an expectation. This executive order says a unified framework. And so to the extent that it is a unified framework that is broader than what is currently in COMAR regulation or other places, I would say no in answer to your question.
Okay, and you would agree with me that Governor Moore wouldn't issue an executive order requesting that MEA file a petition with this commission for a unified framework on this topic if one already existed. Is that correct?
Objection. This calls for speculation.
Right.
You
I'm
know,
happy to speak to that. The executive order
sustained.
Would you agree with me that the executive order that the governor issued required MEA to file a petition at the commission in part that would implement a unified framework requiring utilities to evaluate and implement flexible non-wire alternatives in all relevant infrastructure planning cases?
Yes.
And Section 2C specifically requires MEA to, quote, recommend a consistent benefit cost framework, close quote.
Yes. To prioritize lower cost grid solutions over expensive capital projects. Yes, it does say that.
And you would agree with me that currently there is not a, quote, consistent benefit dash cost framework, close quote?
I believe that was asked and answered.
He's asked the question in a different way, so I'll allow it.
That there is not a consistent benefit cost framework to prioritize lower cost grid solutions over expensive capital projects. Yes, I would agree that there is not one currently.
Could you turn to page 3, ma'am, of your direct testimony, which is Exhibit MEA 3?
Okay.
And there you say, and I'm trying to get it so we're on the same page. Well, you say in the testimony that the Commission and state utilities are diligently managing numerous overlapping dockets, rulemakings, pilots, public conferences, work groups, and legislative mandates, all of which have various goals and deadlines.
I do, and I'm sorry, I'm also looking for where that is in the direct.
Top of the page.
It's on page 3.
It's at the top at the first line.
Thank you very much.
Yeah.
I'm there. Yes.
And I read that correctly?
Yes.
And so this commission is undertaking numerous actions in all of these areas. Is that correct?
Yes.
And you can see that in your footnote 3 at the bottom of the page, this is where you point to those commission dockets, is that correct?
It is.
For example, you've got PC 44 and the electric system planning case 9665, the Drive Act, case number 9619, the energy storage docket, case number 9674, the universal benefit cost analysis docket, is that correct?
And that is correct.
And you would agree with me, would you not, Ms. Lombardi, that MEA is participating in all of those dockets?
Subject to check, I believe that we are in all of those mentioned here, yes.
Okay. Is MEA an active participant in all of those?
By what? Active in that we are, to the extent that we are in some of these, define active. Yes, we take a role.
Well, do you join the work group calls and meetings?
We do.
Do you does MEA, not you, does MEA, I'm sorry, file comments?
Yes, and so to all of the ones listed here, I believe so. But yes, we do.
Okay. I want to direct you to page 4 of your direct testimony. And there you discuss it's number 3, capacity expansion framework. Do you see that?
I do.
Okay. I need to get an exhibit marked, and I think this will be Pepco exhibit 45.
You know, you've actually got 44 that you didn't ask to have marked or anything, so shall we mark 44, the
Oh, sure. I thought I asked that it be marked, but if I didn't, I apologize. Your Honor, I would ask that Exhibit 44, the Governor's Executive Order, be marked as Exhibit 44.
So marked.
And I believe I laid the appropriate foundation pursuant to your rules, so I would ask that it be admitted, Your Honor.
Without objection, so admitted.
All right. May I approach the witness, Your Honor?
Yes.
No, it's okay. Thank you.
Would you like to mark this as 45?
Yes.
So
I'd like to mark this exhibit as Pepco Exhibit 45.
So marked.
Ms. Lombardi, I hand you what's been marked as Pepco Exhibit 45. And that's the response to DR 1-2. Is that correct?
Yes.
And that's the one we had talked about earlier.
Yes.
I'm sorry, I did retrieve it. And that hasn't changed, is that correct?
It has not changed.
And there's no sponsor listed there, but I assumed you were the sponsor, and you can vouch for that?
I am the sponsor.
All right. Your Honor, I would move the admission of Pepco Exhibit 45.
Without objection, so admitted.
I need to get another document marked, Your Honor,
Okay.
and this would be Pepco Exhibit 46.
We're a lean, mean marking machine here.
Yeah, I got it.
Just trying to say something funny. I wasn't
got exhibits,
complaining.
Your Honor. I have to make my record. That's what they pay me to do.
Yeah, quota, huh? Just like that.
Not a quota. I'm not an hourly paid attorney, so I'm hurting myself.
What is this?
Ms. Lombardi, I hand you I asked to be marked, Your Honor, as Pepco Exhibit number 46.
So marked.
And Ms. Lombardi, is that
There you go.
MEA's response to Pepco data request 12-1?
1-12, yes.
Or 1-12, I'm sorry, I'm dyslexic, so I get them mixed up sometimes. That is asking about your testimony, so I'm assuming, ma'am, that you're the sponsor?
I am.
All right. If I could move the admission of Pepco Exhibit 46, and then I want to ask you some questions.
Without
about that.
objection, so admitted.
Okay. Pepco Exhibit 46 asked you to identify commission orders that require Pepco to provide a, quote, full and transparent documentation of the company's consideration of non-wire solutions. And would you agree with me, ma'am, that there are no orders cited?
No, I did not cite any orders in this. I do agree, and then it went on to talk about some other policy
Yeah, we're going to go
considerations.
through the whole thing. DR, I guess Pepco Exhibit 46 of points to page 8 of your direct testimony. Could you turn there?
Yes.
And on page 8 of your direct testimony, you state, non-wire solutions have not been addressed in a comprehensive and streamlined manner before the commission. Is that correct?
No, what it reads is, aren't 9-wire solutions being addressed in other forums? Yes, but not in a comprehensive and streamlined manner, and then it goes on from there.
Okay, so it does say that non-wires alternatives are not being addressed in a comprehensive and streamlined manner. Is that correct?
Yes.
Now, if you could look at Exhibit 46, I asked you to identify any statutes that required Pepco to provide a full and transparent documentation of the company's consideration of non-wire solutions. Is that correct?
You did.
And you did cite a statute there, did you not? You cited PUA 7-802. Is that correct?
I did. The electric distribution system portion of that law, yes.
Okay. And would you agree with me that that statute was effective in 2022?
Agreed, and that's what it says here.
All right. I just want to hand that out. I wasn't going to mark it as an exhibit unless Your Honor wants me to mark it as an exhibit. It's the law, but I can mark it.
No.
I wanted to ask,
No.
does anybody else want to see it, or can I just give it to the witness?
Just give it to the witness.
Okay, that's fine. Ms. Moody, did you want a copy?
If you have one, I'll take
Yes, I do. Anybody else want a copy?
I'll take one.
Okay.
Thanks.
I'm not marking it as an
Yes,
exhibit.
it's not going to be an exhibit. It's a statute. You can always see to it.
And this is the statute that you cited in your response to DR 112, which is Pepco Exhibit 46. Is that correct?
It is.
I'm going to knock off after this.
Pardon?
No, it was just administrative talk here.
Oh, I'm sorry.
I'm sorry.
I don't have my, I can't see.
No, you're fine.
You're good.
Would you agree that this statute sets goals
It does set goals, and one of those is, as I quote in my testimony, demand response and other non-wire and non-capital alternatives. Yes.
And you would agree with me, Ms. Lombardi, that a goal is not a requirement. Is that correct?
To the extent that the Climate Solutions Now Act is a goal and not a requirement, this lays out state policy and state energy policy. Demand response and other non-wire and non-capital alternatives are certainly a legislatively stated policy goal of the state.
Right, a policy goal of the state. And if I handed you section 7801 of that, it would list out 4 specific, well, let me do that. May I approach the witness and see if she's familiar with this statute?
Yeah,
I'm not
go
going to
ahead.
mark it.
Yeah, go ahead.
Thanks.
Ms. Lombardi, I've handed you a copy of PUA section 7801. Do you see that?
I do.
And is that the policy section of that act that we've been talking about that sets out, it says, it is the goal of the state that the electric system support in a cost-effective manner the state policy goals with regard to greenhouse gas reduction, number 1. Number 2, renewable energy. Number 3, decreasing dependence on electricity imported from other states. And number 4, achieving energy system reliability, or system resiliency, efficiency, and reliability.
Oh, that is what it says, yes.
Okay. And you would agree with me, let me go back to PUA section 7802. It does not require Pepco to provide a, quote, full and transparent documentation of the company's consideration of non-wire alternative solutions. Is that correct?
It does not say that, but it does state the state policy goals of demand response and other non-wire and non-capital alternatives, yes.
Okay. And you would agree with me, would you not, that this commission has adopted distribution system planning rules and an electric planning process in rulemaking 89?
They did do that after a lengthy process that began in PC 44, September of 2016. They did.
And you would agree with me that those rules became effective October 23rd, 2025?
The COMA regulations and RM 89 did become effective at that time, yes.
Okay. Need to get another exhibit marked, Your Honor. That'd be Pepco Exhibit 47.
Okay.
Ms. Lombardi, I hand you what I asked be marked as Pepco Exhibit 47.
So marked.
And is that MEA's response to Pepco Data Request 1-13?
It is.
And you're the sponsor of that?
I am.
And that one asks you how you define full and transparent documentation. Is that correct?
For consideration of non-wire solutions for capacity upgrades, it does.
Okay. And then there you cite to Mr. Balakumar's testimony. Is that correct?
I do.
And it says For the reasons described in Mr. Balakumar's testimony, section 3C, the commission should not approve capacity expansion upgrades without full and transparent documentation of the company's consideration of non-wire solutions and a broad cost-benefit analysis, Is that correct?
That is read correctly, yes.
Okay. You would agree with me that the commission does not have a formal non-wire solution screening framework? Is that correct?
No, but I also said I addressed this very question on page 5 of my rebuttal testimony, where I talk about prudency review and other expectations of the commission in all cases for prudency and a full consideration of other alternatives.
Right, but the commission doesn't have a formal non-wire solution screening framework. Is that correct?
Not at this time, and those are in development under the COMAR regulations and the DSP process that I mentioned in my testimony. Yes.
Right, and the commission does not have a formal screening thresholds and criteria for non-wire solutions. Is that correct?
Not at this time.
And the commission does not have technical feasibility assessment methodologies for non-wire solutions. Is that correct?
Yes, there is no formal framework or no COMAR regulation currently in place that addresses that, yes.
And the commission does not have cost estimation procedures in place for non-wired solutions. Is that correct?
Cost estimation procedures, it does have a prudency requirement that all alternatives and costs should be presented.
But there's no formal cost estimation procedure in place for non-wire solutions approved by the commission. Is that correct?
No, not yet.
And you would agree with me that the commission does not have a formal cost-benefit comparison requirement in place yet? Is that correct?
That is correct, and addressed in my testimony and that of Mr. Balakumar, that is one of the things that's under consideration in the UBCA framework.
100%. And so if you could, I'd like you to turn to your rebuttal testimony, and that's been marked as exhibit number 4, MEA exhibit 4. Let me know when you're there.
I'm there.
And thank you for putting line numbers on this. If I could direct you to page 4 of your testimony there, ma'am.
Yep.
And I'm looking at lines 7 through 11. Do you see that?
I do.
You state there on behalf of MEA that the commission should implement the following: a formal non-wires solution screening framework. Is that correct?
Yes.
Hourly 8760 constraint analysis. Is that correct?
Yes.
A benefit cost analysis framework. Is that correct?
Yes.
And integration with the electric system planning process. Is that correct?
Yes, and I'm referring there to the MEA witness Balakumar's testimony for more information on all of those.
Sure. But none of those formal requirements are in place now, correct? And that's why you're making that recommendation.
Yes.
Okay. Now, would you agree with me, Ms. Lombardi, that those recommendations that are appearing in your rebuttal testimony there on that particular page are recommendations that MEA has made in the distribution system planning work group? Would you agree with me?
These recommendations, I don't know if we've made these exact ones. These recommendations are part specifically of our analysis and Mr. Balakumar's analysis of this case, and these recommendations were tied to Mr. Balakumar's assessment of the White Flint substation.
Okay. But we just talked in your rebuttal testimony, Exhibit 4, that MEA is requesting that the commission adopt these for all utilities. Isn't that correct?
No, in here on page 4, what we say, for the reasons described in Mr. Balakumar's rebuttal testimony, along with the analysis of the White Flint station, and also adopt the clear expectations for Pepco's next rate case, that these would be the clear expectations for the next filing and the next time that we come to a forum like this.
So these recommendations would only apply to Pepco, not the other electric distribution utilities in the state of Maryland?
No, of course not. These are the same recommendations that would be carried over, as you stated before. We are in the electric system planning process, and they would also be, and I think we answered a discovery request to that very extent that said we're asking for these in the four corners and the record developed in this case, but not to the exclusion of asking for the same thing in the appropriate forums outside of this rate case, distribution system planning, in the upcoming executive order cost control petition, because I think what we stated, we are very interested in this framework, a consistent framework, a streamlined framework across all dockets.
But you want the commission to approve this framework before MEA even files their petition for a unified framework? Is that your testimony?
This certainly can be under consideration here, because the record in this case, that we've developed point out, as Mr. Balakumar's testimony, has the deficiencies and the things that are missing in this case. And I think, as we've said repeatedly, this is not the only place that we would be considering these items for a non-wire solution framework. So it's not an or. And if the commission were to do that in conjunction with the distribution system planning, this one just happened to come first. So
I see, and I just want to make sure it's your testimony that these frameworks have not been proposed by MEA in the distribution system planning work group.
Some have. I think in the distribution system planning work group, there are a series of metrics that went around, and then some of those were actually the non-wire solution proposed metrics. And so MEA did file actually adopting and referring to this very testimony from Mr. Balakumar, so that there's cross-referencing of this framework in those. It is our full intention that all stakeholders in those dockets would be able to comment on them in that proceeding. But what we have before us is this rate case and these expectations for this company and its capacity planning investments.
I see. So in the work group, in the DSP planning work group docket, other utilities could comment on these proposals, but in the context of this docket, you want the commission to impose these on Pepco. Is that correct?
Yes, and it's certainly for them and up for discussion, and they can choose to or not. And the point that we are making very strongly is that a disallowance alone might not align these investments with the energy goals. A disallowance, along with clear expectations and recommendations, would mean by the time we get to the next rate case, then we're having investments that are aligned. All of this is happening in conjunction with the distribution system work group, but as I point out in my testimony, these are silo dockets, they're standalone. There is not a place where they're necessarily all coming together. A rate case, as I point out in my testimony, is where the rubber meets the road. That is where decisions are made, that is where spending decisions are made. And so to have this framework in this case, in different cases, we're asking the commission to put clear expectations in this case for Pepco, presumably then, as the commission could do, and I think this the commission has done before. They've laid out their expectations in one rate case for example, BGE, gas, and things like that. So it's not uncommon. Here are expectations coming in. Everyone reads it and understands it because they are regulators. It is a regulatory tool, and that is exactly what they are able to do.
I see. So you would agree with me the expectations right now are not clear. Is that correct?
I would. And when you say the expectations, define which ones you mean.
Well, let's take the hourly 8760 constraint analysis. Before I read Mr. Balakumar's testimony, and I've been active in tons of work groups here and active in every rate case for the last along 15 years here at the commission, I've never heard one party raise the issue of 8760 hourly constraint analysis. There's one example.
And repeat your question.
So it's not been clear about, for example, utility is allegedly required to use an 8760 hourly constraint analysis. Isn't that correct?
Yes, and I think there's two things at play here, right? And so one of the things at play in my testimony and in the testimony of Mr. Balakumar is that there's two things. One is a disallowance based on regular garden variety prudence, right? Prudency, alternatives, that we've covered in our case. That we've covered in my testimony, in his testimony, right? What did you know or should you know at the time? So we all know the standard of prudency. We don't have to repeat that. And that was one of the underpinnings of the White Flint disallowance. Also in this case, and in our testimony, is something else, which is actually somewhat forward-looking, which is saying going forward, we would encourage the commission to have a unified framework going forward. One doesn't obviate the other, right? So there's a prudency standard for White Flint, which Mr. Balakumar discusses at length, and then I kind of summarize. And also, commission, as a state energy office, we're also forward-looking. And I think that what we were trying to do in this testimony is saying there's a couple things. There's disallowances, there's prudency, there's these investments. Where do they fit into the framework, and how do we move forward?
So when Pepco was considering building White Flint, they should have known that in 2025, the commission for the first time, or a party for the first time, would say the company needed to do an 8760 hourly analysis. Is that correct?
The commission, what I say in my testimony is that at the time that Pepco was building White Flint, and those decision points for 2017 and 2019, they had a prudency standard, and the company knew when they came here before this commission, they were going to have to demonstrate what they knew at the time, a consideration of alternatives, right, and whatever that means. And that is what they knew, and so they took the risk coming in, right? And so what we're saying is we're trying to be very clear. And I think that Mr. Balakumar's testimony lays this out. We don't believe that prudency standard was met for the reasons that stated in Mr. Balakumar's testimony, but also going forward, we ask the commission to do two things. They can make the decision that they're making on the White Flint investment, but going forward, we have asked for, in this forum, a unified non-wire solution framework so that it's crystal clear, so that we're not guessing. Yes. Well, what does a robust consideration of any alternatives mean? And so we gave, those are the examples, and then he backed them up, and he can talk about them.
So prior to getting this unified framework, it would be guessing what was required for a prudent analysis of building a substation in Maryland for any utility, correct?
No, I don't think the commission is making a utility guess as to what considers. I mean, I think this commission has had investments before, and they said even in this case, and it's something that we talked about quite a bit in the last Pepco rate case. It said, well, we think there was insufficient consideration of the load forecasting and the non-wires alternatives, and so pause those investments. We're not going to include them at this time. And then Pepco came back with this case and filed here, and here we are today. Going forward, one thing that we'd really like to make really clear is that if you're looking at what should the consideration of alternatives be, then these are some of the things that we could see. You mentioned the hourly constraint analysis. Why? Why is that important? Because it scopes the problem. And so it helps all the parties, it helps the stakeholders, whether you're the DSP or not, whether you're an intervener, whether you're in the rate case, and you're trying to see if a new capacity upgrade, is prudent, then it helps you to know, well, how was it? I mean, what did you consider? How big was the problem, right? And how long does it last?
Okay, were you here when Mr. Allo testified?
I was.
And did he indicate under oath that an 8760 hourly framework does not help scope the problem?
He said a lot of things, and so in my notes, he said a lot of things. First, he said it can, I think, and that was on day 2 on live rejoinder. In response, he said it can because it helps size capacity. He said it's foundational to load forecasting. He also said it is something that the company can do, but chose not to do, right? And so he said about 3 things, some of those conflicting. Mr. Balakumar can say more.
And he said Pepco chose not to use an 86 or an 8760 hourly load forecast because that's not the proper engineering way to make that decision on building the White Flint substation. Isn't that correct?
He said that. He said a couple things. He said, don't have my notes, but he did say, look, even if the 1.3 megawatt overload had only lasted 1 hour out of 8,760, the solution still would have been to build a brand new substation, which we believe is $254 million of ratepayer money. So that's something that he said, and that is something, and Mr. Balakumar can say more, that we disagree with, right?
Let me ask you this, and I read your direct testimony. Do you have an undergraduate degree in engineering?
I do not.
So you're not an engineer?
I am not.
So you're not offering the testimony you just provided as an engineering expert, is that correct?
Objection, Your Honor. She was responding to the question posed before her. So this question is argumentative.
Overruled. It's perfectly legitimate for him to ask that as a question.
No, I'm answering this question as a policy person in the state of Maryland. And if for a Pepco engineer to come in 2026 after 10 years of the PC 44 grid modernization process, after the energy storage work group, after all of the work that the stakeholders have done in this state to get innovation, grid modernization, optimization, flexibility, non-wire solutions, after all of the work that we have been doing, no, there's not a COMAR regulation, but there's a clear expectation that this is the state energy policy. The state energy policy is exactly for storage and non-wire solution. And in 2018, BGE looked at they had some overloads on Camp Small in 2018, and they built a battery. They built a battery, and it was energized 3 months later, and they put it into rate base, and it went without any fanfare. So they were able to do it without a COMAR regulation. And so, no, I'm not answering as an engineer. I'm answering as somebody who's talking about state energy policy. You've been in hearings. You've heard ratepayers talk over and over and over and over about costs. We firmly believe DER integration. The goals of PC 44 in 2016 are alive and well in Maryland. We think the commission has spoken. And we think that building a $254 substation, if you haven't scoped the problem, even for a 1 hour overload, is is not state policy. It's not prudent and it's expensive.
Let me ask you this. Did Mr. Allo testify that it was a 1-hour overload, Ms. Lombardi?
He said, I believe he said it was a 1.3 megawatt overload, and then I think on questions he said even if it was only a 1-hour overload, his answer would have been the same. We can check the transcript, but that's what I saw in my notes.
And you would agree that Pepco considered building a battery, is that correct?
I agree that Pepco said that they did, and Mr. Balakumar can say more about this in his testimony. We believe that they said that they did. They also said in discovery, it's attached to Mr. Balakumar's testimony, I think they said they didn't have to because there was COMAR regulation, so it was a little inconsistent. They did consider it, and then I think Mr. Allo, when he was sitting up here and also in his testimony, referred us to a 2019 PowerPoint that was internal. It's confidential, so I won't say what it said. That was internal and said, hey, without saying what it said, but where it talked about cost and where it talked about, the PowerPoint presentation talked about alternatives, but it was pretty slim on what they said.
I'm going to leave this topic and we'll let the record reflect what it reflected of Mr. Allo's testimony. At page 7 of your testimony, your direct testimony, you note that non-wire solutions may be able to address temporary peak loads without requiring additional expensive infrastructure investments to serve a few high-demand hours. Is that correct?
Oh, let me get there. You said page 7 of my direct.
Yes, page 7 of your direct testimony.
No line numbers. I'm with you on that. Go ahead.
And you said non-wire solutions may be able to address temporary peak loads without requiring additional expensive infrastructure investments to serve a few high-demand hours. Do you see that?
I don't, but I'm going to trust that I said
Well, look
that.
under the question, why is MEA emphasizing non-wire solutions?
Yes.
Like the middle of that paragraph.
Thank you. I'm so sorry.
And it says,
It's not
non-wire
line numbers.
solutions may be able to address temporary peak loads without requiring additional expensive infrastructure. Do you see that?
I do.
So there you're suggesting that non-wire alternatives may be able to address temporary peak loads. Is that correct?
Absolutely.
And non-wire alternatives may not be able to address temporary peak loads. Is that correct?
Absolutely. And I say that in my testimony. And I want to make very clear something. What we are saying, what Mr. Balakumar was saying, was that it's not, the problem is that there's not a battery. The problem is that in the analysis to scope the problem, to even understand the problem that we are solving, the record that was developed upon discovery here was insufficient and imprudent. So I don't know that a battery would have worked at White Flint. And as a matter of fact, some of the best information that we got on some costs and analysis were in a back and forth that Mr. Allo had on a question from Commissioner McLean. And there was new information on battery sizing and alternatives and things that were not in the record that we had seen. So the question is not, did you have to have one? What is the analysis? What is the scope of the alternatives in the analysis, and does that meet a prudency standard in effect at the time when the decisions were made? Mr. Balakumar's analysis said no.
And you would agree that Mr. Allo testified, based on evidence in the record, specific load forecasts, that Pepco's load forecast had demonstrated that the overloads at the Park Lawn substation were persistent overloads in multiple years, in multiple consequential yearly load forecasts, demonstrating that they were not temporary and hence addressable through a storage solution. Isn't that correct?
I'll object only to the extent that if that's Mr. Allo's testimony and she recalls it, doesn't mean she agrees with it,
I didn't ask her to agree.
or that she can verify the truth of the statements therein.
Had you completed your question?
Yes.
Hold on, what? Repeat the question.
I said, Pepco's forecasts demonstrate that overloads at Park Lawn Substation were persistent over multiple years in multiple consequential yearly load forecasts, demonstrating that they were not temporary and hence addressable through battery storage solutions.
And what was the question?
That was the testimony of Mr. Allo.
Okay, I mean, I don't think it's for her to verify another person's sustained.
All right. Reference page 5, lines 29 through 30 of your sir rebuttal testimony.
What? Oh. What? Cocaine.
I'm looking at page 5, lines 29 through 30.
Yes, I'm there.
Now, would you agree that Pepco's has provided both pre-filed written testimony of Mr. Allo, live rejoinder testimony of Mr. Allo that demonstrates Pepco had a full understanding of the project, persistent overloads at the Park Lawn substation over multiple consequent yearly load forecasts?
As the testimony of Mr. Balakumar makes clear, Mr. Allo provided some forecasts. In MEA, they were introduced here in MEA 1, MEA 1C, and MEA 2. That is your data, that is historical data. And though Mr. Allo characterized that as consistent and persistently increasing load forecasts, our witness, who's coming up after me, disagrees. He thinks that the data in those were not consistent and persistent, that the load forecasts were actually were fluctuating, were decreasing in some cases, and showing that the projected overload was actually moving out year by year. Under those conditions, that's when the decision to build the White Flint substation was made, and at no point, and he can speak to this better, at no point did we know how often those overloads were going to last. Therefore, it's not possible, or less possible, to scope the size of the battery to see if a phased approach would have worked, which is what they did in BG&E Cold Spring. They're like, we have overloads, we'll build a small battery, then we'll phase it out, we'll build new batteries for the next in 3 subsequent stages. If the load forecast and the load does not materialize, we will not have built a new substation for nothing. We will have built a battery. And so that is what Mr. Balakumar's testimony will say.
All right. And I'll see that that discussion of the Cold Spring battery at BG&E in Mr. Balakumar's direct or sir rebuttal testimony. Is that your testimony, ma'am?
No, it's case number 9610.
All right. On page 8 of your direct testimony, you note that Comar 2050-1503H requires electric companies shall identify non-wire solutions considered to address system constraints. Is that correct?
Not being difficult, but I'm not. Did you say page 6 of my sir rebuttal?
Page 8 of your direct
I'm
testimony
sorry.
exhibit, I think it's 3.
That's right.
Again, I'd give you the page numbers, but
No, line number.
Asked and answered.
Yeah.
Line number.
the line number, I'm sorry.
I knew what you meant.
Thanks. Look at footnote 10.
You got it.
That helps me. That's a signpost.
Yes, I'm there.
All right. That says electric company, and it's a quote, shall identify non-wire solutions considered to address system constraints. Is that correct?
It does.
And it cites the Comar 2050-1503H. Is that correct?
Yes, it does.
And you would agree with me that that Comar section became effective November 24th, 2025. Is that correct?
That is true.
On page 9 or let me mark another exhibit, Your Honor. And I believe this is Pepco Exhibit 48.
No, 47.
No, the last one was 47. It's 48.
That's correct.
Oh, you're right.
He's the keeper of the markings.
Sorry to step on your toes, Commissioner.
Thank you.
I hand you what I asked to be marked as Pepco Exhibit 48.
So marked.
And is that exhibit the comments of the Maryland Energy Administration to RM 89 draft rule comments distribution system planning?
Yes, they are, and they're dated June 4th, 2025, and that was before we had engaged outside, Mr. Balukumar, our outside counsel, to help inform our opinions in this process.
Okay, super.
So yes.
And if I turn to the last page, page 8, it says signature Joyce Lombardi, Energy Policy Manager. That's you?
That is absolutely me.
Excellent. On page 5 of those comments, you indicate that forecasting is an inexact process. Is that correct?
I do.
And you note that MEA believes that forecast accuracy is ripe for a performance incentive. Is that correct?
I do.
And in the MEA petition that you're going to file, is there going to be a request that the commission implement a forecast incentive mechanism?
No, I think what we'll, and if I may, since you asked, what we had in my original testimony and that of Mr. Balakumar was some tracking metrics that would actually lead to possibly, should the commission and stakeholders want performance and incentive mechanisms. And I think MEA has gone on the record saying we're very interested in working with the utilities and incentivizing the utilities to be making the right kinds of investments. And I just want to back up for 1 second. I'll get there, but just come there. You're going to like what I'm saying next, because what we said in this case was Pepco, my SIR rebuttal, from my direct to my SIR rebuttal, we changed positions, and we changed positions because of some of the things that Pepco had filed. And so our case is not just about White Flint, right? It's about the ADMS, it's about some other things, and Pepco's filings, in this case, referencing others, made great strides. We acknowledge that. Mr. Balakumar also acknowledged that in his testimony. We changed our testimony and our recommendations in light of those changes. So, are we going to, performance mechanisms was one of the ones, tracking metrics for possible performance incentive mechanisms aligned with state policy was one of the things we were going to recommend in this proceeding. Pepco pointed out, probably not the place for it, and so we withdrew them. I withdrew them from here, and we'll put them into a cost control petition coming close to you. Your question was, will it be forecast? Will forecasting be one of the tracking metrics in that cost control petition? I don't believe so. But we do. I'll let you ask your next question, but I can go on.
So you believed on June 4th of 2025, quote, MEA believes forecast accuracy is ripe for a performance incentive mechanism to further this essential element, and that's forecasting, of electric system planning. Is that correct?
Yeah, because it's, load forecasts, I think you heard it here, they vary. How much do they vary? Are they iterative? And one of our comments in the distribution system planning was, can it be the word iterative, sorry, it's jargon, but can we keep testing them to see that they're right? And I think as you see in this case, MEA Exhibit 1 and 2, the load forecasts change as they do. And I think that's exactly why in Mr. Balu Kumar's testimony, and I think what a phased approach might be very cautious to do non-wire solutions if it pencils. If it pencils. Show us that it pencils. So a phased approach, battery, we might have to change, we might need another battery, or if the load does materialize, then we need a substation. But what we're interested in is getting it right, going cautiously, and not overspending, right, while we're trying to implement this grid of the future that's been promised for at least 10 years.
And are you responsible for drafting these comments, ma'am?
Those you're holding, I was.
Okay, and you say here, a utility's infrastructure spending is only reviewed for prudency in a rate case after, and you italicize that, the investment has already been made with a standard that allows for the best decisions made at the time. Is that correct?
Yeah, I'll review it, but that doesn't sound inconsistent.
Very good.
Hang on, let me go read that.
Yeah, of course. I'm not trying
All
to...
right, what page? I know, what
I'm
page?
not in that business.
Read page 5. Thank you. Yeah, I mean, unless it's an MYP, but I didn't account for that in that filing.
All right, fair enough. And you would agree with me, would you not, Ms. Lombardi, that Pepco's ADMS and GIS investments are foundational investments? Is that correct?
I said that. I did say that in, I believe I said that either in testimony or my DRs, and then we changed our position on those between direct and rebuttal.
All right. All I'm interested in is their foundational investments, and we can agree to that, correct?
We can agree to that, and then we also asked for, well, it's written in the testimony, we also asked for a backstop. But yes, yes.
Now, you would agree with me, would you not, that Pepco has a NWA evaluation documentation that was adopted in 2025, is that correct?
Was that provided in a data request to us? Is that what you mean?
It was, and it was attached to Mr. Allo's rebuttal testimony also.
Did it have a 6 in it?
Well, it had a page 6 in it.
I just want to make sure we're talking about the same thing. I asked the question
Sure.
again. I
Well,
want to make sure I'm saying.
May I approach the witness,
Yeah, go
Your
ahead.
Honor?
Certainly.
I'm not trying to be tricky.
Oh, never.
Never. I hand you what's been marked as, well, not marked. Well, let me mark it, I guess. No, it's already in the record. It's in
Yeah.
Allo's rebuttal testimony, TOA, I believe it's dash
Oh,
page. Anyway, that's a response to your data request. Is that correct?
it is.
And that's the PHI NWA solution. Is that correct?
Yes, I believe this is confidential.
It's not. We filed it public, and so.
Excuse me, counsel, do you have a copy I can have?
No, it's in Mr. Allo's rebuttal testimony. I do not. I'm sorry. I got it. No. No.
I have it, thank you.
You have it?
Okay. Yep.
All right. So you've got that, ma'am?
I do.
And does that indicate that Pepco does in fact have in place a standards that it now does with related to non-wire alternatives? Is that correct?
Not necessarily. I can't say yes or no on that one. Not trying to be difficult, but I believe in discovery when I believe what this is. I believe this was represented to us as being guidelines and not prescriptive in a discovery response. So I believe this is something that is a Pepco document, a guidance document that came out after the 2025 COMA regulations.
Okay. But nonetheless, Pepco does have a guidance document, is that correct?
Yes,
And have
you do now.
reviewed that document?
Tangentially.
What does that mean?
I mean, I have reviewed it, it means I have reviewed it to a certain extent.
All right. Can you turn to page 10 of that document? And at the bottom, page 10?
Yes.
Or, I'm sorry. Wrong page, my apologies. Could you turn to page, maybe it is page 11 of that document?
Yes.
Does that indicate that Pepco has an NWS evaluation process?
It does. My understanding, this document, unless I'm reading it wrong, only applies to substations or feeder rebuilds exceeding $500,000. I'm
Okay,
looking at
that-
page 3.
That wasn't my question. Could you turn to page 11? Does that show that there is an evaluation process that Pepco goes through?
Well, I don't know goes through, but under the four corners of the document, it says that there is one.
Okay. And if you'd look at page 12 of that document, it has a flow chart that Pepco has in use as of 2025. Is that correct?
I'll agree subject to, I'll have to take your word for it that it's in use
Well-
as of
Excuse me,
2025.
counsel, can you please redirect me to exactly where you are, which exhibit? I had thought I had the exhibit,
No,
but I didn't.
I will give it to you again. I'm not trying to. This is attached to Mr. Allo's rebuttal testimony. I asked her about whether we had an evaluation process, and it is in schedule TOAR 1, page 27 of 106, and page 28 of 106.
It's not in there. It's like,
And just so you would agree that there is a flow chart process in that document,
I would.
and you would agree that that's the process that Pepco now follows. Is that correct?
Well, I can't answer that. I can only agree to what I'm looking at in the paper. I can't speak to your internal processes.
So you can't say whether or not we follow our policies.
Objection, Your Honor.
Fair enough. Could you turn to page 5 of your sir rebuttal testimony? And I'm looking at their pages 9 through 12. And that's where you discuss Mr. Balakumar's analysis on the Orange and Rockland project. Is that correct?
Page 5, lines 9 through 12. No, I'm talking about White Flint here. On my sir rebuttal, correct? No, I don't mention Orange and Rockland here.
As MEA witness Balakumar explains in his sir rebuttal testimony, he updated his analysis in response to Pepco's arguments on rebuttal based on new information. You see that?
I do.
And that update that he did was an analysis of the Orange and Rockland West Warwick substation. Is that battery project? Is that correct?
It was far more than that. And what I mean here is Pepco's own data. So what I'm referring to is new information, Pepco's own data that he can talk to and talks about. And then he did his own non-wire solution analysis. So
And
that's what I'm
that was
referring to
based,
there.
That was
Please
based.
let her finish her response. Thank
Yes,
you.
ma'am.
Thank you.
Sorry.
Right, and the I think the Orange and Rockland project he had mentioned. Yes, I'm sorry. Ask your question.
Do you know whether or not the project that Mr. Balakumar compared to the White Flint substation was the Orange and Rockland West Warwick battery storage project?
Yes.
And are you familiar with Mr. Balakumar's testimony?
Yes,
Have you read his testimony?
I have.
And have you looked at his schedules?
I have.
Let me hand you a copy, a partial copy of the application by Orange and Rockland Company that is attached to Mr. Balakumar's sir rebuttal testimony.
Your Honor, Mr. Balakumar, I apologize. Finish your question and I'll state my position.
Sure. Mr. Balakumar attached to his sir rebuttal testimony as NBSR7 attached a copy of Orange and Rockland's application. Is that correct?
Yes.
And you indicated that you had reviewed Mr. Balakumar's testimony and his schedules. Is that correct?
Yes, I thought you said tables, but yes.
May I approach the witness?
Sure.
Sure.
Let me hand you a copy of a portion of Mr. Balakumar's sir rebuttal testimony, and that's the Orange and Rockland application that was attached to Mr. Balakumar's testimony.
It doesn't have an exhibit number. This is, you can,
That's the way it was put into Mr. Balakumar's testimony, and it is part of Schedule NB-SR-7. So that's the way it came to me.
Counselor, are you about to ask her a question about the testimony of the next witness?
I am not.
Okay.
Absolutely not. I am about to ask her some questions about this document that she's reviewed.
And I would just say that she can respond to the extent she knows, but if Mr. Balakumar is here and available for cross-examination,
Oh, I'm so looking forward to that. And not just because he has Kumar in his name.
I'm familiar with it and then I saw it, but I have not read this, no.
Okay, so you haven't read it.
I have not.
All right, fair enough. Can I retrieve that? I might need that for another witness.
Can I draw a heart on it, or?
Gee, I wonder who.
Were you in the room for Mr. Allo's testimony, correct?
I was.
And you heard him talk about Pepco Exhibit 13?
I believe so.
The non-wires alternative in New York?
I did.
Did you review this document?
I did not.
Okay. Let me ask you this. When MEA files its petition, is MEA going to ask the commission to identify a standard process for identifying NWA project opportunities and requirements that utilities attempt to develop those opportunities?
Objection, Your Honor. He's asking her to provide confidential information regarding what MEA may do in the future in a petition it will file. That's deliberative process that is entitled to confidentiality at this stage.
What say you to that?
Well, I mean, I think they've publicly been directed to file a petition. I'm not asking for any of the legal advice that she's getting or their deliberative process. I'm merely asking, is that something they're going to consider?
It's also outside the scope of her testimony, what they're going to consider in the future, or
Close one, but sustained.
All right. We talked earlier about the electric system planning for Maryland. Do you recall that question?
I do.
And that's case number 9655, right?
Yes.
And we talked about the fact that the work group was working on metrics for the electric system planning. And MEA has been at least a little bit involved in that. Is that correct?
Yes.
Okay. May I approach the witness, Your Honor?
You may.
I hand you what I asked be marked as Pepco Exhibit 49.
So marked.
And Ms. Lombardi, is this well, there are two emails here. The first one is dated February 6th, 2016. Do you see that?
2026.
Or 2026, excuse me. Do you see that?
I do.
And that email is from you,
It is.
and it's to Ms. Drury.
It is. Yep.
And the topic is the electric system planning work group meeting package. Is that correct?
It is.
And when I look at page 2, you say, Sam Reed and team, I understand the metrics recommendation process in this docket is near its end stage. Is that correct?
Yes, absolutely.
And you indicate there that MEA has hired a technical consultant. Is that correct?
Yes.
And you point to the fact that you've also filed testimony in this case. Is that correct?
They do.
And that technical consultant is Mr. Balakumar.
Yes.
And there you state MEA recommends that Pepco be required to file standardized performance tracking metrics and those items, correct?
Not Pepco. I'm sorry.
Okay.
This document doesn't mention Pepco.
Okay. Could you turn to page 3 of the first document?
Yeah.
Doesn't it say CN 28, direct testimony of witness
Oh, yes.
Balakumar? MEA recommends that Pepco be required?
Yeah, I was citing his direct testimony.
Yes. And so these are some of the same recommendations that you made in this case that you're proposing be made in that case.
No, I withdrew them from this case, and now they're only in the distribution system planning.
Okay.
Yeah.
So
And
those
that-
are the only ones, is that correct?
Those are the only tracking metrics? All, yes, these 7 tracking metrics were originally in Mr. Balakumar's direct. We withdrew them.
Okay.
And then to better align with distribution system planning, and I think even Pepco said it's a better place to go into that forum. Because they were looking at metrics, right?
And this
So-
email indicates that MEA hadn't been very active in this docket. Is that correct?
That is true. We didn't have what I thought was the technical expertise, and I think what I said there is I thanked all the participants for their thoughtful work, and I said this is a late filed document, and so give it the weight that you will. But what we're trying to do, and I think you see what we're trying to do in this docket and others, is align our positions across the cases, hire experts, and be very clear across all the dockets of what we want and be transparent, right? So we're not, like, what we're saying in this case, we're saying in all the cases so all the parties can see and assess. So that's absolutely true.
And there's another email there from you dated February 27th, 2026.
Yep.
6:25 p.m. And you're familiar with that?
Let me see.
Sure.
Oh, I'm sorry. I'm sure it's in here, but do you know? There it is. Yes.
And there you say, good evening, on page 2 of that. MEA submits the following comments on the consolidated and short list metrics.
Yes.
And so, do you know if the DER, Dispatch Technology Readiness Index, is still in this case, in Mr. Balakumar's testimony?
No, we withdrew all that.
Okay, what about the flexible interconnection process?
Same.
That's been withdrawn?
Yeah.
Okay, so I won't find anything about that in Mr. Balakumar's rebuttal testimony, is that correct?
When you say that, you mean the index, the proposed index metrics? No, but we do mention dynamic flexible interconnection. We do mention that, and he does mention that. But these metrics were withdrawn and put in the DSP, and actually what I tried to do is not overlap and then just pick out the ones that weren't in DSP so that we have a lot of metrics in that case. So there was a complete record, and that we were very clear on the subset that we were most interested in.
And you indicated that there are a lot of metrics in that case, and that's the 9656 case, correct?
Yes, they were quite, yes.
And this commission just issued an order on that on Monday, order number 92317, is that correct?
Oh, I haven't read it. This Monday while we were in this case?
Yeah, and I've had to read it.
Well.
It's part of what they pay me to do.
All right, can you tell me what it says?
So you would agree, would you not? And let me hand you the order, and we can.
Objection, Your Honor. It's beyond the scope of her testimony. She hasn't even had a chance to review it.
What are you going to ask her about?
I'm going to ask her about the NWA short metrics that she's seen that they provided comments on.
You know, I'm going to sustain this objection. I think there's probably plenty more you can ask her about.
There is. Let me ask you this: in that work group, in the short list metrics that were discussed, we won't talk about what was approved in the order. Did you file comments on those short group metrics?
I think they're the ones that you just handed me, and I think what I
didn't hand you the attachment to this because the February 27th one, because it was 11 by 18 pages. It was a big, massive spreadsheet.
Yeah.
But MEA provided comments. Is that?
I provided comments that tried to actually harmonize the metrics here in that forum. Yes. And yeah, go ahead.
And all I want to know is, would you agree with me in that short metrics group that you reviewed that there are NWA metrics?
Yes. They didn't completely dovetail with the ones that we had suggested, but there were metrics in that. Yes.
And there's in those metrics there was a list for everybody's position on those, and on the NWA metrics, Pepco was a yes. I mean, you've reviewed the short metrics, right?
Yes, I looked at those.
Can I approach the witness?
Your Honor, I'm just trying to connect the dots to Ms. Lombardi's testimony. this is going beyond the scope of that, talking about,
Her testimony talks about this case and about NWA metrics and the need to have a unified metric system in place, and part of those metrics were about NWA, Your Honor.
Yeah, overruled.
Could I get this marked as Pepco Exhibit 50? I don't know where to put a sticker on this, but I'll.
50.
I'll,
So marked.
I don't know that I have enough for everybody. It wasn't. We'll see. Ms. Lombardi, I hand you what I asked be marked as Pepco Exhibit 50.
I gave one to her.
And those are the short metrics, short list metrics. Is that your understanding?
Yes.
And if you could, and this pages are not numbered, but if you look in the very first column, it says metric area. So it starts with state goals and targets, reliability, resilience, and then you get down to item number 8, and that's NWS incorporation.
Yes, I see that.
And there's metrics 8.1 through 8.6. Do you see that?
I do.
And if you will, would you agree with me that Pepco is a yes on all of those metrics?
You are, and I think, let me, it's columns, so yes, I'm just gonna
Yeah, I'm
assume that
sorry.
that's yours. Yes, and those metrics is my comments, which aren't here in this document. They didn't exactly align with and we've withdrawn the metrics from this case, but they don't exactly align with some of the recommendations. But I do agree that Pepco was a yes for these metrics.
And those are metrics that if adopted by, if the commission were to issue an order on Monday adopting those metrics, we would follow. Is that your understanding?
I would hope so.
We wouldn't be able to issue that order Monday if we were still here for this case.
Which we might be.
Well, you did it this Monday, so you guys are wizards because
I think we
was
worked on it
sitting here when
beforehand.
came in, and the date is
Like what
April
it says.
27th. Thank you so much for your time, Ms. Lombardi. I'd move the admission of Pepco Exhibits 50.
Without well, I can't remember. Did you move all the other exhibits?
I believe I did.
Okay.
Not
Not
49.
Not
I don't
49?
I don't have 47, 48, 49, or 50.
All right, with that, Your Honor, I would move the admission of any of the exhibits that I have not moved.
Without objection, so accepted.
So they're getting it out now.
Yeah, ours.
That's going to go out to.
Does anybody? Are you finished?
I am. With this witness, I'm finished.
Okay. People's Counsel,
Ours, sir. No, sorry, no questions.
Do you have any of my emails?
staff,
Staff has no questions. Thank you very much.
redirect.
yes, brief redirect. Thank you, Your Honor. Ms. Lombardi, Pepco Counsel asked you questions about a unified benefit cost framework. Are you aware, based on your experience, if the Commission has required considerations of costs and benefits and consideration of alternatives prior to 2025?
Yes, I mean it's a prudency standard, right? So there's a couple things at play, which I said earlier. There's they have, and as I think in case 9702, there was an inadequate consideration of benefit costs, and I think some investments of Pepco's were disallowed on that basis. So yes, I mean, there's alternatives and cost benefit is something that's been in all the cases. That's not necessarily new. I'm sorry, I'm looking tired.
Really? I wonder why.
And Pepco Council also asked you if the Commission has a formal non-wire solution screening framework, and if MEA is seeking to apply such a framework to Pepco before other utilities. Do you recall that?
I do.
Based on your experience, can you say if the Commission in prior orders has been supportive of consideration of lower cost alternatives, including use of lower cost technologies?
Strongly.
Pepco also asked you if, Pepco Council asked you if the expectations are unclear about utilities using an 8,670-hour analysis. Can you please clarify your understanding of the question and your answer to that question?
Sure. I believe I was asked if there's a formal requirement someplace in Comar sitting here today for an 8760 analysis, and there's not. But as I testified, if we don't know what the problem is that we're solving, how do we know what the solution might be?
And then Pepco Council asked you to explain what you meant by saying ADMS and GIS are foundational, and he said he agrees. Can you explain what your position is and what you consider foundational about ADMS and GIS in the context of your testimony in this case?
Yes, and that's addressed in both rebuttal and, I'm sorry, not rebuttal, in direct and rebuttal. And those referred to the testimony of Mr. Balu Kumar, where he talks about ADMS and GIS as being important investments, which is why on rebuttal. And more than that, in our original position in direct, we said, sure, they're important, but to actually derive the value for customers of these investments, we suggested that the Commission kind of have a backstop. So approve them, get full cost recovery, but then to the extent that they're not linked to, in this case, a dynamic flexible interconnection program, as stated in the testimony of Mr. Balu Kumar, we would ask that amortization be paused until the next rate case. Why? Because, yeah, they're used, but if you're not, really deriving all of the value of the asset, then it's something that we kind of wanted the Commission to really have expectations for how, what is the promise of these investments, something like AMI meters, right? I mean, so that was true of the ADMS. That was also true of the data sharing that we didn't talk about, but that's in the testimony. But it's similar to that, foundational, that they're important. We're not asking for a disallowance. We're not asking for a deferral. We're saying those are important. Get cost recovery, but then we ask the Commission to exercise some gatekeeping functions and to set expectations for the use of those investments for the things that we lay out in the testimony of Mr. Balakumar.
Thank you. I have nothing further.
Okay, questions from the bench, starting with Commissioner Hoover. Just to remind my colleagues that we're going to end after this witness, so questions stand between us and dinner.
Okay. Fair enough.
No pressure.
So, the company's representative asked you a number of questions about the executive order.
Yes.
And in particular about one of the petitions that you're required to file with us, the one on grid modernization.
Yes.
Or grid optimization.
Yeah.
But you're also required under this executive order to file, I think, 2 or 3 petitions
Yes.
with us? So, and without asking you to divulge any confidential information, you're obviously considering all of the requirements that are within this executive order, not only the petitions you got to file with us, but other activities that you're required to do with this is you schedule out the course of events, correct?
Yes, absolutely.
All right, that's it.
McLean.
Good afternoon, or evening, ma'am.
Hello.
Just, two quick things I want to hit. In your direct on page 6, ma'am,
What line number? Just kidding. Just kidding.
say it's about a third of the way down.
All right, sorry. Got it.
All right,
I mean,
it
I don't,
states,
but I will.
in support of the substantive recommendations. Do you see that, ma'am? Starting in about a third of the way down.
Yes.
Okay. Substantive recommendations of witnesses Balakumar and Kim, MEA recommends that the commission undertake a more comprehensive and strategic review of Pepco's investment strategy. And by that, I take it you want something more than what's going on in the distribution system planning process?
Not necessarily more, but more targeted and in conjunction with that. That's in direct testimony. By the time we get to the surrebuttal, we've really honed those in, and so we're very specific. And but I can tell you really quickly, but yes.
No, go ahead.
So it's really quickly.
That's fine.
Really quickly. With the ADMS GIS investment, we asked that it be tied within 1 year to a dynamic, flexible interconnection program. And I think Mr. Lemming, when he stood up, the first thing he said is, I think we're going to hit a lot of these commitments. We'll probably do them within a year. So I think that there's some symbiosis there and some synergy with the data sharing. Investments mentioned by Mr. Balakumar and also in my testimony, the company already said, listen, they filed in the Drive Act. We'd like to stand up a green button connect process. I'm trying to talk fast because I know it's dinner.
No, you're fine.
And so they did. They committed to doing that. And then there's 2 other investments with the data sharing that we kind of wanted. And so we asked that those could be part of them as well. I think I heard Mr. Lemming say that those probably would be forthcoming within the year that we had asked for, and so that's what this means. So it's asking for that backstop. Yes, please approve them, but also please give us a backstop to make sure that we're really getting the full benefit.
Right, you're just not looking for a Pepco specific case or, okay, all right, that's good. I just wanted to make sure.
Sorry.
No,
Sorry.
you're good, you're good. One other thing in your surrebuttal, in page 3,
yes.
In relation to your second recommendation.
Yes.
Let's see, line 6, you state MEA is requesting that the commission approve recovery of these investments, and you're referring to community solar automation, the customer flight path, and the expanded green power connection. And you're saying you'd like the cost recovery to be through an amortization schedule aligned with the asset's depreciation life. Do you have any idea about how long those lives are?
I thought you were going to ask me that. I don't,
Okay.
and I don't. But to my understanding, they're software, so relatively short. I'm sorry, I do not know.
No, I mean, if it's a short time frame,
yeah.
I mean, if it's a long regulatory asset, my concern would be the cost.
I do
overall
not
cost.
believe it is. And the only other thing in response to the question that you asked me earlier, the ADMS recommendations, the GIS, these appear in the Drive Act and in the FERC 222. All of these recommendations are in those proceedings already. We also put them here. Just
Okay.
in answer to your questions, absolutely not for Pepco alone. It's just here's the rate case.
Understood. Thank you, ma'am.
Thank you.
Appreciate it.
Commissioner Linton.
Thank you, Mr. Chairman. Good evening.
Good evening.
Marty. I just had one question for you, just a clarification question. As you know, this case is proceeding under historic test year model because the company converted it back in April 8th. But MEA filed a surrebuttal on April 16th, which is a little more than a week later. And you made several changes to it. So I just wanted to know if the changes that you proposed from your direct to your surrebuttal were due in any part to the company's election to move forward with a historic test year as opposed to fully forecasted.
Not at all. It was all related to commitments they had made to work on some of these state energy goals.
Okay. Thank you. That's all I had. Thank you, Mr. Chairman.
Commissioner Suchman.
I have no questions.
Nor do I. See you tomorrow morning at 10.